Good morning. Good morning. We are going to call the public hearing. We're going to call the public hearing to order. We're going to begin the public hearing now. Thank you. We're going to begin and go right through our list. And as you may already know, if you've seen the schedule, we'll follow this with the committee meeting. So we're going to start with Norman Gaines. Norman Gaines. All right. No. All right, so we're gonna go to Bobby Shea of West Hartford. Robert Shea. Sorry. I mean, I've never called you Robert before, ever. Okay, so we are going to swear you in. So if you raise your right hand, do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do swear.
You may offer us your opening statement, and then I'm sure there are a couple of questions or comments.
Thank you very much, Senator. And good morning, everyone. My name is Robert F. Shea, Jr. I am respectfully requesting the members of this Judiciary Committee to vote yes on my nomination to serve as Claims Commissioner for the great state of Connecticut. I am seeking this position because I want the citizens of Connecticut who may have a claim against the state to have a clear, simple, fair means of seeking review and a process that is as efficient as it can be. I'd first like to start also by thanking Kirsten and her team for putting together this public hearing today. I know how hard it is to get these public hearings ready. I'd also like to thank my spouse, Roseanne, who is here with me today, a couple of rows back. For 38 years, Roseanne has been my best friend and biggest supporter. I'd like to thank my niece, Katie, and her partner, Ann, who are also here. They are graduating this spring from UConn Medical School, and they're going to become big doctors in New York City. We're very proud of them. I would like to thank Governor Lamont and his team for nominating me to serve in this very important role as Claims Commissioner. I am truly overwhelmed with gratitude and humility. I'd like to thank Attorney General William Tong for allowing me to work for 2.5 years in the AG's electronic discovery program. It's been an amazing job, which has helped me to focus on how cutting-edge legal software technologies can be leveraged in legal cases, which is a skill that I will earnestly employ at the Claims Commissioner's office. Finally, I'd like to thank my friends and colleagues inside and outside of this hearing room for encouraging me and supporting me throughout this nomination process. I am a very, very lucky person to have such wonderful friends. Excuse me for a second.
Thank you.
I have more to go, actually, if that's
Oh.
okay.
Okay.
Or is that, if that's enough, that's enough, but
It's what you do with your time.
okay. So the 3 minutes up. I've been a lawyer in Connecticut for 31 years, and I have loved every minute of it. I've attained a wide range of experience on a wide range of cases, and I have met some amazing people along the way. I started my career 30 plus years ago doing pretrial discovery and document review in multi-state asbestos litigation cases. Two of my most fun litigation memories occurred years ago. The first was when I second seated a 2-week administrative hearing before the Connecticut Department of Special Revenue involving a boxing promoter who was inappropriately banned from promoting boxing events at the casinos because he was wrongly alleged to have been a member of the mafia. I also did a 4-day bench trial in the London Superior Court involving an oral contract for boat repairs. These 2 cases were indeed great memories for me, and I believe for our clients as well. I've represented injured people in personal injury cases in our civil courts, and I also represented individual people in small businesses who were charged with legal violations by various Connecticut state agencies. I've represented state employees and lobbyists who were charged with violations of our state ethics laws. I represented committee treasurers, candidates, municipal registrars, and municipal clerks before the Elections Enforcement Commission. I'll jump to the end. I am very confident that my great legal experiences and my great life experiences will help me work very well with my colleagues, Tara and Erica, at the Claims Commissioner Office to implement processes and technologies to help us efficiently evaluate and hear cases, and then issue prompt and fair decisions. We will do our work with respect for others and with professionalism.
Thank you.
Thank you.
And I didn't mean to cut you off before. I honestly thought you had finished. Sorry.
Shouldn't have taken that water break.
Representative Fishbone.
Good morning, Mr.
Good morning.
Chairman. You know, I've only been here since 2016, and since day one, you've always been a straight shooter with me. We've always, you know, we don't always agree, but you know, when this position opened and I was informed that you were being thought of it, I couldn't think of anybody better, really. You know, I don't need to ask you to do good things because I know you will do good things. And I know you were here at the public hearing that we had on Friday listening. I saw the concern on your face with, you know, regard to the claims, the individuals that came before us. I know that you will address those things in an expedient manner. You know, I'm very happy that you're here today. I will tell you that before last year, this proceeding would not have been before us. It would have been before exec noms. But because of the problems in the Claims Commissioner's office, we changed the law to have the Claims Commissioner come before us. And I think we've given the guidelines to the office that it should be done in a manageable manner. I think if you were there a while ago, we wouldn't have had to put the statute in place that we did last year about the reporting. So I'm very much happy to be here to be part of this. And I know that you will do great things. So thank you for coming here today.
Thank you, Rep. Fishbone.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. Representative Shea, it's great to see you. I've only been a legislator since 1993, so it's been a while. But I've seen you here for decades, and especially camped out in the walkway in front of the Judiciary Committee area. And you've always been honest and forthright and diligent, but I'm going to ask you some questions. Clearly, we have a problem in Connecticut with our claim system. I don't want to throw people under the bus. I don't want to say our last claims commissioner did a bad job. That was then, this is now. But there's a mountain of backlog. There's people that are extremely frustrated. Their faith and confidence in the system in Connecticut is gone. The reputation we have for justice as a defendant in these claims as a state is terrible, and we can do so much better. There are areas in our state where we excel. This is just not one of them. So assuming that everything goes smoothly, what will be some of your first priorities to try to dig through that mountain of backlog and try to get a handle on turning the ship around?
Thank you, Senator Kissel. For a couple of weeks now, when I first heard about this opportunity, I started thinking about the processes that need to be undertaken to make quick and efficient decisions on claims. And so I've written up some processes for standard claims, for claims by inmates, and for claims based on wrongful incarceration. So I think what I need to do if I'm fortunate enough to get this job, I need to get down there, look at all the files, and try to employ these processes to each file. And it starts, for example, with was the claim timely filed? Does the claims commissioner's office have jurisdiction? How do we get the evidence that the claims commission office needs to decide whether or not a person has a viable claim against the state? Other immunities besides sovereign immunity that need to be addressed. And I will work with the team at the Claims Commission office and with the Attorney General's office and citizens of Connecticut and the plaintiff's bar to make sure that we can get the information as quickly as possible on each file to make sure that a decision is made very, very promptly. I believe very deeply in government service and public service, and that the government agencies are here to serve the people of Connecticut. And I promise you, Senator, I'll do everything I can in my power to work hard that the office does what's fair for the citizens of Connecticut.
And for what it's worth, I really hope your relatives stay as doctors in Connecticut, but that's an aside.
But I think they'll come back. They have to do their residency.
New York, really? You guys want to go to New York? Oh, God.
They'll be back.
Stay in Connecticut.
Right.
So,
They said yes. Yeah.
all right. It's not going to bear on my vote.
Yeah.
So you have already some guidelines that you've drafted out. Representative Fishbein has just been like the champion of trying to wade through, and I see that we have Rep Blumenthal here too, and Quinn, and the Vice Chair Quinn this year. And so, if you could share that with members of the committee, and maybe they can give you some feedback. I guess what I'm saying is, I think statutorily, you have to give us a report at a year's pace. And it would be good if there was some sort of interreaction along that way. I mean, you're new, so you're going to bring new vibrancy, new energy, new ideas. It's not going to be required, but I don't think that we as the Judiciary Committee should be viewed as sort of necessarily a threat or, a watchdog hanging over the top. Use this as a resource along the way, especially when we're no longer in session, God willing, after the first week or so of June. There'll be time. I know I'm giving away the time of my colleagues, but they've been grappling with this issue, and nothing would make all of us happier than to have happy constituents that feel that things are moving down the road. And as the person you were here observing last Friday, as Representative Fishbein said, the person who zoomed in afterwards, we said, listen, if you got a 90-day continuance as the prior commissioner requested, and yet you felt like something would get resolved at the end of that 90 days, would that be acceptable to you? Now, the couple that was here in person prior to that gentleman they've been waiting for 6 years. So they said 90 days. But to Representative Fishbein's concerns, sometimes if we give them what they ask for, it's not going to ultimately result in a just resolution. So sometimes you got to wait even a little bit more to get to where you want to go. So it seems to me that, and I have no doubt that we're going to confirm you, but sort of your first tripwire is that 90 days, because you're going to have some things that are just going to, the pot's going to be bubbling in 90 days. What are you going to do with that? So what do you think about that? Do you think that you can make some headway in putting into buckets? You have like 3 buckets or 4 buckets, compartmentalizing, or, some people don't like silos, but sometimes we do that as a committee. We just had a meeting where we took our bills and said, what do we want to do at the front end? What are we going to do at the back end? What are sort of, in between that we're sort of not quite there yet. And so by breaking it down into manageable components, it allows us to not only be efficient, but to be productive, because otherwise it's just a mishmash and it's like, oh, where do you look at the mound and it's like, where do we begin? So what do you think about trying to be more interactive? Or do you want to just be left alone and you'll report back to us at the next time you have to? And what it is what it is. Because I'm just concerned that everybody says that they have the greatest aspirations at the beginning. But once you start digging in, you might find one matter that's going to gobble up 2 hours of your time before you can even figure out which end is up.
Thank you, Senator. I myself like silos as well, to put piles of files in their proper place. And you mentioned about these processes that I've started to work on for the different types of claims that would come in. And I would absolutely want input from the Judiciary Committee, members of the bar, the lawyers for the state, to make sure that the process makes sense and works for everyone. But most importantly, works for the citizens of Connecticut who pay our salaries and who are expecting good service from the Claims Commissioner office. So I suspect that I will have constant communication with the members of this committee and your attorneys, and try to make sure that the process makes sense to everyone. I mean, I will say there's something I'm thinking about, in the statute, there's different financial amounts, up to 35,000. And then there's a proposal this year, House Bill 6876, that you look at between 35,000 and 150,000. Now, I might need some advice and guidance as to how I get to that number. In other words, I'm not sure that a claimant has to specifically state the amount that they're claiming. Because we know in Superior Court, you can say, I'd like to recover $15,000 or more. So that's something I could probably going to need some advice on, as to how we quickly determine the value of the case. If a person wants to put a value on it, as opposed to requesting authorization to go to Superior Court. So I have ideas, but I definitely will need some advice and help on getting to those factual determinations very quickly.
I appreciate that answer. And I guess what I'm seeking is, and I guess since I've been here for a long time, part of this blame is on my shoulders too, because here I was on the Judiciary Committee and this thing is spun out of control. And so I think this is a that's why I told the people on Friday, it's a golden opportunity, because there's a changing of the guards. And I think what you're referring to is a really good point, on regular court action that I have filed in the past in Superior Court. What is it? The ad damnum call, the little box you check if it's like, and you check the box so that it would encompass everything above a certain dollar amount, so that when you read about it in the paper, if it happens to get some ink, then it'll just say that they're seeking over X amount of dollars, but it really doesn't narrow it down.
Right.
It's just, that was the box that somebody had to check on the form. So if we're looking for a window, an open-ended box is not going to help us, and it's not going to help you. So these are interesting things. I think the bar would be very helpful too, but we can come out of this whole process with you in the lead, really shining. And I'm not looking for the world to change overnight, nor should anybody in the public think, oh, my claim is going to magically turn into something where I'm going to see results tomorrow. But we're on the right path. And so the chair's been really indulgent. I've been sort of going on and on, but that's my nature. But I really am excited Bobby, that you're here in front of us. As Representative Fishbein said, I've had a lot of years working with you. You've been a straight shooter, not that, and again, it is not an implicit criticism of any of our past claims commissioner. But I just think it's a brand new day for the people of the state of Connecticut. And I'm really excited. And I want to commend Governor Lamont and everyone associated with the selection process, because I really think that he's making some good choices lately. Not that he hasn't in the past, but it shouldn't be all. And I'm not going to say that it all has been, but quite often a lot of these decisions are politically driven. And that doesn't mean that we're not getting excellent candidates. We do. But I'm seeing a variety of individuals. I don't know what your political affiliation is, nor do I care. But I know who you are as a human being, and you're dedicated to the community. You've struggled with different things in your personal and family life, and you've been extraordinarily successful. You've got a support group there that love you, and we have the utmost respect for you. So I'm really excited, and I wish you the best. And you certainly have the senator's support. Thank you, Chairman Winfield.
Thank you, Senator.
Thank you, Senator. We're going to go Representative O'Day, Representative Dillon, Representative Pavlik D'Amato. Representative O'Day.
Thank you, Mr. Chair. Just real quick, I know we've got a lot of business here today. I just want to say thank you for being there. Your service from the back row of this room to this row here, you've got, I believe, unanimous support throughout the building. You've worked hard for the residents of the state of Connecticut in many different ways. And you were one of the first faces that I got to know here in the building when I first got elected, 11, 12 years ago. We've got mutual friends, and it warms my heart seeing you up in that chair. And the state of Connecticut is be well served as you as claims commissioner, and very proud to see you there and happy, and well done to you and your family for the support that you've gotten. And I'm very appreciative to the governor and all that have supported your nomination. And looking forward to working with you. Thank you, Mr. Chair.
Thank you, Rep. O'Day.
Representative Dillon.
Good morning. Congratulations on your appointment. Now we're going to try to talk you out of it. No.
Too late.
You really have a great work ethic, Bobby, and I think that you can really bring a lot to this office. I think it's a great appointment. I was not involved in the reforms, but my experience with the Claims Commission years ago, when I had this notion of finding out about sexual assault in our correctional institutions, was getting a response when I asked about how many claims have been made. We don't know. Could you look it up? Our records are in pencil. You want to come help? True story. So a couple of years after that, we did some legislation, but it was primitive, below, I would think, the standards that we would like to hold ourselves to. And I think, and I'll say this in a personal way, it's sort of like going to the appellate court. You don't see people quite the same. And it's not, you know, I think you're welcome here all the time for anything you need. But it's not, I think it's an isolating place. I mean, you're not going to have people running in and out and everything. So I'm sure that you can handle that very well. But a lot of good can come out of that office. And I really think the people on this committee who engaged in reform did a great job. But there's a lot more to do. So good luck to you. Congratulations to you and your family. And we'll be there.
Thank you, Rep. Dillon.
Thank you, Representative. Representative Pavlik D'Amato, followed by Representative Porter. Representative Pavlik D'Amato.
Thank you, Mr. Chair. And I just wanted to tell Mr. Shea that another rep had messaged me and said I looked like I was going to attack you. So I had to laugh. But I have worked with Bob before, and I like Rep. Fishbein. I can't say enough about him. And straightforward, I think, is the best description that I can utilize for him. He has always been straightforward with me and honest, and he's like he just demonstrated not afraid to ask questions when questions need to be asked, and not afraid to learn something, make mistakes along the way and learn from them. So I do really appreciate that about him, and I do look forward to seeing what he can bring to the position. So thank you.
Thank you, Representative Porter.
Thank you, Mr. Chair, and good morning, Mr. Shea.
Good morning.
I have to say, when I saw your name on the list, I got excited. I will just add to the accolades that have already been shared, the sentiments. I've worked with you for several years since being in this building. You are a man of great character and integrity. It has always been a pleasure to do business with you. You've been forthright, forthcoming, honest. You have a lot of attributes that scream in this building, loud and clear, who you are and what you represent. And you've always represented the people on the strength. So it gives me great pleasure, and I will count it an honor and a privilege to cast my vote in the affirmative for you. Congratulations.
Thank you, Rep.
Thank you,
Porter.
Mr. Chair.
Thank you. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, I just want to say, well, I see Rep. Godfrey. Rep. Godfrey.
Good morning, and good morning, Bob. I've been around a long time, and so have you. And I just want to say it's been a delight over these many decades, actually, working with you. Your advocacy has always been very much appreciated. Certainly your talents for trustworthiness, for honesty, for getting information to us as we've needed it has been sterling, and I look forward to continue to working with you. And I know one of the first things we're kind of doing as we throw you in this in the middle of a legislative session. The legislature's been a little problematic in that I think we have underfunded this office, and I think we have not provided for sufficient staff to be able to deal with backlogs and to deal with the day-to-day running of the claims commissioner's office. And I think you can turn that around. You certainly know your way around the legislature, both as working for the Attorney General, working for a variety of clients that have had matters pending before this committee and before the legislature. And I just wanted to add my voice. I bow only to Pat Dillon on this committee as someone who has been in the legislature longer than I have, and she and I have had a good working relationship and a friendly one, I think, over the years. But we've included people like you who have provided us with the information we need, both at our request and certainly even in anticipating our interests and requests in getting stuff done. And I'm hoping that as you move into this new chapter in your life, that you'll continue to be supportive, continue to be compassionate, continue to be able to sort out the various and sundry claims that are brought to the state so that we can move forward. Actually administering justice when you really think about it and get down to it. So I just wanted to add my voice to those who are very happy that you have been nominated. Those of us, even those of us who also serve on the Executive Nominations Committee and confirmed claims commissioners before we made the reforms relatively recently. So congratulations and go Rams. Thank you, Bob. Thank
Go
you,
Rams.
Mr. Chairman.
That's Fordham, by the way.
Yes, that is
My
Fordham.
daughter went to Fordham.
Thank you, Representative.
And so did I. Thanks.
Comment or question from other members of the committee? Comment or question? With that, thank you for being here to be nominated. And I also want to thank you for being here Friday to listen. You know that this committee has had frustrations with the office for a number of years, and many thoughts about whether or not people could receive justice coming out of that office. To my mind, justice takes a shape, it takes a form, and what we have seen is so far from that form that the saying that justice delayed is justice denied is not appropriate here. I will say what I said in the Appropriations Committee about a week and a half ago, that sometimes justice delayed is just not justice at all. And that's what we've seen here. And so my hope is that I've had the opportunity to sit out there with you over the years and listen to you as a person who is thoughtful about what we do here. My hope is that knowing what has been going on, seeing what you saw on Friday, that you be about the business of making sure that we don't talk about that office and justice as two separate and distinct things anymore into the future. And I was going to move on, but I see that Rep. Staffstrom's here and he may want to say something, so I'll give him that opportunity.
Thank you, Senator.
Who's this guy? Oh, wait. Bobby, good to see you. Sorry to be late for this, but I'm very pleased with the governor's nomination of you. I know you will do us very proud. I know we've had multiple discussions over the last few days, weeks on this office. I think you understand the workload that is involved and the time commitment and the desire of everyone on this committee to see claims get processed as expeditiously as possible. So congratulations on your nomination.
Thank you, Representative.
Thank you, Representative. And with that, thank you for joining us this morning. Enjoy the rest of the public hearing.
Thank you very much.
Next, we will have to be a member of the Board of Pardons and Parole, Carlton Giles of Milford. When you're ready, raise your hand and we'll swear you in. Your right hand.
So much, sir.
Okay, do you swear or affirm, as the case may be, that the information you will provide this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
You may be seated and offer your testimony.
Thank you. Good morning, Chairman Winfield, Chairman Stratstrom, Vice Chairs Flexer and Quinn, ranking members, Senator Kissel and Representative Fishbein, and to all the distinguished members of the Joint Committee on Judiciary, good morning again. Thank you for inviting me here today, and my deepest gratitude to Governor Lamont for renominating me to serve as chairperson of the Board of Pardons and Paroles. I am honored to be joined today by my wife, Stephanie, parishioners from the churches that I am privileged to serve or have served as pastor, several wonderful friends, co-workers, and associates from around our great state. I am privileged to be joined by members of our management and executive team and colleagues from the Board of Pardons and Paroles with whom I am proud to team up every day. Since September 2013, I have had the opportunity to collaborate with colleagues as a member of the Board of Pardons and Paroles. Since May 2014, I have served as chairperson along with Executive Director Richard Thomas Sparaco and with many professionals at the board, some who serve as parole supervisors, parole officers, top-notch administrative and clerical staff, as well as victim advocates from the judicial branch assigned to our agency to ensure the mission of the Board of Pardons and Paroles to facilitate the successful reintegration of suitable offenders into the community. We are extremely fortunate to have as part of our team a much sought after psychologist and an attorney who serves as our legislative liaison and legal advisor. I am honored to be included in this vital and important work as part of the criminal justice system and to collaborate with professionals in the Department of Correction, Judicial, Court Support Services, Reentry Roundtable teams, this distinguished body, and so many others. As you know, I joined state service after a long career with the Norwalk Police Department, having served there in many capacities, investigating serious crimes involving our state's most vulnerable citizens, its children, victims who could not help themselves, serving as a public information officer and many other duties. In addition, I've been active in civic affairs, having served the city of Milford on its Human Services Board as a commissioner and more than a dozen years on the city's police commission, concluding my tenure there as chairman. I also point out my involvement as a leader in the church, having served 2 historic congregations over 32 years as a senior pastor, several simultaneous temporary assignments as well, and currently serving in Norwalk as an interim pastor. During my time as chairman of the Board of Pardons and Paroles, we have made many achievements. For the sake of time, I will mention just a few. I hope I don't get the bell. Members of our staff were certified by the National Institute of Corrections to become national trainers in the structured decision-making framework that is an evidence-based decision-making nomenclature for parole. Since then, they have been instrumental in other states in teaching and implementing the process. In 2015, as you are well aware, the state of Connecticut passed and made effective October 1st of that year, Public Act 1584. As a result, the Board of Pardons and Paroles identified approximately 212 offenders who are eligible for a reconsideration hearing. During my tenure as chair, our agency hosted parole officials and parole board members from around the world.
Mr. Giles.
Finally, during this season of Lent that many commemorate, we wish well Representative Comey for a fast rehabilitation and back to her work here. Thank you.
Thank you. Comment, question from members of the committee, Senator Kissel.
Thank you very much, Chairman Winfield. It's great to see you again, Chairman Giles. I have some questions. My first one is, as chair, how does your time get utilized during an average day and an average week? Because you're performing various roles, I'm assuming. How do you decide what you're going to do on any given day?
Thank you, Senator, for the question. Actually, I am a working chair, I'll say. I serve alongside my colleagues in parole hearings, pardon hearings, and other early termination hearing and other things, in addition to administering sort of the general work of the office.
And part of the dilemma of the Board of Pardons and Paroles is doing what I would call a risk assessment. I don't know if that's the term of art, but you were in your testimony indicating that you and the members of the Board of Pardons and Paroles have taken national courses or gone to national symposia on that. Can you elaborate on that a little bit?
So really, we brought those specialists to us. We've had Richard Stroker, who is a leading expert in the field, and our own executive director serves with the National Institutes of Correction, as did our former legal advisor. So we have statute, as you know, Senator, requires yearly training for the board. In fact, we've gone well beyond, and we have monthly training that talks about risk assessments using, as I said, a sort of paradigm for making decisions in parole.
And my understanding is, at least regarding your parole hearings, we as legislators and the general public become aware of when mistakes are made or an assessment does not come out the way you folks had anticipated if something bad happens. And I haven't really read of anything where something really bad has happened. We know that way back when the Cheshire triple homicide took place, and then Governor Rell froze the Board of Pardons and Paroles because of an assessment that wasn't under then Chairman Bob Farr, although he was at the helm when the murders took place. And so the initial blame sort of went in his direction. He goes, no, that decision on Hayes and Komisarjevsky took place under prior leadership. But that had a huge ripple effect. We felt that there had to be better communication from the officer pulling someone over in the beginning to the release and everything in between in the judicial system and corrections and the courts, all of it. And we came up with the Criminal Justice Information System, CJIS. I think the chairs and rankings are automatically by statute members of that board. I went to a lot of the meetings at the first 3 or 4 years. And now it's like uber technical with computer keys. So I don't go as many meetings as I should, but I want to commend you that the tools that you're using on the pardons and paroles assessments seems to be going well. So I'm sure that you're aware that recently it's come to my attention that another aspect that's not in the title is commutations. And just for the edification of folks that might be tuned in on CTN, what is a commutation and what is the role of the Board of Pardons and Paroles regarding commutations?
So a commutation, of course, can be a reduction of the sentence of an incarcerated person. And of course, our enabling statutes give us latitude there in the commutation process.
And now you are involved in the three people that are involved in commutations right now. Is that correct?
I have been, yes.
And who are the two other members that are involved in those commutations?
Panel member Michael Pohl and panel member Deborah Smith Palmieri have been involved with me primarily in that.
And for the commutations, is it just you three or are there other members rotated through?
At this moment, it's just us three. And as you will remember, Senator, I did the same thing when we rolled out in 2015, the expedited pardons. I had one particular panel that I used because it was a new program, and it's sort of round peg, round hole. So that's not into perpetuity. It's simply because it was a new rolling out, and I was trying to lean into the expertise of those two persons that shared with me on those panels.
So it's just you three, and that's been, and, okay, then let me scratch that. I'll take that back. So I have noted, and correct me if I'm wrong, that we were very parsimonious in granting commutations until about 2021. Would that be fair to say that there was only like one or two a year?
I think that's correct, yes.
And so what took place in 2021 to cause there to be a sea change regarding the granting of commutations?
Partly, Senator, this was an effort for us to review all of our policies we had done. And of course, working at the Board of Pardons and Paroles can be like changing a tire while the car is moving. And so while we were looking at all of our policies, we had to stop to work with this distinguished group on early terminations. As you know, we stopped to work with this group on the expedited pardons. We stopped to work with this group on the revocations process where now everybody's represented. So it was really a part of an overall view of all that we were doing. And that is the reason for when we looked into the policy to see what, needed to or could be done.
So just so I'm clear, in 2021, when we were, I think it's fair to say, still in the midst of our concerns with the pandemic, and this building was not open to the, wasn't utilized as it had been to the public. Even in the Senate chamber, there were restrictions and the utilization of masks. At that time, was it just your idea to revamp the commutation process, or was there any kind of information passed along from the governor's office?
I had no information passed on, Senator, from the governor's office, but you might remember that there was an article, I think, in 2021. There are other voices out there, and I think there are, advocacy groups, as you know, many of them are here when you meet people, not prisons, and others, private attorneys and so forth, who are interested in that part of the process.
So you just acted on the behest of private interest groups?
No, I think I'm sorry, Senator.
Well, you referred to a newspaper article. I don't know if that was shared. I wasn't aware of a newspaper article in 2021. So what article,
Right.
what paper was that?
Yeah. I think that Keelan Lyons did an article. Is he with the Connecticut Mirror? But I was not specifically talking about that as the impetus to what we did. As I said before, we started looking at this maybe in 2015 as an overall what we were doing. And so there was this move in criminal justice that we were a part of. Second Chance Initiative was clearly part of it. I was not meaning to suggest that the article was the impetus, Senator.
Well, as someone who's been lucky enough to be on this committee for, let's see, I missed it my first 2 years and I'm in my 31st year, so 29 years. Certainly, we've been grappling with a lot of these issues legislatively. We've had public hearings. We are aware of the public that comes and testifies, and they reach out to us throughout the years. I get all that. But typically, major changes in policy either emanate from the governor's office or through legislative initiatives. And so my first concern is that typically, if an agency just starts in a new direction or a direction with a lot more force, I would tend to hear about it sooner rather than later. But this really just sort of stumbled before me as the ranking senator on the Judiciary Committee. So that was a surprise. So what outreach, again, it was your idea. I don't think that I don't think it's fair to characterize this as part of something that started in 2015. What happened in 2021 that caused you to wake up one day and say, oh, one commutation's too little. We're gonna do dozens and dozens and dozens. What was that?
Yeah, I think I've tried to answer, Senator. It was not any one particular thing. We'd been looking at many things, and some of them I've enumerated somewhere in my opening statement. I didn't get a chance to read, but we'd been looking at several policies at our agency, and commutations happen to be one of many.
So when you say we, who's we?
Well, I have an executive team to which that I confer with. I don't just sit in my office and, make these decisions in a singular way, although it's my policy and ultimately I'm the chair. But I do confer with my legal guy. I confer with my executive director.
So your executive director, yourself, and your attorney were the ones that made this decision.
I'm saying that as the chair, I can initiate these questions, what could we do? Well, let's look at this. And then I have a team that I can confer with to do that.
Okay, well, typically human nature is if you're going to change a direction, you sort of wade into it. But this is not and again, correct me if I'm wrong, this is a sea change. This is a huge shift. It's a shift from 1 or 2 per year to what my understanding was upwards of over 70 in 2021 or 2022. So was it just your idea that hasn't been enough time taken off of inmates' prison terms? Where did this come? It doesn't seem to me something that would just fall out of the sky. So what was it that prompted your decision to do this? And again, I'm going to move on, but what was it other than just it just popped into your head in 2021 to cause this change?
So, Senator, that's a mischaracterization when you say it just popped in my head in 2021. I think I've said twice that this was really an overall view of all that we were doing from maybe 2015 when we did expedited pardons. And as you know, the commutation policy is part of sort of ensconced in the pardons policy. So when we looked at that, it gave us an opportunity to also look at this. It was not an idea that just popped into my head in 2021. It's been a long sort of view, several years of looking at the policy, what is going on in criminal justice in our state. We sent our revered former commissioner went over to Europe to look at how to do prison differently. And so all of these things are sort of percolating in criminal justice. And much of it we worked on with this committee. In fact, I've been in your conference room to deal with some of these things prior.
Okay, I don't want to mischaracterize anything, that's for certain. When you said we sent our revered former chairperson to Europe, what is that?
I didn't.
Maybe I misheard.
Remember, yes, I think so. I remember that former Commissioner Semple went over to Europe and came back with many ideas about, and we went over to Cheshire with the True Unit and many, many things. It was just part of that overall picture, and that's the context under which I was moving.
All right, so I will characterize it more of a gestation period. And let's say that these thoughts were planted in 2015 and you were thinking about them during that period of time. So what was the trigger? What was what prompted someone, I'm going to say your decision to begin to implement this policy in 2021?
Right. Many of the things that we'd already been looking at, we had completed. So the 1584 process was well underway. Early termination from parole, we worked on this committee, was well underway. Expedited pardons was well underway. The revocation process, we trained new hearing auditor, that was well underway. So this was finally something that we could get to and then implement.
Okay, well, my first disagreement with what you're stating is that we as a committee had any involvement in this change. I certainly didn't. And I can't speak for the co-chairs or other members, but that concerns me because while, second chance society is one thing, shaving off decades off of a sentence of a horrendous murder, that's a totally different thing. So when you decided to implement this new, first of all, is it fair to characterize this? I know you want to say it's an extension of other stuff. I'll agree to disagree on that because I look at it just totally differently. But so it's what month of the year in 2021 did the change take place?
So I don't recall, but I think I signed off on the policy in August actually of, I don't know, Senator, I'm sorry, I don't have that in my head.
Okay, but it was
The actual timeline, I don't know.
sure, but it was sometime in 2021.
I'll take your word for it. I mean, that's easy to track back, but I just don't have it in my head. I apologize.
Chairman, and this is important. I mean, it's not like our concerns were invisible. Okay, this policy, who wrote up the policy? Were there drafts? Were the drafts circulated? How did this new policy get formalized?
Generally in our office, when we do this, we have our legal advisor, executive director. Sometimes others are involved depending on what the subject matter is. We'll all look at this, draft it. We also confer with the Attorney General's office as well, and they will often give feedback as well. And so that's generally how that works.
So did you take this, and again, I'm going to characterize it as a new idea, but let's just say it's a revved up idea, but it's the commutation, much more robust. Did you take a proposed draft of rules and regulations that would guide this process and bounce them off or formally send them to the Attorney General's office for their review?
So I don't want to say formally. I do think that our legal department has some conversation and has some channel with the Attorney General's office. And so I'm confident that I know that occurred. When you say formal, I just didn't want to, underscore that it was some kind of, the whole thing went over at once or something, whatever you might be thinking when you say formal, but there is some channel of communication where they get to weigh in on these things.
Can we get copies of those communications between the AG's office and your office?
I will check with my legal folks to see if that's available. Yes, I mean, I don't maintain those files, but if there are such files, I suspect that you could get them. Yes, sir.
Okay. Was there any question as to whether a commutation would be appropriate for certain individuals? And for that, I mean, was there, since it was going to be now applied in a far more robust manner as opposed to years past, did the issue come up as to sentence to 30 years without possibility of release? Whomever the individual was, man, woman, doesn't even matter what the crime was. But sometimes people are sentenced to a certain fixed period of time. And sometimes in addition, it says without possibility of release, so that there's no early release. Was that issue as to whether that individual would be appropriate for a commutation, was that question asked of the Attorney General's office?
We talked about that at our office, Senator, and and as you know, the policy then does not include those folks.
And where is that written?
That's also in the policy that we excluded folks who have the sentence you just described.
Okay, so there are certain inmates that are excluded, and if you could explain to the committee what those exclusions are currently.
Some have to do with time frame. That really goes to eligibility requirement. They have to have served 10 years. This one that you're referring to, sentence without the possibility of release, is also excluded, and others. I mean, I can't recall. I mean, if you want me to refer to my notes, I can, but those two
Yes,
big ones.
please refer to your notes.
Yeah. Let's see, that's victims of commutations. There's a long list of 10 things here that deal with eligibility.
Thank you.
Serving, do you want me to recount them or you have a copy, Senator? I mean,
I do not have a copy.
yeah. So if a person serving a period of probation or except as provided in subsection C of this section of this policy, the board may not consider an application for commutation if the applicant is serving a period of probation, a period of special parole, is on parole, is serving a term of imprisonment in the community pursuant to the Commission of Corrections Authority, serving a life sentence without the possibility of release, according to 5335, as you know, and more.
Well, what's the more?
Is serving a total effective sentence where the aggregate term or terms of imprisonment is less than 10 years, has served less than 10 years of the total effective sentence for which commutation is sought, has less than 2 years to serve before beginning parole eligibility pursuant to 54-125, has had a charge or charges not only within the last 13 months, has had an application for commutation denied by the panel or revoked within the last 3 years, has unresolved court fees or fines, has unresolved pending criminal charges or cases in any court of the United States or United States territory, or has valid outstanding warrants issued for the arrest of the applicant by a judge or other judicial official of the United States or any state of the United States territory.
Okay, so most of those parameters have to do with 10 years or less. And other than without possibility of release, there's nothing really at the higher end. Is there any charge, like murder in the first degree, that would cause an individual not to be qualified to apply for a commutation? Or is any charge is satisfactory as long as the individual's sentence falls within those guidelines?
That's correct.
Okay, so this policy was adopted by the Board of Pardons and Parole and signed off by you in 2021. That's correct?
Yes, I
And was
believe that
that-
is correct. I have another date there, but yes.
Okay, well, no, what's your other date?
I have a policy in front of me that was signed off August 2022.
So
I don't know what the discrepancy is, why you have a 21 date or 22.
it was my understanding that the policy, the amount of commutations dramatically increased in 2022, and that the policy had changed and became more what I'm characterizing in a friendly manner as robust in 2021, but just maybe I'm wrong. That's all right. I don't want to know.
I have effective date of this policy as January 1, 2021. That's what I have here in front of me, sir.
Okay.
No.
So we have two things. Something was signed off in August 2022, and the policy was effective in January of 2021.
It may not be the same thing. You may be correct in saying 21, and I just don't have that in front of me now.
All right. But it's around that time. Something you're indicating that the story starts in 2015, that it was sort of gestating, and that you, and in consultation with the executive director and your staff attorney, decided to ramp it up around 2021, and parameters were drafted and then formalized, signed off by you, bounced off of someone in the Attorney General's office. And then the numbers came to fruition, where I noticed the greatest change in impact in 2022, when it sort of like really was in full gear. And so who was made aware of this change when it was written down and formalized? Were members of this committee informed?
I had no formal notification to this distinguished committee, Senator. No.
Were members of the governor's office informed?
I didn't have any official notification to the governor's office either, sir.
So you just did this on your own?
The enabling statutes allow the Board of Pardons and Paroles to make its own policy.
But advocacy groups were aware?
I'm not sure. I just was trying to answer your question before. I'm not sure that they were aware.
How did the inmates become aware?
So that's a question, Senator, that I can't answer, that I know you've been asking, but you know, this committee worked very hard to give offenders' phone calls and tablets. So I think the word just sort of goes. I never made a visit to a facility to like make an announcement. I think they just talk with each other. But the truth is, sir, I cannot answer that question.
Well, Chairman Giles, I find that incredible in that you're working to implement something that you feel is part of your mission statement. We can disagree on that. And, you know, because life is so much about degrees and moderation and everything. And so if I were in charge of implementing or putting the time and effort into putting together a new policy and then signing off on that, I would then, I would say to one of my staffers, can we make sure this gets posted, that this information gets out? Was there a period of time where after a month, no one applied and you said, how come we have nobody applying to this? It just strikes me as odd that you would go through this process and not make sure that the recipients of the largesse of this process, at least an ability to know that it's out there. You never had any interest in letting people know that this was out there?
So no, Senator. In fact, this committee did that when they authorized and put in statute that a pardon brochure should go out. Since 2015, more than 50,000 pamphlets have gone out at the committee's discretion, at the committee's direction. And on the back of this page, it talks about commutations in this pamphlet that we worked together in 2015 with this very committee to get the word out to folks.
But again, when the policy was formalized and changed, did the pamphlet change how it was printed up?
I don't believe so. The staff gets these orders for pamphlets. They have to be given out, as you know, in court, at sentencing. There are several when people walk out the door. So I can't answer that question, but I do know since that time, this brochure has information on commutations. Offenders have phone calls that are free, and they have also tablets. So they talk to each other, and I cannot answer the question about how so many people begin to learn about it. And also, as you know, there are attorneys in the community.
All right. Well, we're going to have to just put that in the box of a mystery, because somehow all this effort was put in to do this, and the inmates became rapidly aware of it, but no one on this committee was aware of it, and you didn't tell the governor's office. And I find that problematic because it's a major change in our judicial system. That being said, when did you notice an uptick in the number of applications?
So I would have to take your word for it. I know you've been following this, Senator, and part of the reason is because I am also, as I said, a working chair. So I'm not solely concentrated on that, the kind of thing that you're talking about. I am also reading cases for parole and pardons and early terminations and so forth.
Yeah, we've known each other a long time.
Yes,
and
indeed.
I have the utmost respect for you.
Thank you. Likewise.
I'm just incredulous that this huge change. When you were a law enforcement officer back in Norwalk, and you made an arrest of someone that abused a child because you said you were working with the most vulnerable.
Indeed.
Didn't you expect that if they committed a crime and they were sentenced, that they would serve most of that sentence?
So when I was a police officer, sir, yes, I did. When I was a police officer 40 years ago. Yes.
What changed?
Well, I've lived and I've seen things and I've learned, and I think that, life can be different.
All right. So if someone has served 10 years, anyone that in our prison system right now who has served at least 10 years, who doesn't have any of those disqualifying factors like an outstanding court case or a fine or fee that hasn't been paid, right now, the message out to the public is anybody in there for 10 years, you can apply for a commutation. You can have a hearing and have years taken off your sentence. Is that the state of the law in Connecticut right now?
No, that's incorrect.
How would you characterize it then?
Somewhere halfway of what you were saying, persons are eligible to apply, not given any of these circumstances. But there's a very, very robust, to borrow your word, screening process And many of these cases, as you know, because you're a student of the numbers, many of these cases, in fact, the case that has garnered so much attention never make it to a full hearing, and in fact, can be proof that the system is working just as it was designed. That a person who has a notorious case, who hasn't shown an effort toward rehabilitation, is denied at the pre-screen session. Persons who have shown some effort, who look like they may have some meritorious behavior, can make it to a full hearing, and some of them are denied at a full hearing.
Okay, let me just stop you there. I appreciate your candor. Implicit in that is sort of a screening process. It's my understanding that the inmate would make an application and there's and so that was my question. They'll make an application. There's sort of a first bite at the apple. They'll be initially screened. And then if they make it through that initial screening process, then there's a full hearing. Is that a correct statement of the process?
That is correct.
Okay, so my question is that every single inmate in Connecticut right now, if they have served 10 years of a long bid, when I say long bid, a long sentence, one that's exceeding 10 years, and they don't have any of those other fairly minor disqualifying factors like an outstanding court case somewhere else, or they still owe some money. If they're just in there for a bid over 10 years, which are serious crimes if you're getting over 10 years, every single one of those inmates has the ability to apply. That's the first step. Just applying, filling out the form and applying so that they can get to that first screening. Is that a fair statement?
That's a fair statement, excluding what we talked about earlier, that list you made me read.
Right, but I personally don't think that that's a huge exclusion. I don't think there's a lot of inmates that fall in those categories. I think the vast majority of inmates doing time over 10 years have the ability to apply. So that's news to me. And now everybody in Connecticut knows. Every single inmate in Connecticut doing over 10 years can apply for a commutation and they will get to the first screening. At the first screening, is it the same 3 members of the Board of Pardons Paroles that review all those applications?
It is. It's the same process for the pardons process as well. The persons who are going to be on the full hearing or vice versa do the pre-screen. So yes, it's those same 3 persons.
All right, I don't want to say the process is rigged, but I want to say this.
Hold on. I'm gonna interject at this point.
Sure.
There's been a number of there's been some chatter in the audience, and we need to make sure that we take our conversations out in the hallway, and we need to keep outbursts to a minimum, or not at all. We need to let the senator ask questions and the nominee answer questions, and we can't have kind of the back and forth in the room. Okay, Senator, you have the floor.
Thank you very much, Chairman Staffstrom. What I mean by that is in an initial screening process, you have a review. What you've stated is that the policy now is, as implemented, that the same 3 individuals that do the initial review then will do the formal hearing. To my mind, that's like putting a Superior Court judge on the same panel as the appellate court to review their own decision. I guess my problem with the way it's set up, and it's not any of the individuals, it's the structure, is that do you see any problems in having the exact same 3 individuals that do the initial screening to do the formal hearing? And the concern that I have, I'll be direct, is that if I've looked at an application and I say, yeah, this is a good individual, it meets my base level to get through the first screening, I think I'm going to probably go into that formalized hearing not completely unbiased because I've already been exposed to certain facts that have passed through my judgment once already. And so I just think that in that situation, there's a predisposition at the formal hearing to be favorable to the applicant. Do you not see that as a possibility? I'm not saying that happens. I'm just saying, if I'm just John Q or Jane Q public, and I'm looking at this from the outside, let alone if I'm a family member of a victim, it just doesn't seem even-handed. And how do you respond to that?
I disagree with that, Senator. In fact, it doesn't bear itself out because some folks who get to the full hearing get denied. And that's because just like in the pardons process, at the pre-screen, we don't have all of the information. We have sort of a, not quite a skeleton, a little more than a skeleton, but when a person is triggered out of the pre-screen for a full hearing, based on what we've seen initially, then we get more information. And sometimes at a full hearing, because of the information we have, the person is denied. So I don't think your theory plays itself all the way out.
Okay, so the denials are evidence that it's not biased. And I would say it's not completely biased.
Thank you.
But I would say that there might be a little tipping of the scales of justice. That's just me. I know that everybody walks into this saying, I'm not convinced one way or another. And certainly you're saying that the denials are indication that further evidence can change how those scales are perceived.
Sure. And Senator, of course, we've had your confidence across the years on this, with our training and experience that we've been doing some things correct. And we've been very grateful. And all of us are hoping to have your support again to continue on in this work that we're doing.
Not on this one, but in any event, here's the deal. What has caused during this new process to cause the granting of, well, first of all, do you have statistics on the number of commutations that were granted in 2022? I think it's like over 70, but.
Yeah. That information is on our website, and 21 and 22, it looks like the total cases that were processed were 328. The overall grant rate seems to be 23%. I have a math phobia, so the minute you ask me about that, then it just goes left. But I have the sheet here, Senator, which can be made available to you, and all of this information is available to the public. We put these stats on our website. We have an excellent research division, and they do this. This is what they do.
Well, I get it, but I'm just asking for a simple statistic, and you can't read it to me.
So the numbers are there. It looks like denied at full hearing. Well, I hope I'm right. Is 2. Thank you very much. In commutations received in 2022, looks like were more than 450. Ineligible were 135, denied were 167, and granted were 63.
And that was for what year?
2022, it looks like.
Okay, so I had 70, 63 appears to be the right number. And it's my understanding, and you may not have this statistic, but the average amount of time commuted was 15 years. Is that correct?
And again, I don't have that number with me. They're going to kill me because I'm sure. Yes, 15 years. Yes.
Right. So that's a huge policy change. Don't you feel that that should have been a directive from the legislature?
So Senator Kissel, as you know, the enabling statutes permit us to make our own policy when it doesn't say something different. We, as you know, you and I have been to your conference room before on other issues, and we are certainly willing to work with you on this. I did not think that my authority was somehow diminished to write the policy on this as we had done in other cases.
Well, I'm going to have to agree to disagree on that particular one. I think just personally, and I can't speak for the committee, that it undermines people's confidence in the judicial system. Because so much time and effort goes into the sentence. I've talked to judges, especially upon renomination, if they get the criminal side, they struggle with every sentence. Victims are informed after a horrendous crime, especially when someone's going to be sentenced to over 10 years, that the individual's going to be in prison for such and such amount of time. That let me go back to one of the things you had said earlier. You said if an individual shows any kind of change, I don't know if it's remorse, I don't know if it's good behavior in corrections. What is it that tips the scales in favor of granting an inmate's request for a commutation? Generally, and I know that these are case by case.
They
I
are,
get it.
yeah.
But what for you and the other two members, and I know maybe you can't speak for them, what's sort of like the key thing? What is something that inmate X shows a really good record for this and inmate Y didn't, and so no on inmate Y, yes on inmate X?
I don't know that there is one particular thing for inmate X or Y. It's really about the body of work that they have tried to do. And if I said anything, as you just said, I said, I didn't mean to minimize it in that way, and I would have misspoken, because really what we see, and after we examine it, it really has to be sort of overwhelming is a better way to say that, not just anything. If I said that, I misspoke and take that back. I don't know that I did, but it really has to be some sort of extraordinary effort at rehabilitation. And I know, Senator, that you are pleased about this because at least this piece of it, the school in your jurisdiction is a leading educational institution in helping prisoners to do better and get their education. You, of course, having the most correctional facilities in your district, but you also have Asnuntuck in your jurisdiction. And they are one of the leading schools, along with others, Yale and Wesleyan, preparing offenders to reintegrate suitably.
Yes, and as you're referencing my district, you'll recall that I had a problem when they decided to allow inmates into Asnuntuck because Asnuntuck as a community college was not designed as a correctional facility. And indeed, my concerns were borne out when one inmate decided to escape from Asnuntuck and then found somehow miraculously within 24 hours in Waterbury. And I don't know, did they have a car waiting for them to whisk them to another community? Did they hitch a ride? I don't know. But I can tell you this, constituents of my district were concerned when they found out an inmate had escaped from Asnuntuck. And I think that it was discontinued at that time from having inmates in the facility.
Right now,
So there are consequences to actions. I think that other members of this committee have probably a lot of questions. I've tried to elicit as much information as I could. I'm still a little mystified. I know that you feel that you're acting in simpatico with the legislature, but not with this legislator. I really wish that this had been bounced off of us before it was implemented. I know that perhaps we failed in giving you an open-ended statute. I'm going to have to vote against your renomination today to flag this until I get to the bottom as to exactly what's taking place, because it is not the public policy that I support. I have no problem with a commutation once in a while if someone's older in years or ill or something like that. To have it as a wholesale, open the back door on a sentence for every inmate that's in there for over 10 years, if they show any kind of rehabilitation progress, is not justice in my mind. And I hope that you understand my perspective.
Thank you, Senator. It's good to see you again. Thank you.
Thank you.
My
Mr.
regards
Chair.
to Cynthia.
Further,
Yes, thank
further
you, Chairman
questions or comment?
Stafford.
Representative Fishbein.
Thank you, Mr. Chairman.
Good to see
morning,
you.
sir.
Good to see you. Good morning.
I will share that over the last week, I watched many videos of proceedings of your body. In fact, my wife says that you owe her a weekend because almost every waking moment this past weekend was spent researching and reviewing videos. I've watched every video that is on CTN or on YouTube in preparation for today. One of the individuals that recently was commuted was a Carl Alexander. And I will give you credit, Chairman Giles and Ms. Smith Palmieri and Mr. Pohl. As you may recall, Mr. Alexander was originally sentenced, I believe, it was kidnapping one. He was given 42 years. His out date was 2024. During the hearing, it was quite clear that Mr. Alexander is a different person. And you guys all recognize that, he's part of the True Group, True program at the facility. In fact, they had voted him as being the chair of the group. The victim had written a letter saying, I understand, I forgive him. I leave it to the board. And in fact, during the hearing, Mr. Alexander didn't know that was coming. And he shared with you that he had written a letter to this individual many years ago and was holding on to it because he was unable to get it to that person. In that case, you did reduce the sentence by 18 years. Now, I'll share with you that last week we had a bill before us on Wednesday having to do with individuals getting ID when they got out of prison. And on that day, Mr. Alexander came before us. So I got to see the front end and the back end, right? And Mr. Alexander shared with us how it was very sudden. He didn't have an ID and the difficulties. And that's something we're going to have to work on. But in my review, I got to see Mr. Alexander at both ends, and that was very, very helpful to me. I do recognize that, I think, but for this policy, and for the moment, I will share that term, Mr. Alexander probably would not have been afforded the release that he got. In my research, I've learned that the Board of Pardons was actually created in 1883. That at some point thereafter, the Board of Paroles was created, and then they were merged together in 2004. There's a difference between parole and commutation. In fact, in 1992, Governor Weicker asked Attorney General Blumenthal at the time to opine on commutation, because commutation only appears a couple times in our statutes with regard to the Board of Pardons. In fact, a warden is allowed under the statutes to do a commutation separate and apart from the Board of Pardons. But traditionally, a commutation only dealt with a death sentence. And of course, when the death penalty went away in this state, that portion of commutation went away as well. So at the very nth, the major or the longest term that we could have is life in prison. In the letter from Attorney General Blumenthal to Governor Weicker, he notes that the power to commute a sentence is part of the pardoning power under which it may be exercised. And he goes on to say that ordinarily the pardoning power resides in the executive. And he actually references a U.S. Supreme Court case, the Dumshot case. But he says in Connecticut, the pardoning power is vested in the legislature, which has delegated its exercise to the Board of Pardons. Once again, referencing the Dumshot case. So the U.S. Supreme Court has said that the pardoning power exists in the legislature. However, we would defer to the Board of Pardons. So, statutory construction is you're given the power that the legislature gives you. So as we move forward from there, and we look at the enabling statute 54-124A, the only place that commutation appears in that statute says commutations from the penalty of death in accordance with section 54-130A. It's the only time. It doesn't say commutations from all penalties. So we go to 54-130A. Once again, the only other reference to commutations in conjunction with Board of Pardons is in parent A, commutations to the penalty of death. Now, we've heard the term policy here today on numerous occasions. So, Chairman Giles, what is a policy as opposed to a regulation?
So we, over at the board, do not have a requirement to go the regs route, although for one of our things in my tenure, we have done it, I don't know. But anyway, we are permitted to promulgate these rules for our process to move forward. As opposed to the legal regulation that you're referring to. I know I heard Senator Kissel earlier talk about that. We were not required to go through the regs, Connecticut State's reg process for this. It was my understanding.
Well, where does that understanding come from?
So I was not informed that my office, that I had to, as a chair, run my policy through regulations.
Okay, so
On this.
the expedited pardon process, it's a regulation. You recognize that in 2015 or thereabouts, the expedited pardon process was created, and that was by regulation. So you went through regs review on that.
Right.
Now, I'll point out that under our statutes, a regulation, and this is 4-166, which expressly you do fall under, and we're going to get to there in a moment, does not include statements concerning only the internal management of an agency and not affecting private rights or procedures available to the public. What we've heard about today is that through this, whatever it is,
Policy.
as you like to call it, you have restricted certain individuals from being able to apply for something. That's a regulation. The full of regulation in the statute says it has to do with any procedure or practice requirements of any agency. There is no definition of policy. So generally a policy is an internal, we will use blue pens in our office. That's a policy. It's not a regulation. So the 85% rule with regard to parole, is that a policy?
I believe that it is one of our policies, and 50%, 85%, yes.
Okay,
Under the
well,
statute, yes.
but it appears it's codified in regulation 54-125A3.
Right.
It's in the procedure. So it's not, it doesn't exist in a vacuum. In 1995, Public Act 95-255. The legislature passed a provision that says the Board of Parole shall, not later than July 1, 1996, adopt regulations in accordance with Chapter 54, which has to do with it's the UAPA, the Uniform Administrative Procedures Act, to ensure that a person is convicted of an offense described in subdivision 2 is not released on parole until such person has served 85% of their definite sentence. Such regulation shall include guidelines. That was the enabling statute. When we get to 4-168, Connecticut General Statute 4-168, it says, except as provided in subsection G and H of this section, an agency not less than 30 days prior to adopting a proposed regulation shall follow the process. G and H have to do with emergencies. I think we can agree today that none of this went through regs review. 4-167 says no agency regulation is enforceable against any person or party, nor may it be invoked by the agency for any purpose until you follow the regs review process. Within the document, which I have, it says in the limitation of rights, no person has any right or entitlement to a commutation. Furthermore, participation in the commutation process may be limited or eliminated altogether at any time at the discretion of the board. Where is the enabling statute that allows you to shut off commutations?
So it's, it's my impression, Representative, that the enabling statute, as I've referred to before, gives us the authority to write these policies as we have done here. Senator Kissel is correct when he opines that, you know, we don't have any board members who are lawyers. He goes on to say we don't have to be, but we, you know, we refer to our legal folks around us, but it is my understanding that the enabling statute for the Board of Pardons and Paroles gives us the authority to write these policies and then implement them.
And you have a letter from the Attorney General's office confirming that?
I do not know if I have a letter from the Attorney General's office confirming that.
Okay, so, because I'm going to tell you, in the dumb shot case, our Supreme Court does recognize a right in a commutation, not the issuance of the commutation, but the ability to file for a commutation. The court said, we hold that the power vested in the Connecticut Board of Pardons to commute sentences conferred no rights on respondents beyond the right to seek a commutation. So our US Supreme Court has opined that there is a right to seek. I do not know by what legal authority the board takes it upon itself to tell people that they can shut off that process. You know, part of the problem here is I see good things, but somebody jumped the shark. Victims of heinous crimes are part of the process. And when they agree to some sort of a sentence with the prosecutor, and that's of availing to the family, it's almost an implied contract. I really think that this is a regulation. In fact, your document, it has a section that says supersedes, and there's a colon because it's a standard document, and it says new. So you created this new, whether you want to call it a policy or not, it is a statement of procedural rights that clearly is a regulation and clearly should have gone through regs review. And I'm just concerned. I mean, when this board was when the Board of Paroles was originally created, it was required that 2 lawyers be on the board. There are no lawyers on the board now. I don't know if that would be of help or hindrance at this point, because I do see that you folks are doing good work. But something like this should have been approved by the legislature. I mean, Senator Kissel is the chair of regs review. I'm on regs review as well. I really think that somebody should be taking a step back and following the proper process, and perhaps not acting on any of this without following that process. I will point out that I do have the pre-screened document from March 8th. There were 74 cases that came before you folks. 35 of them were approved, so it's about a 50%. I understand the intent. But I can't affirm what's happened here and what apparently continues to happen. I would like to vote for all of you folks. But something's got to be done. So I'm on like two different planes.
Yeah.
I love you all as people. I love what you're doing, but there's a process. And if you don't follow the process and you just do your own thing, then how can I affirm that activity? So, yeah.
So Representative Fishbein, because you have, sort of articulated, you have faith in us, we are hoping that you will reaffirm us to go back and do the hard work that you and Senator Kissel and others are saying needs to be done. The biggest room in the world is the room for improvement. And if we have, as you suggested, maybe gone too far or not done it the way that maybe some of you suggest, as you know, as I said to Senator Kissel, we have been up to his conference room before to work out things. It's no different now, sir. These things are fluid and we are willing to do the hard work as we've done already to make this a way that meets everybody's or most people's expectations. So I do hope that you will give us your confidence again.
I appreciate that. Can I just, a few more questions? You mentioned that the board had approved this commutation document. Did the board approve it?
No, the entire board has an opportunity to give input, but not in a formal way. Like I don't call them together and say, I'm doing this. So no, I didn't mean to say that. When I say board, I'm really talking about the agency.
Okay.
Yeah, not the individual members who you will see today.
So was there any official meeting where this document was shared in any form with the board members?
I can't recall that we had such a session. It is possible because we do meet for training but I did not have a session where I called them together just to review this in particular. I don't believe I did that. No.
Because I will tell you, I clicked on every link and I looked at everything and I didn't see it on an agenda.
Right.
So that's of procedural concern to me as well. Now, you signed it on 5/25 of 2021. But it says it was effective June 1, 2021. Why is that?
Yeah, I don't know, Representative.
No, it says June 1.
Yeah. I don't know was there a discrepancy in the time? Is that what you're asking me?
I don't know. Usually if we sign off on something saying that it's effective,
Right.
it's effective that date, right? So, 25 to June 1 is about a week. So I'm thinking, I don't know what's going on here.
Yeah.
Why the document would say effective June 1, 2021, but it was signed by you on May 25 of 2021. Why wouldn't it be effective upon signature?
I don't think we generally do that. Generally, the team, the legal team will give it to me and we try to promulgate it to the agency so they'll know what's going on. I don't know the answer, but generally that's what we do.
Okay, thank you.
Yes, sir. Mr. Chairman,
Chairman,
I'm
yes.
sorry.
Do you need a break?
I would love a comfort break. I was just going to ask you.
Yeah. Why don't we take a 5-minute recess?
Thank you.
All right, I'm going to call the committee back to order, please. And I'm going to ask again for quiet in the room. Please, side conversations need to be taken out into the hallway.
Good to see you.
Before we move on to other folks, Chairman Giles, you were asked a series of questions before the break about your interpretation of statutes and your power and authority. And I don't think you had these statutory references at your fingertip, but I would like, I've been trying to follow along, and thankfully I have the advantage of the blue book in front of me. So I just wanted to see if we could clean up some of your testimony a little bit. I'm looking specifically at Connecticut General Statute, section 54-124A F, which reads, the Board of Pardons and Paroles shall have independent decision-making authority to, skip down to number 4, grant commutations of punishment or release, right? So we can, is that the statute you're referring to by saying the board does have the authority to grant commutations, correct?
It is, sir, yes.
Okay. And then if I look at Congen Stat 54-124A D, which reads the chairperson, that would be you, correct, shall be the executive and administrative head of said board and shall have the authority and responsibility for, skip down to number 4, adopting policies, and you've referred to the term, you've used the term policies a number of times in testimony, in all areas of pardons and paroles, including, but not limited to, which is that term we in the legislature use to give broad authority, granting pardons, commutations of punishment or release. So is that the statute you're referring to when you testified previously that you believe you have the power as the chair, irrespective of the legislature, irrespective of other members of the Board of Pardons and Paroles, to adopt policies relating to commutations?
It is Representative Stastrom, yes.
Okay. All right. I just want to make sure we have that, because I mean, I think we can have a legitimate debate here today about whether that policy, whether the policy that was adopted should or shouldn't have been. But by my read of the statute, the question of do you have the authority to adopt that policy, I think is pretty clear in the statute, is very clear, it's crystal clear in the statute. So I just, as we continue this discussion here today, I think it is fine for folks to differ on whether a policy should or should not have been adopted. But whether you have that authority or not, I just wanted to make sure that we frame this debate around that statutory language.
Thank you, sir.
Representative Osborne.
Thank you, Mr. Chair, and thank you very much, Chair, for being here today. I developed an interest in this when a constituent of mine contacted me with real anguish that there was a application coming up before your board concerning the possible pardon, parole, or commutation of an offender who had brutally murdered the daughter of dear friends of hers, and who the daughter who my constituent knew. And the anguish that this family experienced was palpable, and something that I wouldn't really want to revisit on other families. So I've done some research into this subject, and I have a couple of questions about that screening step that's in there, because I do know that there is statutory authority under I think it's 125A for the exemptions of certain types of crimes like first-degree sexual assault, felony murder, capital murder. Those prisoners are not eligible for parole under that statute. but that doesn't mean that they're ineligible to apply. So I have a couple of questions. So what happens when someone who is ineligible for relief under your policy? What happens when they do make an application, even though they are ineligible? Does that start the entire process? Do they go through screening? Will they be denied at screening? And what triggers a notification to the family that an application has even been made? So that's my first question.
So the first part of your first question is, if the person is ineligible, it never gets to the pre-screen panel. The staff has weeded that out already.
So the family will never be notified, and they won't have their trauma stirred up from an ineligible application, correct?
Well, here's what happens. If a person applies, there is something called a notice of application that a family is triggered. So it's hard to do this, but in some of these specific cases, there can be a double notification, because when an offender applies, a registered victim is apprised of the notice of application. But in answer to your first part of your question, an ineligible application never gets to the pre-screen.
Okay.
That's not the second part of your first question.
Okay, so thank you for that clarification. The next question is, when you are in pre-screening, is there any part of your policy at the pre-screen level that considers whether the offender had taken a plea bargain to begin with, and whether they had a reduced sentence as a result of that? And if so, by how much that sentence was reduced? Is that analysis part of the pre-screening review?
It is not.
And to your knowledge, is that analysis, or are those questions, those issues, part of the review if they get through pre-screening to the next level?
It is, and I should maybe circle back.
I'm sorry, I misheard. Is that it is or it is not?
It is not part of the pre-screen process. And as I stated before, very often we don't have all of the information related to the offender in the pre-screen. Sometimes more information is triggered if they come out of the pre-screen for a full hearing.
So you may or may not have information about a plea bargain, or by how much a particular offender sentence was reduced at the full hearing, correct?
Or even a sentence modification at the pre-screen. We may not have that information yet.
Okay. In addition to the capital felony and the felony murder and a couple of other handful that are completely ineligible to apply, there is another category of offenders who cannot apply until they've served, I think it's no less than 85% of the definite sentence imposed. So if somebody were in that category were to apply when they're, say, at 50% and therefore ineligible, that would trigger the same. They wouldn't get to pre-screen, and staff would keep it even out of pre-screen, but that application would trigger a notice to the family. Is that correct?
So I think you're mixing apples and oranges. The 50% and 85% designations are strictly for parole. And I thought we were talking about commutations, but maybe you're going back and forth.
I think I probably am.
So they're right. The 50% and 85% designations are controlled in statute, and those persons don't get talked to about parole hearings until they're 6 months out from their eligible time.
But they still have the capacity to make an application, and although it wouldn't make it to the pre-screen, it would still trigger a notice to the family. Is that correct?
Parole hearings do still trigger notice to the families, but again, you're sort of mixing the two categories.
Okay. I'm here learning too, so thank you very much for that education. Without wading into the issue, I'll say I agree with Chair Stastrom. I think this was clearly in your legislative purview. And it is the legislature that has granted sole discretion. Whether people agree or disagree with that, how that discretion has been exercised is really a conversation for this committee. But I thank you very much for being here today and for answering the questions that have been put to you and for helping us to understand this process better. Thank you very much. Thank you,
Thank
Mr.
you, ma'am.
Chair.
Representative Labriola.
Thank you, Mr. Chairman. I'd like to begin by saying that I agree with the sentiments expressed by the ranking senator and the ranking state representative on this committee and their concerns about this policy shift, as Senator Kissel called it, a sea change. It's a massive, huge, radical change in policy of your board, Chairman Giles. Thank you for coming here. I think it's important that we focus on this. Thank you for patiently answering all these questions, because this is a big issue. And I think that the public should be made aware of this. And this public hearing, I think, goes a long way towards that, shining a light on this. Because I would suspect that most people in the general public would not agree with what's been going on. And I noted you used the phrase "room for improvement," and I certainly hope that you take that into consideration going forward. I learned about this from the press. I saw there was a series of articles about it, and right around the same time, I was in court, and I talked to some prosecutors who alerted me to it as well. I've had the privilege of serving on this committee for 21 years. I am a practicing attorney in criminal law for 36 years. I'm in criminal court all the time. I talk to prosecutors and judges. From what I gather, they weren't really aware of what was about to happen, the prosecutors and the judges. Did you make any specific notifications to the prosecutors or judges of this policy shift?
I don't believe we did, no.
Well, I guess then going back to what I said before, I think it's good that we're shining a light on this, because these are the same people who were involved in prosecuting these particular defendants. And they were the ones who sentenced them or took the plea in a case where a person took a plea bargain. And so they would be the people who were most familiar with these individuals, obviously, and what they were charged with and what they were either convicted of or pled guilty to. My level of concern is quite high. I don't recall being this concerned in my time here in the legislature. Because though, you talked about that there's room for improvement going forward, if you're confirmed, it's too late. These people were released. You don't have the power to change your decision, do you?
So it's important, Representative Labriola, to know that the persons who have been commuted, none have been returned. There have been no incidents with those persons at all. Some of them are in the room today.
Through you, Mr. Chairman, do you have the power to reverse your decision and send them back to jail?
I believe the policy talks about being able to revoke them, Representative Labriola, but with any citizen, of course, breaking the law, they would be arrested and charged and so forth. So nothing has happened with the persons who've been released. Many of them, some of them are in the room now.
Thank you. I think what you're saying is that they haven't reoffended.
Right, which is what I thought you were alluding to.
No, I'm asking, isn't the decision a final decision on your part? And once the sentence is commuted, isn't that a final decision? It's too late, right?
Well, too late is,
Do you think that a prosecutor or a judge could re-sentence a person who's been commuted?
I'm
for the
not
same
certain,
crime?
not certain what our policy says on that about judges and prosecutors, but I do want to point out, though, since you mentioned prosecutors, Representative Labriola, the prosecutors are part of this process. They appear at the hearings as well, and we take very seriously their consideration. John Doyle has been very active, along with Chris Watson, State's Attorney Chai, all have been very, very involved.
Well,
among others.
I'm going to move on from the part that these are final decisions that you're making, and that, in my opinion, it's too late. I have talked to some prosecutors who prosecuted some individuals whose sentences were commuted recently. And I've talked to some judges who were prosecutors at the time, who prosecuted these individuals. We're not talking about small crimes. We're talking about major crimes. These are people who got lengthy sentences, either by accepting a plea bargain or by being sentenced after trial to, in many cases, horrific crimes. And these prosecutors and judges that I talked to, they just shake their head and they think that the policy that's being implemented is wrong. You know, in response to the previous questioner, legislator, you talked about victim notification. And you just now started talking about prosecutors' involvement. But I was listening to this public hearing as I was driving up here. In your entire time that you were here, you didn't really talk much about considering victims or the families of victims or the danger to society at the time of the crime or the danger to society now. I don't think I heard you say that. And so I just feel an obligation as a legislator who has constituents who are members of the general public to ask these questions.
Yes.
And I know they're tough questions, but I feel compelled to ask them. It seems to me that the victims and the victim's family and the danger to society should be uppermost in your mind in making these decisions. Is that the case?
That is in fact the case, Representative Labriola, and thank you for giving me the opportunity to speak to that. And the reason I hadn't spoken to victims is because nobody was asked me as you have done. Victims, as I said, are involved in our process, and we take very seriously the input and impact of victims. I want to tell you also, Representative Labriola, that there is no monolith about victims. Often what's happening, of course, like maybe today or others who advocate for victims, we can sometimes bring our own thoughts on what the victim is feeling and thinking and seeing. But I should tell you, there are other victims' voices. I think Representative Fishbein referred to one, and there are others, many others. Some victims, sir, who come and say they understand that progress can be made. And quite frankly, looking back 30 years or 20 years, we wouldn't disagree with the judge. I'm sure that when a judge sentences an offender 2 years out or 3 years out from what you described as these horrendous crimes, we wouldn't disagree at all. But when we have the opportunity to see someone, talk to them, read their file 30 years out, it can be, as Representative Fishbein talked about the hearing he had seen, a totally different individual. Some who are in the room now and doing very, very well.
I don't doubt that those kind of cases exist. I'm asking about the other types of cases, the kinds of cases where a victim feels re-traumatized or a victim's families, because many of the victims that we're talking about are no longer alive.
Right. So Representative Labra, I don't think you can separate them. All victims are traumatized. And when they get a notice, all victims are re-traumatized. But some have processed it in a way that says, if this offender has made progress, it's not up to me, the victim will sometimes say, to hold up they should go out and make an impact. Some are like our state victim advocate who say, it doesn't matter what they've done, they should serve their time, then go do something to society, do well in society. And maybe people will feel that way. But there are others who do make good inroads and strides in rehabilitating themselves. I talked about the university programs that are available and many other things and the kind of work that they do. When we were all cowering, many of us were cowering during the COVID pandemic, we've seen offenders who went and worked in the COVID wards, cleaning up bodily fluids, some things, Representative Labriola, that we wouldn't do for pay. And they've done well. Hospice workers who hold the hands of dying inmates and talk about what a change that has made for them.
I recognize that, Mr. Chairman. I see that is profound. I see that. I'm asking these questions. I only have a couple more. But I'm
Understood.
asking these questions because I feel a sense of outrage on behalf of the general public and on behalf of those victims' families where sentences were reduced dramatically. And let's take the first kind of case. There's only two ways you're going to go, a person can go to jail. They either plead guilty or they're sentenced after a trial. So let's take the first kind. A person pleads guilty. It's a plea bargain. So it's a deal. It's an agreement, as Representative Fishbein pointed out. It's like a contract. And in that process, the victim's family, because often the victim's not even alive, the victim's family or the victim themselves has input. And they're considered by the prosecutor and by the judge. And it's a long process, I can tell you. These cases, they take 18 months. There's a lot of court appearances. It's a lot that goes into it. A lot that goes into it. And sometimes the victim doesn't want to testify, or there might be some part of the case where the prosecutor agrees to a particular number. It might be, it could get up to 60 years, but the person takes a 30-year sentence. And then they're released under what's been taking place in the last year and a half with, say, 10 years off or 8 years off or 15 years off. That strikes me as an outrage to many victims. That's what I'm asking about. I'm not asking about the cases you were just talking about, which I applaud, and those are profound.
Right.
I get it. I'm asking about the other kinds where a victim or victim's family might feel as though they were slapped in the face. And so I ask you, do you consider the fact that in a plea bargain, that they were part of that deal at that time?
So heretofore, Representative Labriola, we have not considered in a great way, although we consider everything, we've not considered in a great way this sort of contract as you all have described that goes on between the prosecutor and the victim. We're looking at the case way out, and we're trying to see if the person is suitable for reentry into society. Victims' input is very important to us, as I've said, and sometimes, when we have to hear victims, it is, as you described, it can be heart-wrenching. But we're trying to assess whether or not, which is under our purview, a person is suitable for reentry into society. It could be that going forward, victims will control the process. I don't know. But to this point, it's important for us to consider all of those things, jury verdicts, plea bargains, and what the offender has done in those ensuing years to try to make right in the best way they can what they have done.
Well, I think I'm hearing you say that if you were confirmed and going forward, that you would give a greater emphasis to the fact that victims and victims' families were very involved in a plea bargain situation, and that I think you said heretofore you haven't, but maybe I'm assuming that what you're saying is that there's room for progress and that going forward you would consider that.
I've said that, Representative Labriola. I think as you know, the governor spoke publicly about this and said he was going to call folks together. I'm told that he's going to do that. So I don't want to get ahead of his policy folks, but if I am still the chairman, I'll be at the table.
Well, I appreciate that. I just want to ask about the second kind of case, which is where a person goes to trial. They don't take a plea bargain. They say no to the plea bargain. There's always an offer. But they say no, and they want to go to trial, and then they're convicted. Well, that's even a more elaborate process where a victim is involved. Because of course, if a victim is alive, they're going to testify in almost every case. Certainly, victims' family members will testify. Loved ones will testify. Spouse, children will testify in many cases. Regarding, let's say it's a murder case. Oftentimes they have relevant information, and so they're involved by testifying. And in this case, it's not that the offender pleads guilty, they're found guilty by a jury of their peers, and then they're sentenced by a judge. And when the judge sentences them, he considers the victim's testimony, not just their input, but he presided over the trial. So he saw very dramatic and poignant testimony. So the judge really considers the victim when a judge sentences somebody after trial. And so that judge who sat through the entire trial and presided over evidentiary questions, made sure the trial was fair. Presumably it was fair because there was no appeal, or if there was, it was unsuccessful. So the defendant was given a fair trial. The judge listened to the case, sentenced the defendant, and certainly very much considered the victim's input and society as a whole. So I hope, and will you consider that as well in the course of your decision making? Will you consider the fact that the judge factored into his decision on how many years a person should serve, almost in a very big way, he considered the victim's input? Will you consider that in your decisions?
So the answer is yes, as we already have and always do. And as I said, Representative Labriola, we probably do not disagree with the judge when he sees an offender 2 years out or 3 years out, when he has to make that decision at that time. When we see someone under our statutory authority, it's often 25 years out, 30 years out. And the question is, what our assessment is this person suitable for release into society? And if we have assessed that they are, then they get an affirmative answer in their commutation hearing. But often, sometimes it is not met, that threshold. But in answer to your question, yes, we consider what judges have done, prosecutors, victims we hear, they come, we're very grateful for their participation. We know we can empathize with them.
I have no other questions, but I just want one last comment. So it's obvious that you are quite competent, you are knowledgeable, you are articulate, you are passionate. I do think, though, that there is room for improvement. I would like to see the policy radically reversed. I think that the general public would like to see it dramatically reversed. I feel compelled to not support you today. I don't see how I could. But I hear that you are going to much more thoroughly consider victims' input at the time of sentencing, at the time of plea bargain, and that you're going to factor those things in going forward if you are confirmed. And I hope that is true. And I wish you the best.
Thank you, Representative Labriola. Hope to have your support.
Representative O'Day.
Thank you very much, Mr. Chair. And Chairman Giles, thank you so much for being here. I am truly appreciative of your, as has been stated before, the passion, the forthright. I mean, you're answering tough questions and you're getting them, and there's going to be a few more. But please don't take from my questioning anything but the deepest respect for your years of service to the community, to Norwalk as a police officer, and especially as a pastor. It does warm my heart, and I do appreciate all of your service. One of the lines you used in your position is, it's almost like trying to change a tire while a car is moving. Maybe you should put the car in park and put on the brake next time, because as you've heard, there's a lot of concerns about how the policy change was significant. And I say that in trying to use your words. There was a dramatic increase in the commutations. Is that fair to say, from 1 year to essentially 2021, 22?
Yes, we've gone over the numbers.
Yeah,
Yes.
yeah. And I'm not going to go over the numbers again. Don't worry about it. You don't have to look at it again. But can you well, let me ask it just open-ended. Would you do anything differently, having gone through the questioning so far here today at all?
Well, we've already gotten input, from the Attorney General's office. If I thought that input from this team in the committee would have been more useful, I mean, I'm not I think I've said, Representative O'Day, you know, we've been to Senator Kissel's office before. So if we've had that opportunity, we certainly could do that. We've done that before. That's not a strange, I don't want to ruin his reputation, but he sat down with us before and we would do that. So, yeah.
Yeah, so in other words, no, I what I'm hearing in here, listening to everything, I think if before you implemented this policy, no, let me just get my facts correct. My understanding from your previous testimony is that you essentially met with your legal advisor, executive director, and spoke with either yourself or someone of those other two, spoke with the AG's office before implementing this policy. Is that, I
I
understand?
believe that's generally correct.
Okay.
Yes.
Might I suggest that when you implement such a policy change, that it might be a good idea to include the chairs and ranking of the judiciary, which has oversight on this committee? Would that be a fair comment?
I think it's a fair comment for sure.
Okay. And that wasn't done before implementing this policy, as I understand it. And it wasn't done within, your whole board did not vote on this policy change. Is that fair?
That's correct. That's
Okay.
not right.
So, and I think, Chairman Giles, that's the biggest problem that I personally have. Because I think if you had reached out to the ranking and the chairs of this committee and had a full board vote, I think maybe some of the other board members might have said, hey, this is a big change. Let's have some conversations. And I do like your comment, and I'm going to use it. The biggest room I know of is the room for improvement.
Right. Not an original, but please feel free to.
Yes. And so, but I want to get through. I know we've got a lot of people here. You said that there's three of you on the board that go through the commutations. Yourself, board member Pohl, and board member Palmieri. Is that correct?
Yes.
All right. And you said that you have the expertise, and I heard your expertise. You said that you created that group to look at the commutations, correct?
You're right.
Based on your expertise, the expertise of that group.
Yes.
Just briefly, if you could describe why you believe the expertise of the three of you was why you put that group together.
Thank you. Panel member Pohl was a middle school teacher. And most of these cases that we're seeing on commutations are persons who are in that adolescent range that we've been dealing with, the neuroscience. And I thought I wanted to lean into that experience that he has had in the classroom and dealing with these not yet developed brains. Panel member Palmieri comes to the board from a long distinguished career in federal probation. And as you know, in federal probation, they can sometimes see their clients over a longer period of time, some because of the nature of the sentencing, sometimes pretrial right to post-conviction. And that sort of long view that she could bring, I wanted on that panel at the time. And that's not unusual. When we first implemented the expedited pardons process, I did the same thing with panel member Zaccagnini and panel member Chance. For about a year, we did those expedited because panel member Zaccagnini had a strong background. She came from the Department of Children and Families, and panel member Chance had a hefty background in treatment and that kind of thing that I wanted on those persons.
When you say you had used the words, the very robust screening process, is that the screening process that yourself with board member Pohl and board member Palmieri, that's the screening process you're referring to when you said that?
So yes, that's the formalized pre-screen process. But remember, we have to get prepared for the pre-screen. So we've done some pretty heavy lifting before we come together in the pre-screen to see what the suitability is to bring folks to a full hearing.
Now, you described your position as a working chair. What does that mean?
I was trying to describe that I still also do hearings. That's the design of the Board of Pardons and Paroles, that the chair also does hearings. And so I do my share. I think I'm maybe meeting with other members of a panel sometimes at least twice a week and sometimes more. So I am still reading files is the point I was trying to make. I'm reading pardons files, expedited pardons files, commutation file, early termination from parole, all of those things. So that's what I mean, just sort of to express.
Fair enough. I was just wondering if there was some outside, like for the board members for here, you're paid as a full-time board member, correct?
That's right.
What are the salary ranges?
Oh, I don't know, sir.
Do you know what yours is?
The truth is, so I hate to tell you that I don't know. But I don't know.
Okay.
But as you know, it's all public. You could Google anybody's name and find out what they make.
Exactly. Legislators, we just went from 28,000 to
Right.
40,000
Right.
Last year.
Representative O'Day, if I may, while you're framing your next question, because you raise a good point, I should tell you the folks with whom I work are highly professional and dedicated and passionate people. When we read files about offenders or persons who want pardons to get their records expunged, we're not thinking about what the salary is.
Oh, no.
I know you weren't suggesting that, but I thought it was a good place to make clear. These folks are quality folks.
And I wasn't inferring
Right.
anything otherwise. No, when you said you were working chair, I was thinking, I want to make clear to the public that the full-time job that you have and the other board members is as a board member on the Board of Pardons and Paroles, and that it's a highly paid position. So the general public knows that your focus is on that job, not working elsewhere on anything else.
That is correct, and thank you for the clarity. Yes.
My last real comment, or actually two questions real quick. The average time commuted was 15 years. Has that been consistent for the last five or 10 years, or is it the average time gotten longer or bigger?
Well, I don't think we have really the longitudinal work because, we hadn't granted so many commutations. So I don't know that you compare when you say over the last 10 years, I'm not sure you can do a sort of straight line longitudinal study on that. My research folks aren't here. Maybe they could, but I don't.
So are you aware though? I mean, can we get I got to believe that there's records that would show us the average time commuted over time.
I'm sure there are out
Okay.
there and I can get them to you.
That would be,
if anybody could do it, our research folks can do it.
that would
If
be
it can be
great.
done, yes.
That would be great, because if this 15 years is an anomaly, that's one thing. If it's consistent and it's just simply more granted,
Right.
not a larger time period, that's different. I will tell you, 15 years commuted, particularly as my colleague pointed out, after a deal was struck, it seems an awful long time that's been commuted. Now, I don't practice in the area. I'm a commercial litigator, and I don't do any. There's two things I don't do as a lawyer: one, criminal work, and two, family work. Okay. Being a commercial litigator is depressing enough. I can't imagine being in that field. No offense intended there, good Representative Leverille. So that's a concern of mine. So if you can get me that information on the average time commuted, that would be great. And then finally, you mentioned a number of times that you could understand how a judge, a prosecutor, a victim, and a perpetrator could come to an agreement as to what an appropriate sentence is as a compromise. But that it's different when you look back in time. Like you can understand at the moment you were a police officer,
Right.
but then as in your position now as a chair, how long have you been chair?
9 years, I think.
And how long have you been on the board?
10.
So in looking back 20, 30 years, you're looking at I think the words you used was see if the person is suitable to go back into society. I would ask you, that shouldn't be a period, that should be a comma, because it should be when taking into consideration what the perpetrator's crime and the impact on the victim and their families. Because I heard you say, see if it's suitable to go back into society. Someone could perpetrate a horrendous crime. And I'm a somewhat religious person. I try to be better every day.
Story of our lives.
Right. And
Yeah.
some people are born again, and they are different people. And so from a Thursday to a Thursday a year later, they're completely different, and they would be, quote, suitable to go back into society based on their spiritual revival.
Yeah.
But they shouldn't, because they committed an egregious crime and need to serve their sentence that they agreed to in some certain circumstances, or were sentenced to in others. So I hear you when you say the biggest room is a room for improvement. I hear you when you say you look at victims. I will, with all due respect, say I was disappointed in two responses. One, when I asked you for room for improvement, what would you do differently? You, with all due respect, you hemmed and hawed about meeting with, you could have met with the committee chair and ranking. I think that was an easy answer. I tried to give you a softball. The second one was really in taking into consideration victims. And I know you've now kind of assured us that will potentially play a bigger role. But let me just say thank you. That was a very difficult seat you're in.
Thank you.
And I do take you at your word in improvement, and I really do appreciate your time. And thank you, Mr. Chairman.
Thank you, sir.
Further questions or comments from the committee? Further questions or comments? If not, Senator Winfield.
Thank you, Mr. Chair, and I'll be brief. I know we have quite a few people left. Chairman Giles, you and I have gone round and around in the past about some of the things the board has done. I want to tell you that despite that, and despite some of the conversation today, I will be casting a vote in the affirmative for you. I believe that in the conversations you had about what powers you have, that to my mind, you have followed the statutes as they are laid out, and that the General Assembly, should it choose, has the power to change those statutes. And that's a conversation, I think, whether we do or do not do that, we should really engage in and be very thoughtful about. The issue of the spike in commutations, I think, has something to do with the fact that effectively you weren't doing them. And if we had looked at this 5 years from now, if this process hadn't intervened and we looked at this 5 years from now, you wouldn't, over that 5 years, if you average it out, you wouldn't really see a spike. That goes to the conversations you and I have been having for a very long time about what the board is doing. So I think that's important. The one or two things. One, it is not my place to tell you how to function. I will just say that I am available, as I know my co-chair is, for consultation, given that you or your successor at some point will find yourself in front of us. And it may be important to have had that conversation. And then finally, oftentimes when you all come before us, there is a reliance upon an attorney, but not necessarily an understanding of what that reliance means, such that you can be conversant before the committee. I would just suggest that while it may be right to rely upon the attorney to be more capable of having that conversation here, I think it would ease some of the concerns of the committee. Thank you.
Thank you, sir.
Thank you. Chairman Giles, let me just conclude by a couple concluding remarks of my own, following along the line that Senator Winfield just did. And I will say, and this may cut both ways for folks, but obviously we have had an open dialogue with you over the years, and I think I speak for my co-chair as well when we say frankly, we're frustrated by the Board of Pardons and Paroles at times over the last several years. We're not doing enough, frankly, particularly during the pandemic. We thought the board had more power and more authority to grant compassionate medical releases, for example. And we expressed our frustration to you on many occasions about that. And in fact, you pushed back on us and said, well, no, I don't think the statute gives us that authority. And we thought the statute was more permissive than you did. So I do think that is important in the context of this discussion. You know, I certainly read the statutes as giving you the authority to implement the commutation process that you did. And I also know you from my own experience as someone who does look carefully at what his and your board's powers are, because at times I've been frustrated by you not doing enough, frankly, in my estimation, and you blaming that on what you thought was your statutory power. You know, I think the other thing that is has sort of not come up yet today is we have a somewhat unique process here in Connecticut when it comes to pardons and commutations in particular. And frankly, our process is very different than most other states, or frankly, from the federal government, where that power is vested in a single politician who at the end of their term, frankly, can commute the sentence of anybody they feel like, for whatever reason, with zero victim input, with zero input from prosecutors. In fact, we saw that, you know, the last president who left office issued a number of very questionable commutations on his way out of the White House. And nobody was consulted on that. And nobody had to be. And the fact that we have a process here in Connecticut that actually requires an application, that there is victim notification, that there's an opportunity for the state to be heard. And frankly, the fact that you as decision makers end up having to answer back to us and to sit through a hearing like this, to me signifies there is a lot more protection built into the policy that you have adopted than we see in most states, or that we see at the federal government. So given sort of my interactions with you over the last few years, given the fact that I know you do look carefully at what your statutory charge and authority is, and given sort of the way we've set up this process, I see no reason for this committee not to reconfirm you today. I think we could have a debate as a committee as to whether our statutory process needs to be changed, granting commutations. But to take that out on you or on the other members of the board for executing their authority as granted to them by our statutes, I think would not set a good precedence for this legislature. And as a result, I really do hope my colleagues will consider strongly supporting your nomination here today. We thank you for being with us.
Thank you, Representative Stratton.
There's no clapping. Next, we will hear from Joy Chance. Ms. Chance, if you could raise your right hand. Do you solemnly swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Great. You can have a seat, and if you could turn your microphone on, and we'll hear your opening statement whenever you're ready.
Okay. Good day, Senator Winfield, Representative Safstrom, and Senator Kissel, and Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Joy Chance, and it is an honor and privilege to be renominated as a member of the Board of Pardons and Paroles by Governor Ned Lamont. My sincere thanks to this committee for the opportunity to appear before you to speak to my desire to serve on the Board of Pardons and Paroles. Born into an ethnic, diverse family, my formative years were spent in the Caribbean before settling in Connecticut. I have a large extended family, which consists of several siblings who have made and continue to make contributions to society. I am fortunate to have parents who have provided structure and encourage education and the pursuit of excellence. I am the proud parents of two exceptional adult children who continue to strive for the goals they have set forth for themselves. I continue to live my life based on honesty, integrity, and purpose. My education and past work experience have prepared me to serve on the Board of Pardons and Paroles. I earned a Master of Education degree with a minor in psychology from Cambridge College in 2003. Since then, I have worked tirelessly in the areas of social services, primarily with a specialized population. This work experience includes 12.5 years at the Open Heart Association in Hartford, involved in the direct operations of the transitional program and shelter for homeless men and those who have present with mental health and substance abuse issues. The Open Heart Association works in collaboration with Parole and Community Services, Department of Corrections, Office of Adult Probation, and Department of Labor to provide individuals in needs of transitional, educational, and community services. I continued my career as a clinical therapist at the Connection Inc., providing counseling in Middletown, Meriden, and New Haven offices. As a clinical therapist, my responsibilities include counseling, assessment, planning, implementation, and evaluation of client service needs. This is done in collaboration with Parole and Community Services, Office of Adult Probation, Department of Children and Families, Department of Mental Health and Addiction Services, community health centers, domestic violence, and community colleges.
Thank you. Thank you. Ma'am, the bell is rung, so we're going to see if there are any questions for you.
Okay.
Senator Kissel.
Thank you, Chairman Winfield. Ms. Chance, thank you for coming and testifying today. Congratulations on your reappointment. You have nothing to do with commutations, is that correct?
Not the recent one, Senator Kissel.
You did in the past?
In 2016 and 2017.
About how many commutations were reviewed at that time?
I believe, to my recollection, I served on 4 commutations.
And that was during all those years?
Yes.
When did you become aware of the new policy regarding commutations?
When it was sent out to the entire board.
Do you recall when it was sent out to the entire board?
It was effective, the first one was June 21st, 2021. And then there was a revised version, I believe, August or September of 2022.
And why was that policy sent out to members of the Board of Pardons and Paroles that weren't involved in the commutation process?
I believe because eventually all of the board members will become involved in the commutation. And I think, as the chairman stated, when they restarted it again in 2021, they selected 2 people plus the chair to do the commutations, and hopefully once all the kinks are worked out or whatever, later on down other members.
Okay, and just one follow-up. You said they selected the 2 members and the chair, or was it the chair that selected the 2?
I'm sorry, the chair.
Okay, thank you very much. Congratulations.
Thank you.
Thank you. Comment or question from members of the committee? Comment or question, Representative O'Day?
Thank you, Mr. Chair. Just briefly, thank you very much for your service, Ms. Chance, and to the state, and for being here today. You heard some questioning about the hearing a voice for victims. What experience as a social worker, I believe you said that in Open Heart, you dealt with some social services in a specialized population. When you said specialized population, what specialized population are you referring to?
At the time, it was homeless men and individuals who presented with mental health and substance abuse issues.
Thank you. And it sounds to me like when you were on the commutation committee or group, you spent a lot of time in looking at it from the victim standpoint. Is that fair to say?
Absolutely.
Thank you very much for your time here and for your service to the state of Connecticut. Thank you. Thank you, Mr. Chair.
Thank you, Representative O'Day. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you very much for joining us and thank you for your service. Have a great day.
I'm all set. Thank you.
You are set. Maybe I should say that. Sorry.
Unless you'd like to stay longer.
Definitely not.
Don't avail yourself of that.
We can make it happen.
Next we'll hear from Stephen Dargan of West Haven. All right, welcome back. You raise your right hand. Do you swear or affirm, as the case may be, that the information you will provide to this committee will be the truth, the whole truth, and nothing but the truth? So help you God on the penalty of perjury. Thank you. Be seated. If you remember, push the red button. There you go.
Okay, well, I'll be a little different than my past two former colleagues, and going with Senator Winfield, I will be brief, but let me first start off by saying Senator Winfield, Representative, my good buddy Statcham from Bridgeport, Senator Kissel, Representative Fishbein, my good buddy O'Day, Representative Potter. Sorry, I would introduce myself to you. I didn't serve with you, but I served with these other fine individuals. So, well, Kirsten's not here, my former clerk of public safety that you have over here now. So for 40 years, you know, I was a baseball official and basketball official, and they usually said, "You stink." For 40 years, I've been in some capacity as an elected official, 26 years up here with some of my former colleagues, and they usually said, "You still stink." So for the past 6 years, I've been at the Board of Pardons and Parole, and I still stink. And there's not people knocking on the doors to get on the Board of Pardons and Parole. I could tell you that right now. But listen, I heard the big issue is the issue of commutations, right? But people I serve with behind me are some of the hardest working state employees you ever meet. They probably read files all weekend because we knew we had to be here today. So I understand the complexities of the criminal justice system. You know, when I was chair of public safety, I said the best way to figure out an issue was in a collaborative form. ACLU, who's here, the NAACP, law enforcement. And you know what? We really got things done. So if there is a difference, we need to look at better ways to improve the criminal justice system, because it should be all about fairness, right? We talked about victims. It's so important to us. But a lot of times when somebody gets a 10-year sentence in a plea bargain that's pleaded out, suspended after 5, and it's a 50% case, they're up before us in 2.5 years. But that's not explained at the front end either. And then we have to deal with that issue. So let me just say in closing, there was an article yesterday in the New Haven Register that was interesting. And it was from the Connecticut magazine. It said, in the 1950s, a series of brutal murders terrorized Connecticut and swung opinion on the death penalty. At that time, Abe Ribicoff was looking to repeal the death penalty.
Mr. Dargan, could you speed it up?
I will, along with the Hartford Courant. And after the brutal murders terrorized Connecticut, they changed their position. So this was an article in yesterday's paper. So as the criminal justice system, we all know it changes, constantly changes. So thank you very much, Senator Winfield, for giving me the additional time. And you do represent my city, so I do wish you the best of luck.
I'm trying to take care of West Haven. Senator Kissel,
Thank you, Chairman Winfield. I feel like saying representative Dargan, but it's great to see you again. Thank you for your service. You minimize how bright and hardworking you are, but we all know you don't stink. I'm guessing that article was about Mad Dog Taborski, but I'm not sure. I didn't read it. But he went around terrorizing the people of state of Connecticut by going into package stores and then causing them to kneel on the floor, and he shot their heads off. And that's part of the reason why for decades, state of Connecticut not only apparently had the death penalty, but closed at 8 o'clock. Yeah, if I was the spouse or son or loved one of those fatalities, I wouldn't want to see someone's sentence commuted. In fact, having toured up in my district, we had the death chamber. We don't have the death penalty anymore. And I actually saw the electric chair where it was explained to me that, hey, Mad Dog Taborski was the last person executed in the electric chair. My question to you is, you said you understand that it's good to bring people around the table. Is it your understanding, though, that from what we gathered from Chairman Giles, no victims advocates and no law enforcement were brought in to discuss the change in commutation policy? Are you aware that anybody was brought in from that side of the spectrum?
I'm not sure. I can't speak to that, but understanding what the concern is here, I think in a collaborative way, it would be important if we want to move forward to change that, to have everybody at the table.
I appreciate that. And one last question. You do have experience above and beyond serving on the Public Safety Committee. Because I remember when you first came before us, you rattled off the various national seminars you attended, and that so you sort of skipped over that in a humorous way. I appreciate it. But can you just give us, for the edification of my constituents, you do have experience when it comes to public safety issues above and beyond your service in the legislature.
So after 9/11, there was, with the Department of Justice and NCSL, I was appointed to go around to look at our infrastructure, our fusion centers, because right after 9/11 or before that, law enforcement did not talk to each other. Local, state, and federal law enforcement didn't share information with each other. So since 9/11, there's been a better collaboration with law enforcement to serve that. And then we did wage assessments, not only on our electricity, on our ports, on a number of numerous things that I saw, along with all our Navy SEALs, our Rangers, everyone before they got deployed overseas. So I was able to see a lot of our infrastructure and some of our finest individuals that serve within our military.
So I'll conclude with this, Steve, Mr. Dargan. I have the utmost respect for you, really a lot of fond memories, and you practice what you preach. When we had issues, I believe it was the one after the terrible tragedy in Newtown, when my community, Enfield, wanted to have armed individuals as security for our schools. And there was some objections. And I remember we gathered around different stakeholders in your office, and you brokered a deal. And what we ended up using was retired law enforcement officers. They had to maintain their qualifications regarding firearms and stay up to speed. And you helped cobble that together. And so I think that you bring good balance to the Board of Pardons and Paroles, a wealth of experience, and it just doesn't hurt being a legislator, because you know as much as anyone that it takes everybody's input to really make policy work effectively. So thank you for your years of service, and I wish you the very best. Thank you, Mr. Chair.
Thank you, Senator.
Thank you. Representative Fishbine, followed by Representative O'Day.
Thank you, Mr. Chairman. I guess it's afternoon. Good afternoon. You know, there's another aspect to the commutations process that I just want to share. We do sentence people differently than we did 40 years ago. I recently, one of the commutation proceedings that I watched, the individual had been sentenced to 60 years. And there was 20 years knocked off the sentence. But one of the concerns by the three members of the panel that dealt with that was that the way the sentence was structured was 60 years, get out. Good luck. Try and figure it out. And the board, the three-member panel recognized that is a recipe for failure. There is no way that anybody could be behind bars for 60 years and then just go figure it out. So what the board put in place in that case and some other cases is a period of 18 months of a halfway house. You know, can you do it? You know, it's scary for these people that just, you know, as I've shared before, I've got a family member was in for over a decade, and it's a totally different world. You know, there was another case where the individual was sentenced to 30 years, and the board recognized the victim in that case, but recognized the system and the sentencing. And they didn't knock 15 years off of that. They knocked it down to 27 and gave him the 18 months, right? Which makes sense. So my flag here is not about the end result so much. It's about process. So I have the utmost faith in the members, Mr. Dargan. I have the utmost faith in what you've done on this board. But I think we got to take a step back on the commutation thing. And, you know, I'm concerned that this shift, this opening of the gate was not apparently shared with the members of the board. As a, you know, a team player, I always try and get all stakeholders together, but this is a small knit group. Why it wasn't talked about amongst the board, you know, is troubling to me. But I do recognize, as you recognize, Mr. Gargan, that we do sentence differently. And we got a lot to talk about up here on various claims regarding this, but I thank you for coming here today.
Representative O'Day, followed by Representative Dillon.
Thank you, Mr. Chair. And thank you very much, Mr. Dargan, for being here and for your service to the state for many years. And with the chair's indulgence, I know we got a lot of people here, but I want to tell a story at how Mr. Dargan has worked in a collaborative way. My first day of session, I didn't know what I was doing. I will admit, I was trying hard, and there was a bill that came out of public safety, but it came before Judiciary, and I had some ideas on how to fix it, but I didn't know what to do. So we were on the floor of the House, and literally went to the whip, and I said, "Listen, this bill came out of Judiciary. It was in Judiciary, but I had some ideas to fix it. I didn't know what to do, and here it is on the floor. What do I do?" And I was told, "Well, it's too late now. We'll do a couple amendments. It'll take a few hours. And when you run for re-election, you can say you tried to fix that bill." And I said, "Well, what if I just go talk to him?" And at the time, Dargan was the ranking member or the chair bringing out the bill. And somebody was arguing about the bill. And so I said, "Well, what if I go up?" And the whip said, no, you're just wasting your time. I said, "Okay, let me ask this way. Will you get mad at me if I go talk to the chair of public safety just to ask him if he'll listen to me?" "No, but you're wasting time." I thought, okay. So I go up to then Representative Dargan, and I start talking really fast, like I am now, because I was real nervous. And I said, "This bill came out of Judiciary," and Representative Dargan goes, "Who are you?" And I said, "Oh, Tom O'Day. I replaced John Hetherington." "Oh, John Hetherington, great guy, bow tie, smart. What do you want?" And I said, "I got some ideas to change this bill." And I went through all three of them, and he goes, "Slow down, slow down, slow down. What's the first one?" And I give it to him. He goes, "Yeah, that's okay. That could be consentable." I didn't know what that meant. "What's your second idea?" I gave it to him. "That could be consent as well." "What's the third one?" I gave it to him. He goes, "I don't really like that one. If you just do the first two, they'll be consentable." I go running back, you know, like a deer running on ice. And I go, "Two of them are consentable. What does that mean?" "What?" The reason for the story is, to my colleagues, this man is all about collaboration. This man is all about trying to do better. This man is a great servant to the state of Connecticut, and I am proud to call him a friend and a colleague, former colleague, and somebody who I hope to work with in improving this system. And the biggest room is the room for improvement, as the good chair said. And I'm looking forward to working with you, Mr. Dargan, on fixing this thing going forward. Thank you very much, Mr. Chair.
Thank you, Representative Day. I know St. Patty's Day passed, but I appreciate those remarks.
Thank you, Representative O'Day. Representative Dillon.
Thank you, Mr. Chair. Congratulations. I feel like I should honor a former colleague of ours by saying Dargan instead of Mr. Dargan. I believe in rehabilitation. And if I recall our first encounter, we had differences about, we had different allies about whether or not women should be included in a particular Irish event. And which became quite contentious in the city of New Haven. Obviously, as an Irish American woman, I believe that women should be admitted. Do you have a position that issue now, Mr. Dargan?
Representative Dillon, I followed your lead after that. Thank you.
Well, I believe, given your past, your fallen past, that you are well suited to this position, and especially good at collaborating and at admitting error when needed. So I want to congratulate you and look forward to, and thank you for your service also.
Thank you, Representative Dillon. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, it is always good to see you.
Thank you, Senator.
Thank you for joining us today. Next, we'll hear from Rufaro B. Page of Naugatuck. Raise your right hand. Do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, and nothing but the truth? So help you God, or under penalty of perjury? You may offer your testimony. Just push the red button. There you go.
Thank you. Good afternoon. I did prepare a statement. However, it's over 6 minutes, so I'm just going to go. I don't want to hear that ding, so okay. So to the respective gentlemen that chair this committee, as well as the representatives here, I appreciate your time. I sat before you all about 8 years ago and received your support unanimously. Thank you very much. Senator Kissel, you had very nice things to say about me as well, because I was a paralegal prior to my serving on the board. And it really has prepared me to do this great work that we all do here. I'm a lifelong resident of Connecticut. I was educated, born, raised, and now I'm raising my very own family here in this great state. So I just really want to touch bases on where I was 8 years ago and where the board is now. When I started originally, we just did discretionary parole hearings, revocations, and rescissions. Since then, we have now 10 different mechanisms for which a person can receive relief. And one of the things that makes me want to continue doing this great work is seeing the system work, right? We are able to do a number of things: grant pardons, early terminations, commutations, which has been a topic here today. But one of the things that really I enjoy serving on is the 1584 panels. Those are the youthful offenders who committed crimes when they were under the age of 18. One case in particular that I would like to talk about is a 14-year-old girl who committed murder when she was 14 years old with a friend. And, you know, she had a lot of adversity against her going forward. I mean, you know, when she did the crime, and she went to York and she was sentenced to 60 years to serve, which meant she wouldn't be out of prison until she was 74. And this young lady, prior to us even enacting this 1584 bill, she worked tirelessly to make sure she gave back to her community, to make sure that the people that are coming into the prison system did not go out the same way. She helped implement the work unit there at York, and she was afforded not too many years ago a hearing under the 1584 Act, and the people that spoke about how much she changed, it was just remarkable to hear and to see that it really, even though she had no opportunity for release, she still did this because she wanted to make a difference, right? And so this lady, when she was granted parole, there was not a dry eye in the room. There just wasn't, because people were proud to see that the system does work. And that's what makes it worth me wanting to continue. You might say I don't want you to go. I'm sorry. But thank you.
3 minutes goes very fast.
It does. And I'm a talker, so.
Senator Kissel.
Thank you very much, Chairman Winfield. Well, thank you for the props, Ms. Page. I appreciate it. The
Thank
fact
you.
that you remember back then. And clearly, I'm happy that we supported you then. You haven't lost your enthusiasm and passion for the job. You know, all of you, and this includes the good chairman. I mean, the debate is on implementation of public policy. And I'm just very a jealous guardian of the rights of this branch of government, the legislature, because I believe that we get elected by our constituents to help effectuate good public policy. And, you know, it's up to us to debate, I think, this commutation policy. And whether one agrees with it or doesn't agree with it, we could pick some other department or some other body in the government and just say, well, what if like 3 people there decided to come up with something, and now all of a sudden I have to have like some crazy Connecticut flag hanging off my car every day, you know, because someone at the DMV decided everybody's got to do that. And, you know, some people might say that's fine, and other people might say that's crazy. That kind of debate should be here. So we'll get to that later. My question to you is, you've talked about the evolution, and certainly there's that evolution. And there's also the fundamental question as to what is punishment. If it's just about rehabilitation, then people can do horrendous things, especially in their youth. And within 5 years, they might be totally changed. But part of what we do is something is so bad that there has to be a punishment. Hey, they could be like an angel, but sorry, there's more time to serve because you took away something from someone, either huge amounts of property, and we tend to be pretty lenient when it comes to property crimes. But if you harm someone or murder someone, we can't reverse that. And so there has to be some sort of consequence. And then we get into the debate with my good chairs and myself, you know, if we increase the penalty, does it deter the behavior? Who knows? My question to you is real direct. We have given you more to do, and this was talked about a little bit when we had Mr. Shea and the Claims Commission. Do you guys have enough resources to do your job? Because taking commutation off the table for now, but with everything else that you're doing, and the fact that I believe it was Mr. Dargan that said you guys were all reading files over the weekend because you can't even afford to give up a day. You know, it's very much labor intensive, and you guys want to do a good job. It's one of those crazy areas of government where no news is good news. As soon as you pick up the paper and somebody does something really bad that was let go, now all of a sudden, you know, it's going to be trouble, and people are going to be second guessing you. So it's tough to be the insurance policy when you're dealing with something that you can predict, but people do crazy things, and that's unfortunate. They wouldn't be here in front of you if they didn't do something wrong along the path. But how about your resources? And we got Senator Winfield here. He serves on appropriations, but now that we have you, it's a good chance for you to find out what's going on.
So since I've been on the board was actually full when I started, and a lot of people retired. And so we are down to, I believe, 8 people. So we are doing a lot of things on the weekends and then early mornings, but I'm so happy that the governor nominated 2 other people to come and serve with us to help divvy out the work. So Honestly, it is very laborious, as you said. However, we want to make sure that we review enough information so that we can make the best decisions that we can for the safety and the trust of the people that we serve. We want to make sure that we're reviewing everything that we possibly can that would say, okay, or we're taking into consideration all the information that we can to make the best decision that we can.
I'm really excited and, I'm not going to blame you since you did have paralegal background for not weighing in on the commutation issue, but that's for us to grapple with here. But thank you so much for your service. And I'm glad that you're on the Board of Pardons and Parole.
Thank you so much.
Chair.
Thank you, Senator Kissel. Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon. Thank you for coming and congratulations on
Thank you
your
so much.
renomination. Watching that story that you told about the young lady at York, she was very fortunate in that she had an aunt and uncle who have a 4-bedroom house and they got a room that's all set up for her because she doesn't have a decent relationship with her biological parents.
Exactly.
Right.
Mhm.
So, that's one of the things that you guys are looking for too. I'll also point out that when we look at the numbers sterile, it doesn't reflect the cases where the state's attorney takes no position on a commutation, which, I did see happen. So certainly at some instances there is an acknowledgement. And I'll tell you, every single video that I watched, I wouldn't have determined differently. I sat there and said, that makes sense every single time. So, it's unfortunate the cross-examination that the chair got on a procedural issue. But I have faith in the membership. So thank you once again and congratulations once again.
Thank you so much.
Thank you, Representative. Representative Vogel.
Thank you, Mr. Chair. Just briefly, thank you very much for your service to the state. I did not spend as much time as the good ranking member going through all the video, and I appreciate his due diligence. So I don't know how that hearing went with that 14-year-old. How long had she served before she was commuted?
She wasn't commuted. It was a 1584. So
Okay.
so what happened was she went for a sentence modification, and then that made her eligible for the 1584 because you have to serve 60% of that sentence. So when she appeared before us, she served 30 years.
Now, when looking at it, based on what I'm hearing from you, is you did also take into account what the victim's perspective was on it. I assume after 30 years, did they opine that she had served
They
sufficient
did not,
time?
no.
So you didn't hear from the victims at all in that scenario?
There were no victims. However, we do outreach to victims who are registered in any kind of serious crime.
And so there was no objection to that?
There was no objection.
Well, thank you very much. And I appreciate your time and your answers.
Thank you.
Good luck. Thank you, Mr. Chair.
Thank you, Representative. Comment or question from members of the committee? Comment or question, Representative Porter.
Thank you, Mr. Chair. Thank you for being here today and congratulations
Thank you.
on your renomination. Thank you for sharing that story as well. I just wanted to ask, and I'm gonna just say overall, overarching, average, what are the sentences that get commuted? And when I say that, I mean, like, is it an average of 20, 30, 40? How many years has a person served? Does it?
I'm not really sure because I haven't served on any of the commutations since the new implementation of the policy. But on the commutations that I served on, I want to say about 20 years was the
Average? All right, thank you for that. And thank you, Mr. Chair.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for
Thank
joining
you.
us. Thank you for your service to the state. Michael Pohl, Manchester. Mr. Pohl, do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, and nothing but the truth? So help you God or under penalty of perjury?
Yes, sir, I do.
You may begin your testimony.
Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Michael Pohl. I'm grateful to Governor Lamont for nominating me for another four-year term as a full-time member of the Board of Pardons and Paroles. Thank you to the entire committee for the privilege of appearing before you today as you consider your recommendation on the confirmation of this nomination. 4 years ago, I appeared before you and shared who I was and what I accomplished in my life that prepared me to be an effective member of the board. Since my last confirmation, I earned a certificate in corrections from Manchester Community College. I've engaged in many hours of training with my fellow board members, including attending a week-long training at the National Institute of Corrections with other new board members from across the country. I've served on countless parole, pardons, commutations, medical and compassionate parole, and parole discharge panels. In preparing for this hearing, I took the time to go back and review my confirmation process from 2019. What was said about my qualifications and the unique perspective that I would bring to the board. I listened to what was said at the committee and on the floor of the House and Senate, and believe that I've met the high expectations that you set. 2 weeks ago on March 5th, I began my 40th year in recovery. As many of you asked in 2019, I have taken the time to try and make a difference in the lives of incarcerated people by openly discussing and encouraging recovery at parole hearings. I helped move the CCAR Corrections Recovery Coach model forward by talking with Director Eric Ellison about the importance of having someone in recovery to connect with in the community as incarcerated people are released and consider how to proceed with their lives. Pardon panels have been fulfilling and an amazing spiritual experience. People with criminal records who have faced discrimination based upon their past, by not being able to obtain truly gainful employment and better housing because of their past criminal records, deserve to be able to move forward with their lives unless there is an important reason for that conviction to remain on the record. To see the faces of these individuals, as we say in effect, on behalf of the people of Connecticut, you are forgiven. The tears of relief, the burden that they have been carrying around is gone. They have a fresh start. I've listened to the discussion in the legislative branch on pardons, and I hear you. In 2019, I assured the committee that I understood as a Board of Pardons and Paroles member that it is vitally important to consider not only the offender, but the impact of offenses on victims and always the safety of the people of Connecticut. When making decisions, I have in every instance sought to make a decision based upon our structured decision-making model.
Thank you, Mr. Pohl.
I thank you for your time and would be happy to answer any questions.
Senator Kissel.
Thank you, Chairman Winfield. Mr. Pohl, thank you for appearing before us. I'm going to be honest right off the bat. I don't know how I'm going to vote. I did tell the good chair, Chairman Giles, I was going to vote no to flag it for the moment. And I'm up in the air on the two other members of the panel that are involved in commutations. But I need to get a little bit to the bottom of this as best I can. First of all, you said 40 years in recovery. I don't know if it's alcohol or drugs or both, but 40 years is huge. So congratulations on that. That's awesome.
Thank you.
Really, really proud of you. First of all, I forgot to ask Chairman Giles, but if an individual comes before the three-person panel for commutation and they go through the formal hearing and they are denied, it's my understanding that they can reapply and be heard 3 years down the road. And part of my concern is if that is the case, what we're putting through the victims and the victims' families having to go through that again 3 years down the road. Am I correct? Is there a 3-year waiting period and then it can all happen again?
So thank you, Senator, for the question. The window is 3 years. I know that at the press conference that you had that it was suggested that it be 5. I think the chairman is going to look at that. And certainly, some of the
some of the commutations that we've denied at pre-screen have just come way too early. You know, somebody who is incarcerated for 10 years, who received a 35-year sentence for murder, there's not even enough time that's transpired to take a look at what's going on there. So to answer your question, just carry it a step further, you know, we're very deliberate in the kinds of cases that we're hearing in commutation.
No, and I agree. That's what's making this a really hard issue for me as far as you folks go. Sometimes, I mean, I've been lucky enough to be blessed by my constituents to serve here for 31 years now. And it's because they have faith in me. And I'm going to be honest, sometimes I bump into, it doesn't matter the governor, it can be Republican, Democrat, but you bump into certain parts of the state bureaucracy, different departments. And some people just have, I think in the Bible, they call it stiff-necked. They're stubborn, they have their own way, they don't want to listen to anything. They're just not cooperative in public service. And that's unfortunate. You guys all strike me as you want to do the best job humanly possible. It's just a huge policy change. You can hear all of us up here. I think if you took a poll of every one of us up here on this committee, we would all have a different perception as to what is crime and punishment. What is our philosophy of punishment? Is it all about rehabilitation? Should there be just, you know, doing some time because of a certain equation with what the crime was, all of that. And I just think that it is so worthy of a debate of the legislature. But okay, so you guys are already talking amongst yourselves about the victims, and that's important.
Senator, if I may, on victims.
Pardon?
If I may, on victims.
Yeah.
Because it's been talked about a lot today, but it hasn't been really talked about from the perspective of sitting in that hearing room.
Shoot,
and I want to tell you that there's nothing that can unbreak a mother's heart who has lost their child to violence, to gun violence. There is nothing that can take that away. A parent even beyond that, you know. So when a victim comes and testifies and gives input at a commutation hearing, it is very much not just heard, but it's felt by each of the three of us that are there and doing these commutation hearings. And to carry this even a step further, when grace is given by a mother who has that broken heart and can take and say, look, you took my child, but I had to come to a place where I could forgive you. I need to take a minute, because that kind of grace is also present in some of these hearings. So when it comes to victims, it's not an easy thing, because we hear that, and not just hear it, but we feel it and we consider it highly when it comes to the commutations and any other parole or pardon panel that we're a part of.
No, and I agree, and I can understand. I study the Bible. I wouldn't say I'm an expert, but you know, the whole concept of grace, I get it. But as much as the victim or the victim's family may want to get that off their chest, or to turn over that weight and be that higher person, that better person, that forgiving person, there are other interests in light of the totality of our society that we as legislators have the prerogative and the responsibility to determine. And we wrangle with those issues here all the time. And it can be something that lands in the lap of consumer protection. It can be something that lands in the lap of the Attorney General, or it can be something that lands in the lap of our judges and our juries. And that's how it has to be. You happen to be at the tail end of the process, the judicial process. And I appreciate, but it just seems to me that we have to weigh in on some of this. So to that extent, when did you become aware of this new policy? First of all, did you have any input in formulating the new policy?
So I did not have input in forming the policy itself, but there is once the policy was created and sent out in, I believe it was May of 21, we had the opportunity to review. And, you know, with every policy, you know, each of our board members is vocal. And we have our enabling statute, we have a cross section of people. So when a new policy or a revision on a policy comes out, the chairman's always willing to hear what we have to say and the impact that we feel that policy will have on the work that we do.
Do you have any insights as to why there was sort of a memo or a directive as to the policy in 2021, and there was a revised version in 2022?
I believe so. I believe that the revision was the cases, that the most severest of cases, the caveat was added at that point, that they would not be eligible for hearing.
So for about a year, there was no caveat regarding those cases.
That seems like a long time.
6 months.
It could be. However, when it comes to the pre-screen process, I don't know that I've ever approved to go forward to a hearing any case that had premeditation involved with it.
No, and I appreciate that. And I asked a bunch of questions of the chair, but because you serve on this panel, and I don't have a huge amount because we have lots of people, but part of my dilemma or my frustration or my concern as a senator is that this appears to be a very fluid policy. That a handful of people, not even a handful, less than 5, are making a policy. Within a year, it can change. Now, granted, it maybe is moving in a direction that I feel more comfortable with, but tomorrow somebody could wake up and that could change in a whole nother direction. And unless there's guardrails, we use guardrails regarding finances. I think on this one, we need guardrails regarding justice. Unless there's guardrails that we all can agree on, whether it's a statute or a regulation, then I don't feel comfortable. And so your testimony here today is that there's latitude. Maybe it moved after 6 months to a year in a direction that I feel a little bit more comfortable with, but that doesn't mean that I'm not going to wake up tomorrow and see that it's moved all the way in another direction. Do you understand? Do you share my concerns?
So I understand what you're saying. However, I think that you're looking at it from a certain direction, and I think we went in a different direction.
Oh, yeah.
It wasn't about, we want to hear these cases. It was about letting people who have the ability to apply know that those cases are cases that wouldn't be heard.
Well, I don't want to get in a debate with you on the policy because this policy was created and it determined who can apply, right? They have to do at least 10 years and then they can apply. My last question is there anything in your gut that says, because you're involved in this pre-screening process, that maybe it shouldn't be you in the formal determinative process because you're looking at these files twice?
So absolutely not. The pardon process that the chairman referred to at pre-screen, we look at cases that are going to come before us for a full hearing, right? When it comes to commutations as well, if we look at just the application and supporting documentation that an incarcerated person would have submitted with it, that gives us the inkling of, do we want to hear this case? Has it risen to the level where a commutation is something that would be possible? Not a decision making, but is it possible? And at that point, at the pre-screen level, is turned over to a parole officer that further develops that case. And, Senator Kelly had the applications at the press conference. That's a bare minimum thing, and there's way more documentation that go with that for us to review to bring forward at a pre-screen. And then to look at all of the evidence that was gathered and additional information that was submitted, and, you know, as well as a number of different things. It's following a case through from beginning to end, right? And, you know, the chairman also said that not every commutation that's been brought forward from a pre-screen was granted. And when we bring forward a case from commutation, it isn't, as Representative Fishbein said, and I appreciate his comments, that we bring every case down to 18 months to put them out. Oftentimes, these sentences reduced based upon merit, based upon what they've done, and a whole change in attitude and outlook, and how much they've helped since they've been incarcerated. So that it makes sense that 18-year-old black and brown boy from the city who got sentenced to 60 years in prison isn't there until they're 78, because they've made the change. They've made the change while they've been incarcerated. They've taken those programs, and not only taken the programs, but became facilitators in those programs that turned around. We had a guy recently who couldn't read or write when he came there, who taught himself how to read and write, got a GED, and then turned around and started tutoring other people who couldn't read and write so they could get a GED. That's not criminal thinking. That's a whole change in a person.
Do you perceive that punishment is solely for rehabilitation?
No.
Okay, so there has
No,
to be some.
I'm gonna let me just go one step further with that. Very rarely do we ever consider bringing a conviction for murder down below 25 years, because there is a piece there. There is a piece there where somebody has to be held accountable for what they did. Rehabilitation is a piece of that. And victim input is a piece of that. And state's attorneys, you know, in several cases now, state's attorneys' input has helped us. And with early, what's happened early on, and where we are now. And state's attorneys in every one of these cases aren't opposed to a commutation. There are some where they are, but not in every case. And there's some cases that they choose not to participate in.
I appreciate your candor. Just one last question through you, Mr.
Sure,
Chair.
sure.
Do you have any philosophical problem with us as a legislature weighing in and saying, we think that the parameters shouldn't be open-ended for you folks just to make up your own rules as you see fit going along? And we're going to create some guardrails on the process. You know, however it shakes out, I may get what I wish for and be very unhappy with the night result, but that we will describe what this new world is going to look like.
Senator, there's 36 senators and 151 state representatives, and every single one of them has a voice here at the Capitol. And this is no different. This is authority and power that you've given us and trusted us with. And that, you know, certainly, I mean, you know, putting a bill forward and having a debate in front of a judiciary committee or any committee on matters that affect the people of the state of Connecticut is incredibly important to how this form of government works.
Okay. Thank you very much. Thank you, Mr. Chair.
Thank you, Senator Kissel. Representative Doucette.
Thank you, Mr. Chair. Thank you, Mike, for being with us. Full disclosure to everyone here, we've known each other for quite a long time in the great town of Manchester. I was not a member of this committee back in 2019, but I watched your testimony then, I can recall. And I think you've only matured, educated yourself as you detailed through training. I think you've showed how hardworking you've been over these last 4 years on the board. So no secret, I will certainly be supporting your nomination today, but I wanted to give you an opportunity to answer a few things. First, if you could By way of your background, remind the committee and those who weren't on the committee 4 years ago. You mentioned that you had been in recovery, but I don't think you mentioned all of the work that you put in and time helping others in recovery. If you could tell the committee about that and what Pathfinders Association of Manchester is.
Thank you, Representative Doucette. In reviewing the 2019 comments on the floor of the House and Senate, I was humbled. You know, I'm sitting here today and I shouldn't be. You know, 40 years ago, somebody helped me move on and process through what I needed to process through, and became a person who has evolved and recovered from alcoholism and addiction. And I've helped countless other people over the last 40 years face what they needed to face to make the changes that they needed to make, to become productive members of society who are givers, you know. And as I see these commutation hearings, I can't help but apply everything out there to them. You know, what we're talking about are people who have stopped doing time and started living their life, stopped making it about me, which is criminal thinking, to helping others. You know, and being a part of an executive director of Pathfinders, you know, which is a non-paying volunteer job that takes some hours, you know, maybe 5 hours a week, something like that. To be there in the community as we receive back people who were incarcerated, you know, and people, quite honestly, from the brink of death, and helping them turn it around. That's what I've, you know, what I've done. And when I take that along with my 8th grade teaching experience, and I put that with Chairman Giles' background as a police officer and a minister, and with Ms. Smith Palmieri's background as a federal probation officer, when we're doing the work that we're doing in commutations, and the rest of the board members, the vision that they bring, the lens that they bring on different other hearings that I serve with them on, you know, it's we come together and do the best we can by everybody involved. And it's a distinct honor and a privilege to be able to do that. And to be able to give a second chance to those that are ready for a second chance. You know, there's some that aren't, but there's many who are. Thank you.
You said you were humbled, and I would say that you are humble, in that, you know, I know that it's many hundreds, perhaps, people that you have helped through the years, through Pathfinders or even just informally. And I think your experience in that regard and towards, you know, rehabilitation generally, I think you have a real understanding that I know back in 2019 and confirming you, thought was extremely valuable and would be valuable to the board. Now, moving on to the policy, it was your testimony again that you did not draft this policy, but rather you have obviously been involved with implementing this policy. Is that correct?
Yes, sir.
Okay. And I mean, your understanding is that policy is sort of the guiding principle in what you're doing on the board, correct?
Yes, sir.
Okay. And I heard some of Chairman Giles' testimony. I had to run to another committee and the back and forth, but and I've learned a lot because, as you know, Mike, I'm not a criminal attorney. I am an attorney, but not a criminal attorney. So I've learned a lot today. I've reviewed the applicable statutes. They are, as was alluded to, there's only a handful of mentions of commutation. The statute delegates broad authority. And it says that the chairperson shall establish a policy in all areas of pardons and paroles, including but not limited to granting pardons, commutations of punishments or releases. So I think it's there. And again, I've learned a lot about this process. So it seems to me that for anyone to think that, you know, you as an individual member of that board is not worthy of reappointment based on the policy and based on the statutory framework that we're working with, I think, you know, it doesn't make sense to me. So again, I don't think that's a criteria to be used in your nomination. So with that, I would ask you, you know, if you could tell us generally your decision-making process. And again, we've alluded already to it. You've spoke to it, your experience with rehabilitation generally, but you know, talk about your decision-making process and your philosophy in general. What is your decision-making process? What is the purpose of the process and you being up there on the Board of Pardons and Paroles?
Thank you, Representative Doucette. When it comes to commutations, we're handled applications at pre-screen, a docket, usually of 40 or less. The most recent docket that came out for pre-screen is only about 18. You know, I take a look at the offense. We have police reports. We have the applicant that actually writes their portion of what they believe, their version of what happened. I take a look at that along with what's there, not to make a decision about guilt or innocence, because that's a job for the court, but to take a look at what are the facts in front of me. In fact, you know, at the pre-screen level, and I really want to say this because it's been out there. There was a press conference a week ago, and I feel for the mother and the sister of a victim that was there. But Carney was number 5 on the docket, and we reviewed that case individually because we don't collect until the hearing. We reviewed the case before the victim input even came in. Now, that man went to that house to allegedly commit suicide. And instead he shot his ex-girlfriend 3 times. That was premeditated. I can't do something with a commutation when you're telling me that you're going there to do one thing and you did something else. And it's like that decision was made before the victims even had input. And then we received 1,000 letters after that, you know. It's just in that way. And you know, we take a look at criminal history. You know, has this person ever had other offenses, and what were they like? You know, were they violent? Did they involve a gun? Did they involve drugs? Did they involve whatever it is? You know, is that, you know, that's something. We take a look at disciplinary history. Most of the people that we see for commutations haven't had a disciplinary report, a ticket, in 10 to 20 years. Have been a part of the solution in the prison, not the problem, for 10 to 20 years. Programs, I had alluded to them before, programs, and not just taking them, becoming facilitators in those programs, including some of the things that they do on the outside. Some of the inmates that are incarcerated people, some of the incarcerated people are even involved in the gun violence programs in the city right now. And I've said at many of those hearings, it's time for you to go home. Because Mayor Bronin and Mayor Elicker and Mayor Ganem, they need you. Because if anybody's going to listen to anything on gun violence, it's going to be from somebody who's been there and served a very long time in prison, and probably in many of these cases took a life. Something's got to happen for this to stop. So some of these people are people who, if commuted, but so when we receive those letters, that's a part of, should we bring this forward? Education, Yale and Wesleyan have done an amazing job. We heard last week, somebody who received their associate's degree from Middlesex Community College, and this year in May is going to graduate with a bachelor's degree in philosophy with an emphasis in social justice, because they're working on their last 3-credit class. The more somebody engages in education, the least likely they are to recidivate. And the change, everyone here is an educated person. We know what happened to our minds when we went to college. That's what's happening with these things. So I look forward to that. And I look at other things, involvement in hospice. The chairman talked about it. When somebody's involved in hospice, I've held 3 people's hands while they died, not incarcerated people, family members. You can't go through that without that changing. The vet dog program that we have is just an amazing program. It allows inmates, incarcerated people, to help a veteran by training a dog that will help them in the community. We had somebody last week that gave mental health support at Garner, the mental health facility, going in and doing things that staff even have a hard time doing. But caring for the needs of people who are so mentally ill that they can't take care of themselves. When somebody has the ability to do that and they're doing it for a long period of time, they're not the same person, So when we're looking at that stuff, and quite often, it's like the substance abuse piece. I want to just this little story to finish up what I'm saying here. Often in a parole hearing, I'll talk about, what you really need to do is go to addiction services and connect with a recovery coach. Because what you want to do is, on the way out, you want to have a coach so that the person you connect with when you get back into the community is somebody in recovery. And in fact, a year ago, I was at CCAR in New Haven, and the topic was, how does your job and your recovery interact? And I shared about what I do in a parole hearing. And a guy three seats down said, yeah, that was me 2 weeks ago. Thanks for telling me to come here. That's the kind of thing. And that's the kind of thing that we need to do, right? It's not just about a judgment. It's not just about, are we coming to suitability? But when we have people on the board that can help with the transition by speaking for a couple of minutes on how to do that, that shows people that we care, and it shows people that we're vested in their outcome. And that's so important to what we're doing. Thank you.
Thank you. Thank you. That's helpful for us, and it's important for us to hear. I have confidence in your ability, given everything you've just outlined and your experience, to make those decisions. And that's why you are again here today before us, not because of the policy or because we're reformulating state statute, but because of your ability to perform the job. And I have every confidence that you are in the right place and should continue to be there. Thank you. Thank you, Mr. Chair.
Thank you, Representative.
Thank you, Representative. Further questions or comments of this nominee?
Just one quick question.
Yes.
I've heard a lot today, and I think you and Senator Kissel touched on this briefly. One of the reasons that our criminal justice system exists is to be a deterrent to others to commit crimes. What impact do you think that a sentence commutation has on that deterrent to others?
Thank you for the question, Representative Howard. So 2 things. One is, I talked about when people can go back into the community and help people come to the understanding of what the outcome is if they continue to do what they're doing. But more importantly is what's happening on the inside. And we've been told about it by a few different incarcerated people who've come up for commutation hearings. And that is that people are inside right now, engaging in education, engaging in programming, engaging in not engaging in disciplinary problems, and trying to see what they can do to better themselves, because they see that there's maybe an opportunity for them to find a way out before they're 78 years old. So the impact really is on the people who come out and get involved with like Ice the Beef. Ice the Beef, which is a community-based program, or other gun violence programs. You know, that's really the piece. In terms of deterrence, I don't know that it'd be like saying when it comes to commutations, you know, if you get a 60-year sentence, you might be able to get it down to 30 years. So if you continue to be involved in that gun violence, maybe you'll only have to spend 30 years in prison. I don't think those two things really go together. I don't think it's a piece where it affects deterrence.
Okay, thank you. I appreciate it. Thank you, Mr. Chairman.
Thank you. Further questions or comments? If not, Representative Porter.
Thank you, Mr. Chair, and thank you for being here today. Congratulations on your renomination. I absolutely feel you deserve it. You certainly have my support. As a matter of fact, everyone that's come before you has my support. I want to go back to a question that I asked your former colleague when she was in that seat, because you do serve with the commutation trio. Can you tell me, on average, what is the sentencing, right? The length of sentences when you are looking at commutation? You did state that, I believe it was murder, you're not looking for less than 25 years. But outside of that, how do you gauge, or what is the determining factor?
So I can tell, thank you, Representative Porter. What I can tell you is this. We've come from a long road when we're dealing with the offense of murder. It used to be that the sentence was 25 to life, indeterminate, and you were eligible for a parole hearing at 25 years. And then it came to that indeterminate sentencing went away, and it came to definite sentencing. And with that definite sentencing, I believe you could earn up to 15 days a month if you were working and you behaved yourself. So that 60-year sentence, if you pled not guilty and went to trial, that 60-year sentence would make its way down to about 30 years. Today, though, with truth in sentencing, we had somebody last week that committed their offense at 18 years and 7 days old. 8 days prior, they would have been eligible for a parole hearing, a 1584 hearing, at 60% of their sentence. But now that 18-year-old with that 60-year sentence would be in prison until they're 78 years old, unless they found some kind of relief. So it's really on a sliding scale, because a lot of what we've seen are cases from the early to mid 90s where good time, they call it good time, where that was earned, but then stopped in mid 90, and it's now, it's day for day what you get. So somebody who was sentenced in the early 90s that is accumulating good time would have less of a commutation, less years commuted than that 18-year-old that was sentenced to 60 years. But when you equate it, the sentences, after commutation, a lot of times look the same.
Thank you for that. And then the last thing that I want to ask you, I'm just curious around outcomes, right? We're talking about people who are getting their sentences commuted. serious concern to the community and folks in the building. Can you tell me, I'm sure, I'm hoping, right, in the 4 years that you've been doing this, that in the sentences that you have commuted, have you kept up with how the individuals are doing? Are they recidivating? Have they committed other crimes? Are they out doing well, contributing to society? And it's really prompted by the question that my good colleague asked around, what's the benefit? Because the first thing that came to me was, if we're talking about someone who has truly, right, been rehabilitated, and part of that is due to the punishment, I have to believe, right? Losing your freedom, losing the opportunity, but you can't argue that.
Right.
But I want to know, down the line, what are they doing? How are they contributing? Have you had any instances where you have regretted giving someone a commutation because of, them committing crimes and having to recidivate?
So thank you, Representative Porter. Every single one of the commutations that I voted for, I absolutely believe that I did the right thing by everyone involved. I don't know of a case where anybody has recidivated with any kind of violent crime or anything like that. I don't know of any others. I know, that, and that's an important thing to think about. And one of the other important things to think about here, with most of these cases being murder, one of the lowest recidivism rates is somebody who's committed murder and spent a number of years in prison. So I wouldn't expect that we would see recidivism. Is it totally, is it possible? Yes, anything is possible, but is it probable? Not according to state and national statistics.
Thank you. And that was actually a point that was made by someone that served on this committee conversation I had a couple of hours ago. He made that point, that they usually don't recidivate, but I thought I would ask the person closest to the issues that we're discussing. And the only other thing that I'll say is that, going from being a tax burden, right, being an incarcerated person, to being someone who's been released and found good grounding and is a productive citizen and now tax contributing, is always a bonus for us, especially where we are right now. So I thank you for your service, and I thank you for taking the time to be before us today. Thank you, Mr.
Thank
Chair.
you, Representative Porter.
You're welcome.
Further questions or comments from the committee? Further questions or comments? If not, Mr. Pohl, it's always good to see you, and I want to thank you for, I think, highlighting two important things in this discussion, at least for me, which is that people change over 40 years, right? And you were a living example of that. And also our laws change over 40 years. And as much as we try to account for gaps of those, when we change criminal procedure and when we change particular sentences, we're not always successful doing that. So what might be the sentence for a crime committed today, if that crime had been committed in 1991, it might have been very different. We've learned a few things, I think. And certainly here in Connecticut, we've been a national leader in showing smart on crime works. And we've seen our crime rate over that period since the 90s fall dramatically compared to a number of so-called tough on crime states. So I think it's important that you put that perspective before us. I think it's important that you have that perspective with you on the board. And congratulate you on your renomination.
Thank you, Representative Stafford.
Next up will be Deborah Smith Palmieri. Ma'am, if you could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Great. If you could have a seat, and whenever you're ready, we'll hear your opening statement.
Senator Winfield, Representative Sastrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. Good afternoon. My name is Deborah Smith Palmieri. It is my honor and privilege to be renominated by Governor Lamont to the Board of Pardons and Paroles. I thank this committee for the opportunity to appear before you and to speak about my commitment to being a member of the Board of Pardons and Paroles, and to the important work it does. I've been a board member since July 2020, initially appointed as a part-time member and renominated to a full-time position in February 2021. I'm a lifelong resident of Connecticut. I was raised in Uncasville, having graduated from St. Bernard's High School and then Southern Connecticut State University in New Haven. I have lived in the greater New Haven area for the last 38 years, currently residing in Guilford with my husband Eduardo Palmieri, where we have raised our 5 children. Many people have asked what qualifies me for this position. My simple answer is, as of this time, I have 33 years of criminal justice experience and law enforcement experience. I was listening to Representative Fishbein earlier, and he alluded to being there on the front end, the middle, and the back. I have been in service on the front end, the middle, and the back. I have worked in the pretrial services unit for the state of Connecticut as a bail commissioner. I have worked in interviewing pretrial for the federal probation office. I worked as a federal probation officer for 28 years. I retired only because of the mandatory retirement age. Within that career, I worked for the federal courts and I wrote pre-sentence reports, making very detailed investigations on offenders, providing specific sentencing recommendations to the federal judges, meeting with the federal judges to discuss why I would recommend such a sentence, providing sentencing guidelines. I also worked as a post-conviction supervision officer. And in that role, I worked in the communities throughout Connecticut. I worked specifically with substance abuse, people who struggled with substance abuse, mental health, and I supervised high-risk offenders in the community. As a probation officer, it was essential to be able to assess risk and needs for the community. It was essential to be able to look at supervision and the level of an appropriate supervision strategy. And more importantly, we looked at protecting the victims in the community. Our activities, other activities and part of my qualifications are trainings and my years of experience. Thank you very much.
Thank you. Questions or comments from Ms. Palmieri? Senator Kissel?
Thank you very much, Chairman Staffstrom. Nice to see you again, Ms. Smith Palmieri. When did you first become aware of the new policy regarding commutations?
Well, as you know, I'm one of the newest board members. I really have only been on there about 2.5 years. And it was probably in 2021 when I became aware of the policy. We had a training on it. I read, of course, that's the first I had learned of it, and then was trained at it.
And were you afforded any opportunities to participate in giving advice regarding it, given your background regarding law enforcement?
No, I was not. I think in fairness, I was still very new to the board.
Okay. And I know it's a matter of public record, but can you tell us what your salary is?
I think it's probably, I don't know.
Nobody knows what they make?
I'd have to go back and look.
Yeah, Ms.
Maybe
Palmieri,
it's
that's okay. If the senator wants the answer to that, he can ask
Yeah.
OFA or legislative management to get him that answer. Thank you.
Thank you.
Yeah, I'm just a little surprised. Having to go shopping, I know how money has to stretch.
Like I
No,
said, Senator, our nonpartisan office, you can certainly request that information.
Thank you.
Chairman Staffstrom, appreciate that. Regarding this policy, had you studied the Board of Pardons and Paroles at any time prior to joining it to consider how often commutations were granted?
I honestly, I had not.
Okay. Was it, did the chair or anybody else on the staff inform you why you were selected to be on this 3-person panel?
Not specifically, I was assigned to one panel with with Chairman Giles and Mr. Pohl. And then as the schedule came out and I was on the panel again, I didn't give it very much thought. I mean, we're assigned as the chair had pointed out, very often there's a few people that are kind of, you see often on the pardons panel, on the 1584 panels. Others do rotate in and out. I hadn't given it much thought. The schedule comes out. I make myself available for the days I'm assigned and for the days that I need to prepare for the work.
Now, how does it work? I know that there's just 3 people on the commutation panel and they stay the same, but do you do other things as well?
Sure. I sit on pardon panels, parole panels, revocation panels. I've sat on 1584 panels.
So on the commutations, which seems to be the bone of contention, at least from my perspective, does that sort of get sprinkled in every month, or is it certain times of the year it ebbs and flows? How does that actually work?
I think it depends on how, if you've watched any of them, you know that to hear 5 cases takes the entire day. I ask a lot of questions. And so if we do a pre-screen and approve 20 cases out of 80, or it's, I think they need to be heard within over the next 2 months. There are 3 months. It takes the parole officer time to meet with the individual, prepare a report, gather the rest of the documents. And then depending on how many they have, depends on how many individuals, depends on how many hearings are scheduled a month.
So given the amount of time each hearing takes, it would be fair to say you couldn't do them all at once, and especially if there's a large number of applicants. So
oh no.
Let me give you an example. We, as the legislature, we have a long session January to June, and then we have a shorter session February to May. And we have other obligations and duties in the off period, but it's not really off. We're always doing something. Is there sort of like a season, like maybe there's a notice that goes out to the inmates, or just as sort of like catch as catch can, maybe a lot of applications 1 month and the next month they drop off for whatever reason?
I don't think that there's any time off for a particular type of hearing. I think I can't speak specifically to the scheduling, but they're scheduled according to how many are brought forward for a full hearing. And I think Mr. Pohl might have mentioned that we've had a pre-screen hearing canceled because there were none or weren't enough to review perhaps. And then our next, the next pre-screen panel, there's I think 18 where typically we've had as many as 40 at a time to review. So I do think the numbers are reducing, which will reduce the number of full hearings going forward. Does that answer your question?
Yes,
Okay.
and I appreciate it. If we asked the Board of Pardons and Paroles to, on their own cooperation, to stop the process of commutations until we weigh in as far as public policy goes, let's say for a month, would that really jam up the system and cause a hardship, or you don't have an opinion, or you don't know?
It's not that I don't have an opinion, but I don't think that that's part of my responsibilities.
That would fall to the chair?
That would fall to the chair.
Okay. And have you seen, since you've worked on the commutations, an increase in the numbers of applicants month to month or year to year?
Well, I go back to that. I became a full-time board member in 2021. And, I think that's around the time the policy had just come out. So I think anytime you start something new, there is an influx of business, if you want to call it that, or applications. I do think it seems to me that it's slowing down a bit.
Okay. And is it correct, and I believe the previous individual, Mr. Cole, said that if in a formal hearing, it's denied the commutation, that the applicant can reapply in 3 years? Is that your understanding?
That is my understanding. However, it is also my understanding that to reapply, there need to be a change in circumstances.
What would a change of circumstances be for an incarcerated individual?
That's a very good question, because we have not had any reapplications to date. But my understanding is that, it's not just simply more programs completed, or there really needs to be a change in circumstances, something that is very different from the first time that the application was looked at.
So if a victim felt concerned, do they get notice upon the application or just on the formal hearing?
I believe that was answered earlier, and it is on the application.
Right. So even though it may be denied, if the term is 3 years, wouldn't a victim get notice 3 years hence if the person was denied?
I think they would get noticed if notice again if the applicant applied again.
Could that be agonizing for victim or victim's family?
I would certainly think so.
Yes.
Mhm.
Thank you, Mr. Chair. That's all the questions I have.
Further questions or comments? Representative Fishbein, followed by Representative Day.
Thank you, Mr. Chairman. I looked up, there's a website where you can get information about salaries. And I wasn't gonna go down this road, but Senator Kissel opened the door, and but I'm seeing that the salaries for members of the Board of Pardons and Paroles, just regular members, with total compensation is about $175,000 a year. Is that
That's not what I'm making.
okay?
No.
So what are you compensated by the state?
Representative, she already answered this question. She doesn't know the answer to that. It also is not relevant to whether she's qualified for this job or not. That salary is set by the legislature. If you have questions about her salary, if other members of this committee have questions about the salary, please direct them to the Office of Fiscal Analysis.
Okay.
Please
well,
ask another question.
That wasn't the answer that was gotten when somebody else of this committee asked the question. There was certainly no flag thrown at that point. So
there was. I just threw the flag at Senator Kissel
because they didn't know the answer. So now
she still
the
doesn't know the
question
answer.
is, what are they compensated? So you're throwing the flag on that one too?
She said
I mean,
she
I would
doesn't.
expect there's salary, there's travel, there's probably incidental.
My question,
I don't know.
wait, whoa. Everybody hold off, okay? We're not gonna have this back and forth between members of the public. Committee's gonna stand in recess for a minute, please.
Wish we would. You kidding me?
The committee will come back to order. Representative Fishbein, do you have any further questions of this witness?
Yes, I'm sure we'll figure out the answer to the question at some point in the future, but you had mentioned that you were trained on this new practice. Who trained you?
That would be Executive Director
Sirocco?
Sparaco.
Okay,
You know, our legal representative sits in on that,
okay.
the chairman.
And was there some sort of meeting to talk? Was that a group training?
Yes, it was. It was with all the members of the board. It may have been done over Teams then. We were still not in the office for in-person trainings.
Okay. And do you know where the idea for coming up with this new procedure came from?
I do not.
Okay. Well, I just want to point out that there is a regulation that requires that if anybody comes to the Board of Pardons and Paroles to have an amendment in their regulations, that they're required to go through the process. So, you know, we're going back and forth on this issue of what a policy and what a regulation is here today on various planes. But it's clear that through the regulation process, the legislature said you got to go through regs. So, but I thank you for coming here, and I think you're doing a great job. And
Thank you.
congratulations on your renomination.
Thank you.
Are there further questions, Representative O'Day?
Thank you, Mr. Chair. Real quick. Thank you very much for your testimony. And I'm sorry, just by way of background, before being on the board, did you have any interaction with victims of crimes in any of your past careers?
Oh, of course.
In what capacity?
Well, in two capacities. At the very beginning of my career, I worked for the state of Connecticut, and I worked as a bail commissioner. So part of our job was to actually work weekends at the local police departments. And I would be assigned to Union Avenue, the New Haven Police Department. And on the weekends, we would have individuals come in and, you know, if say it was a domestic type case, we would actually pick up the phone and call the victim to talk to them, to see what their position was. As a probation officer, we were, you know, same thing, you know, making sure that the offender we were supervising was either staying away from the victim, staying away from a location, paying restitution to the victims. Very often we get calls from victims asking about restitution or saying that somebody had been used. So I've been very much involved with victims throughout my career.
Thank you. And I've heard nothing but good things. And you literally have been on since 2021. So you don't have a whole lot of institutional experience, and that's not a bad thing. It's you're kind of being asked questions about history, and you don't really have that context. So thank you very much for your service. I will, to answer the good chair's comments, if you just simply go to the comptroller's office for my ranking members, and the board members make between 115 and then the chair about 164, and that's easily accessible of everybody's salary. And the last comment I will make, the good chair had pointed out in our federal system, since 93, the most presidential pardons was Bill Clinton, second Obama, and then the least since 1900 are the Bushes and President Trump. So I just would point that out for the good chair. Thank you very much. And thank you very much for your service and your testimony.
Thank you, Representative O'Day, although I guess we could go through some of the names of the folks that the last president commuted or pardoned, and I think let's leave that be for now. But anyway, further questions or comments? If not, Ms. Palmieri, congratulations on your renomination. You know, I will say it is good to see you back before us. I don't know if I said this publicly, but I remember thinking 2.5 years ago, you're someone with 33 years of law enforcement experience. you know, is this person really going to have sort of the balance and the empathy necessary for the Board of Pardons and Paroles? And so the fact that you are here before us as one of 3 people who are being questioned on, did we go too far in that empathy and in that compassion for folks who have been have gotten their life back together, and are what should be an example for others in our system, I think is very commendable. To me, again, it's another indication that I think actually we are striking the right balance.
Yeah.
But so thank you for your work and for being with us today.
Thank you.
Next up will be Nancy Turner. Ma'am, if you might raise your right hand. Do you swear or affirm, as the case may be, that the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. You can have a seat, and whenever you're ready.
Good afternoon, Senator Winfield, Representative Stafstrom, Senator Kissel, Representative Fishbein, and the other distinguished members of the Judiciary Committee. My name is Nancy Turner. It's an honor and a privilege to be nominated by Governor Lamont to the Board of Pardons and Parole, and I thank you for your consideration today. I began state service with an appointment to the board in the fall of 2017. For the last 5 years, I've been serving as a panel member hearing offenders seeking early release to discretionary parole. I've also been part of the revocation process and juvenile reconsideration hearings, as well as pardons hearings. I'd like to extend my thanks to the chair, Chairman Giles, my fellow board members, the parole officers and professional staff at the board for their expertise and collegiality over these many years. By way of introduction, I'd like to share a little bit about myself, my background. I'm a proud UConn graduate, and I returned to my home state in late 2011 after 24 years of studying, teaching, and working in the Washington, D.C. area. While growing up in the Navy, Connecticut was always home. My grandparents settled in Groton Long Point in 1950 after my grandfather concluded his service in the Navy. Then in 1984, when my father retired after 30 years in the Navy, he and my mother moved into our family home, and I am now the 3rd generation enjoying the house and property, feeling very grateful for my grandparents' wisdom. To support the mission of the Board of Pardons and Parole, I want you to know that I bring over 30 years of experience in a variety of capacities in the criminal justice and public policy fields. Since returning to Connecticut, I had the honor of chairing the state's Domestic Violence Fatality Review Committee, and I managed a multi-year federal grant focused on offender reentry and victim safety for the Connecticut Coalition Against Domestic Violence. I also coordinated the efforts to develop state standards for batterer intervention programs through a committee of CJ PACT. These efforts enabled me to collaborate with many dedicated professionals, including those of the Department of Correction, where I was able to learn about facilities, programs, classifications, release mechanisms involved in the incarceration and rehabilitation of individuals who violate the laws of our state. In my work on the board, I'm also drawing on 14 years I spent in the Research Center at the International Association of Chiefs of Police, developing and implementing national standards and delivering training to inform law enforcement's response to an array of violent crimes, including hate crimes, human trafficking, sexual assault, strangulation, stalking, and gun violence. The Board of Pardons and Paroles employs risk assessment and structured decision-making tools to determine whether an offendable is suitable to complete their sentence in the community under intensive supervision while receiving the support they need to lead successful, productive lives. I welcome any questions you have, and thank you for your consideration.
Questions from the committee? Questions from the committee? Seeing none, appreciate being with us. No.
Well, I have to say, when I was here back in 2018.
No.
I appreciated your.
Nice to see you. Nice to see you. Congratulations on your renomination. Jennifer Zaccagnini. I guess I'm still processing. If you
yeah,
could raise your right hand, do you swear or affirm as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. Have a seat when you're ready.
Oh, I was on? Yes. Okay. Good afternoon. I would like to thank Governor Lamont for his nomination and thank all of you for your time here today. My name is Jennifer Medina Zaccanini. I was born and raised in Waterbury to a Cuban immigrant father and a New Yorker mother, and I've lived in Watertown for the past 23 years. I'm the proud mother of 3 children, 2 of whom are students at UConn studying physical therapy and neurobiology, and a third who will join them in the fall to study video production and digital media. For the past
Could you just pull
14
the
years,
mic a little closer? Sorry.
can you hear me now? For the past 14 years, I've had the opportunity to sit on the Connecticut Board of Pardons and Paroles. During this time, I've been fortunate enough to serve under 3 different administrations, with my original appointment being under Governor Rell, followed by Governor Malloy. I've witnessed the evolution and expansion of the board's role and responsibilities within the criminal justice system. I've made release decisions for thousands of Connecticut inmates with the safety of our communities at the forefront of my decision-making process. Since 2016, I have also been part of the pardons process, granting second chances to those individuals who have worked hard and changed their lives in positive, meaningful ways. Eliminating their criminal records helps to break barriers that prevent applicants from furthering their careers and contributing to their families and communities. I hold a bachelor's degree in sociology and a master's degree in criminal justice. My previous career was with the Department of Children and Family. While there, my primary focus was the protection of Connecticut's children. I worked in a treatment unit where I was responsible for providing families with necessary services and programs to maintain the family unit. As an investigative social worker, I was the first to respond to allegations of child abuse and neglect. As a social work supervisor, I supervised social workers in a treatment and training unit. Many of the clients at DCF were involved with the criminal justice system, just as many of the inmates that I see today are involved with DCF. I've been challenged and rewarded by my current position and have enjoyed my time with the board. Look forward to serving the state in this capacity for as long as possible. Any questions? I beat the
Questions? All right, folks, I understand it's been a long day, but I do need to just ask for some decorum in the audience, okay? Questions or comments from the committee? Questions or comments? Seeing none, ma'am, congratulations on your nomination. Navili Brooks. So if you could raise your right hand, do you swear or affirm as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? I do. Great. Have a seat and whenever you're ready.
Good morning, Judiciary Committee Chairs Winfield, Staffstrom, Vice Chairs Flexer, Quinn, Ranking Members Kissel, and Fishbein, and members of the Judiciary. Thank you for the opportunity to appear before this committee. My name is Neville Brooks. It is my honor to be nominated for appointment as a member of the Board of Pardons and Paroles by Governor Ned Lamont. During a career in law enforcement spanning over 30 years, I have demonstrated a passion for doing my part to improve the quality of life for everyone, safeguarding the community by requiring accountability and enforcing the law justly and fairly. As a career law enforcement official, I successfully advanced to become Deputy Police Chief for the City of Hartford. I'm a graduate of several revered leadership programs, including the FBI National Academy in Quantico, Virginia, and the International Association of Chiefs of Police Senior Management Seminar in Boston, Massachusetts. Based on my academic achievements, I'm a member of both the Criminal Justice and the National Catholic College Graduate Honor Societies. I'm an independent thinker, both confident in my decision-making ability and articulate and persuasive in my reasoning. My core values of empathy, honesty, integrity, and fairness are synergistically aligned with my professional values of justice, transparency, and accountability. Throughout my life, I've been blessed with the privilege and responsibility and opportunity and trust to use my skills and successfully lead people during turbulent times. I am confident that my diverse skills and qualifications will make me an asset to the decision-making process of the Board of Pardons and Paroles, and ultimately in a significant impact on the safety and quality of life of the community. I thank you for your time and consideration and look forward, hopefully with favor upon your appointment.
Thank you, sir. Questions to the committee, Senator Kissel.
Thank you very much, Chairman Staffstrom. Congratulations on your nomination. Well, you saw the hearing thus far, and hopefully that hasn't changed your mind about anything. But I'm just interested, were you made aware of this vacancy? And what caused you to have an interest in sort of changing your role as far as law, crime and punishment and justice?
So I was approached about, position being available, and what changed my view is, back when President Obama and 21st Century Policing came out, they talked about, us transitioning and policing from a warrior to a guardian mentality. At the time, I was kind of a little bit, apprehensive about it because I believe you have to be a warrior in a sense to be a guardian. But now with my growth and my age, I'm getting older, I'm kind of, embracing the responsibility of being more of a guardian and helping, people. I tell people I don't have any children of my own, but for some reason people keep naming me as godfather. So, I got an investment in being in the quality of life of the kids coming up and the community around me. So I want to do my part to try and help out and just make sure everybody's safe and enjoying their life. Both, offenders and victims, I believe, have, need an opportunity to, enjoy quality of life and be held accountable as well for action. So.
And I just can't help throwing this one at you, but if you feel uncomfortable because you haven't been involved, but, as someone that's been involved in law enforcement, especially in our capital city, where sadly, like so many other areas, it's not necessarily clearly the only place where there's homicides, gun violence, but predominantly in our urban areas. And we're still wrestling with how do we get our arms around that issue. And, if someone gets shot and God forbid killed, there's not just the victim of the crime, but the family, the friends, everybody could have children. And so there's a lot of wreckage from that one instantaneous action. And from what I read, some of it's premeditated, but some of it just seems to be like spur of the moment. Maybe it's vendetta, who knows? So hearing the testimony regarding the commutation situation and being involved in law enforcement, do you have any opinions on the current policy, or you're not familiar enough to sort of offer your ideas? I'm just wondering.
Yeah, again, I believe on, training, so without having the training in this, I don't know if I'm, qualified to make an opinion on that right now. I mean, given more information about it, it's brand new to me. Maybe I could be able to, come back with a better answer for you, but I don't really feel qualified to do that at this time.
No, I'd rather have you be honest than try to make something up that, perceive that we might want to hear. I think you're an excellent candidate, and I'm happy somebody suggested that you make the application. Personally, I don't think that we have enough folks from up our neck of the woods. Everything seems to be south of Hartford. And so we get a little more. We had a nice woman from Bloomfield. But yeah, given your law enforcement background, and you said that you're an independent thinker, and Catholic colleges, in fact, I mean, I don't know what brought you up to Boston, but I bet you're happier back here in Connecticut. But I'm just biased that way. So congratulations. Thank you. Chair.
Further questions or comments from the committee? Further questions or comments? If not, sir, thank you for your service to the state so far. Congratulations on your nomination. We look forward to your continued service to the state.
Thank you very much. Thank you.
Sergio Rodriguez. Sir, if you might raise your right hand for me, do you swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do, absolutely.
Great. Have a seat whenever you're ready.
Oh, good afternoon. Honorable Chairs Winfield, Strastrom, Honorable Vice Chairs Flexer and Quinn, Ranking Members Kissel and Fishbein, and Honorable Members of the Judiciary Committee. Thank you for this opportunity to appear before you today for your advice and consent of my appointment by Governor Lamont to the Connecticut Board of Pardons and Parole. I'm so excited and humbled by this appointment and the governor's confidence in my capacity to serve on the board. For those members who do not know me, my name is Sergio Rodriguez, and I resided in New Haven with my wife, Randy Ruben Rodriguez, who is here with me today supporting me, and our children since 1993. Born in Tampa, Florida, I relocated north to New Jersey at the age of 21 and began my professional career in pretrial intervention, one of the first court diversion programs in the nation. I moved to Connecticut in 1993 and became intricately involved in the community, neighborhoods, substance abuse treatment agencies, and city government as an employee. By 1996, my wife and I turned our attentions to the needs of children in the child welfare system, impacted by substance abuse, family violence, and mental health issues. We became Connecticut licensed foster parents, caring for some 40+ children impacted by trauma and separation, and we've been blessed to have adopted 2. We founded the Our Kids Family Center in New Haven, serving more than 7,500 children and their families to date. I believe my lived experiences and professional expertise, interacting, managing, overseeing direct services for and with many men and women who have been ex-offenders, substance abusers, incarcerated parents looking to reunify with their children, as well as many in our communities who have been victims, hurt by violence and substance abuse, have enhanced my capacity and skills to listen attentively, review objectively, hear all sides in assessing and recommending the possibility of a pardon, sentence reduction, commutation, or denial of a petition before the board. I support second chance and believe individuals can put their lives together, especially with hard work on their part, when the important and necessary supports and safety nets are put into place with them within their communities. I've seen the successes through my work in over 45 years of work in the human services profession. It is my ongoing commitment to public service and my passion to make our community safe, vibrant, and livable that has brought me to this moment. I firmly believe that my experience and background will be an asset to the work of the Board of Pardons and Parole. I also appreciate each of your commitments and your legislative positions on behalf of your constituents and residents of our state, and Governor Lamont for providing me with this opportunity to come before you today. Thank you so much, and I welcome your questions.
Questions from the committee, Senator Kissel.
Thank you, Chairman Stapstrom. Congratulations, Mr. Rodriguez. And as I had asked the previous new candidate, what caused this sort of career shift, and why are you excited about joining the Board of Pardons and Parole?
Oh, well, I heard about, to be honest, I heard about the Board of Pardons and Parole about 2 years ago, and at a meeting with, at that point in time, I think it was Paul Mounds, who had attended this meeting, and he shared that there were 2 openings or a couple of openings then. And it was at that point that I had really decided to apply. I applied 2 years ago. And then, of course, COVID happened. And during the process of the background check, all of the appointment had stopped at that point. And then more recently, I was still interested, and again, at another meeting somewhere where I'd heard there may be a couple of openings, and had shared my interest in wanting to be a part of the board. I've been in public service for many years as a local legislator, and I've always had a commitment to wanting to work with the community and working with those who've been most vulnerable and most disadvantaged. So it just kind of fit with my mission in life, basically. And that's, so when I found out it was open again, I had asked about the possibility of reapplying.
Great, and I know that you're going to be trained, and Chairman Giles takes great pride, as he should, in the training and making sure you guys have as much information as possible and stay on the cutting edge. I mean, in many respects, Connecticut is a leader nationally in so many aspects of criminal justice. And I've often stated that I think our judges in particular are the best in the country. That being said,
Senator, I'm looking forward to working with this dedicated group of folks.
well, you got to get
watched the
past
hearings.
us first.
I've
but I
watched the
think
hearings.
You're going to be good. But I guess my big question is, in your testimony, you opened up and it seemed to be somewhat weighted towards second chance society and rehabilitation, which is hugely important. But is there anything out there that when you pick up a file that might cause you to have concern that there's something here jumping out at me, especially having so many years experience with children and a vulnerable population?
Well, my concerns really would be centered around community supports, family supports, and opportunities that would be available to individuals, especially, in the issue of pardon and parole. But in any, group that I work with, or any family I work with, or individual that I work with, for me, it's always important, is there community support? Are there available resources for this person to be able to do well and be productive on the outside? So I would have a view of, looking at what's out there to be supportive for individuals.
That's mostly our responsibility and less so the applicant, but that's okay. Congratulations, and I wish you the very best. Thank you.
Thank
Mr.
you so
Chairman.
much.
Further questions or comments from the committee? Representative Porter?
Thank you, Mr. Chair, and good to see you.
Good to see you.
I told you earlier, I was excited to see you on this list. And I'm very excited to have you before us. I believe that you're going to make a wonderful addition to this board, for all the great work that you and Randy both have done in community and continue to do in community. I know that you will have the community's best interests at heart, and that, these decisions won't be made lightly. So I just wanted to say congratulations, and I'm looking forward to doing some work with you.
Thank you. Thank you, Representative.
Thank you,
so
Mr.
much.
Chair.
Representative Dillon.
Good afternoon, Mr. Rodriguez. It's really good to see you, and congratulations on your appointment. And congratulations to your family as well. I know that as a team, you've really been committed to the community. We really go back to your days, I think, with Operation Fight Back,
Fight
when you
back,
were trying
fighting back,
to
correct.
work with young people to stop using drugs. And I think there are a couple of pictures from those days.
Mhm.
I really admired the path that you've chosen in terms of the dedication to the community. And I wish you well, and congratulations.
Thank you very much, Representative.
Thank you, Representative Dillon. Senator Winfield.
Yeah, I mean, the New Haven train is here, right? So, and there are more who just aren't here right now. But no, seriously, I just want to congratulate you on your nomination, and we talked quite a bit leading up to this, so I know how important it is to you. And having heard all that is here today, I'm sure, given the work that you put in to be here, you will do a phenomenal job. So I just wanted to throw in my additional congratulations from the New Haven delegation. Thank you.
Thank you. Thank you, Senator.
Further questions or comments? If not, congratulations. on your
Thank you so
nomination.
much.
All right, that concludes our list of nominees. We do have a few members of the public who are signed up to testify, so we will turn to those now. Norman Gaines. Right up front to the microphone, sir. Oh, I don't have to swear you in. You're not under oath. Yeah, no, you're good.
I'm not gonna lie to you anyways.
All right, good.
Okay, so I'm unaware of how much time I have, so it could be.
You got, yeah, so let me go through that. If folks haven't testified before this committee, they have 3 minutes, so the bell will ring after 3 minutes.
Okay.
So we'll ask you to keep your remarks to that.
Okay. So members of the board, for those of you who do not know, my name is Norman Gaines Jr. I am one of the people who was given a commutation. And for the cases that are extraordinary, I think I fit the bill. I was one of 5 juvenile in the entire state of Connecticut who at one time was serving life without the possibility of release. Then after I received some relief when they found that my 6th Amendment rights to effective assistance counsel was violated, and I was awarded a new trial. When we speak of sentences and plea bargains, sometimes we don't take into consideration how much time some of us have served while trying to clear our names. During my 2nd trial, I already served approximately 16 years. And my family and I have been traumatized with some of this stuff that was going on with the legal system. So instead of going forward with another trial, we pled under the Alford Doctrine, which serves as a guilty plea without admitting guilt, to an effective sentence of 30 years. After the 30 years, After I was sentenced for 30 years, my body of work had to continue while I was incarcerated. I am, when Senator Kissel was speaking about Asnuntuck, I am an honor student at Asnuntuck Community College. Right now, I'm 44% completion of my associate's degree for human services, and my GPA is a 4.0. When we're talking about what I've done within 6 months of my release, I have acquired 3 positions, none of which I've been fired. I was first a selector at FHI, then I moved from that position to become a clerk, which further enhances my computer skills, and I work towards being the program coordinator at the Second Chance Reentry Initiative program. So when I was talking to the panel of the Board of Pardons of Parole, that I would do my best to be a beacon of the community, I would like them to know that I've been keeping my word. So moving forward, and I'm just one of many, because we keep in touch for those of us who have served time and have come home on commutations, we are all doing well. We keep in touch and we make sure we move forward so that when these hearings come up, the public understands that they're in good hands and these people made the right choice. So sometimes the system, when we're talking about policies, right? The policy was, in my case, when you look forward, if you want to look and question your body even further, the policy in my case was told that even if I proved I was innocent, I was entitled to relief. This was by prosecutor Joanne Sulik, put on record to a federal court judge. That's outrageous. For a person supposed to be a public's, to represent the public in such a way, not just to prosecute, but to protect us. So with that, if you have any questions, if not,
Questions from the committee? Senator Winfield?
I don't have a question, but I just want to say thank you for showing up and testifying, not on a particular person, but on what this is that they do. I think it's important context as we think about the votes that we have before us. And certainly I'm happy that you have the outcome that you have. So I just want to thank you because I think it's important. Thank you.
You're welcome. Further questions or comments, Senator Kissel?
Yeah, if you're going to Stuntuck, are you one of my constituents?
I'm not sure.
Well, the fact that you're even visiting my district, thank you very much. I appreciate your testimony. So you get props just for coming up to North Central Connecticut.
Look, I will, I tried to re-enroll again. So since I've been out for Senator Kissel, can you understand? The issues with halfway houses, right, was having a discussion between time for studies and time for work and time within programming for myself, because I've also go to programs before I had to enlist, because while I was incarcerated, we don't get the chance to seek a lot of mental health treatment. So I had to get that when I came out, and I sought that myself. After serving 25 and a half years, to say that I didn't suffer any trauma, especially since I've been incarcerated as a 17-year-old kid, would be outrageous. To say I'm okay, right? Just I don't need any treatment. So we've done that. I've never taken a semester off while I was incarcerated other than during the COVID pandemic. Since then, I had to take 3 semesters off, but within the summer, and I've collaborated with the liaison from the DOC to further my education. So I will be attending Asnuntuck and pursuing my degree within the summertime.
I appreciate that insight. And that's like why the new nominee, Mr. Rodriguez, said the support services are so critical too. It's not just letting you out of corrections. It's making sure that you can be successful as you reintegrate into law-abiding society. So thank you for coming.
You're welcome. Representative Porter?
Thank you, Mr. Chair. And Mr. Gaines, I just want to say how good it is to see you sitting before me. We've had an opportunity to talk and get to know one another, and I do appreciate you coming down to actually validate the good things that can happen when this is done correctly. And I'm happy that you are now a tax contributor as opposed to a tax burden. And I don't mean that lightly. I mean that sincerely.
You're welcome.
Thank you, Mr. Chair.
Thank you. And sir, let me just echo my colleagues and thank you for sticking with us and sharing your story with us. I think it's critically important. So if I understand, you served 25 and a half of a 30-year sentence before your commutation. You know, and I just, again, it, not to beat a dead horse here, but it just, it seems to me like these are exactly the reasons why drawing a bright line and saying we should have some policy that says you can't seek commutations, you know, just doesn't work. These are fact specific cases. These cases, it's the reason we have a board to look at these on an individualized basis. And I appreciate you being here to put a face to that today. So thank you.
Mr. Stastrom, there was one thing that, because you brought it up about the case by case basis. If it wasn't for these commutations, I wouldn't be here today, and a lot of others, right? A lot of the times when we're talking about the policies and things that we're doing in the community, we're so connected to the community that a lot of the change happens because of us. So a lot of the violence, and I've spoken to Mayor Ronan very briefly at a event where I was working for when I was at Open Heart. We are so connected with the community that a lot of the young youth who are, because I was one of the youth, will listen and understand that violence is not the answer. And I wouldn't have had that opportunity to speak to them and hopefully save whatever lives that could have, that wouldn't have been saved if I didn't get the chance to speak to these individuals today. You know, postponing that 4 years from now, we don't even understand how many lives we probably would have lost. And I'm not saying I'm any saving grace, but I do thank you and I appreciate the opportunity that I've been given and the privilege that I've been given, and I'll do everything in my power to exercise my right to bring positive change to the future.
Amen.
Thank you.
Andrew, or Liernick? Andrew,
Yes, yes, I'm here.
go ahead, sir.
Yeah, I would like to make a statement. My statement is I object to any further prison sentence commutations until you, the committee, review policy 111.02. Hopefully that's correct. And is reviewed and voted on by the entire Judiciary Committee. I have to tell you, after listening to this all day, I am really concerned on how even you members of the Judiciary Committee were not informed and are still not, and just finding this out today. So I will relinquish my time so you can get to the other folks, and thank you very much.
Thank you, sir. We appreciate you coming before us. Senator Looney? Senator Looney with us. Gina Giammatteo?
I had good morning in my speech, so I'm going to change it to good afternoon. My name is Jenna Griffith Giammatteo, and I am a Connecticut resident and was a dear friend of Elizabeth Carlson, who was murdered nearly 21 years ago by her ex-boyfriend in her parents' Newington, Connecticut residence. You may have heard her story on the local and national news lately, and I know that she was talked about today. I stand here today to plead with you to stop allowing murderers to be eligible for commutations. Elizabeth's murderer was sentenced to 42 years in prison under a plea bargain agreement. The terms of the agreement did not allow parole or early release. The victim's family was told by the authorities that the plea bargain agreement was ironclad. The family and friends of victims are outraged that a group of individuals nominated by the governor have the authority to potentially overrule sentences of murderers and release them early from prison. Elizabeth's family started serving their life sentence the day Elizabeth was taken away from them, and now every 3 years they must relive this horrific day, praying their daughter's killer is not set free. This is absurd, and I'm asking the Judiciary Committee to not reappoint these Board of Pardon and Parole members until the commutation policy has been revised. There needs to be clearer policies and laws that forbid criminals convicted of violent crimes, including but not limited to murder, from applying for commutation. Governor Lamont stated that Connecticut is one of the safest states in the nation. Allowing these dangerous criminals to apply for early release from prison jeopardizes our safety and betrays the victims' families. Commutation for violent criminals must be eliminated permanently and addressed now. Thank you for your consideration.
Thank you. Questions or comments from the committee? Questions or comments? If not, thanks for being with us. Janet Shapiro Weiss. Janet Shapiro Weiss. Stephen Weir. Stephen Weir. Heather Summers. Heather Summers. Liz Donahue. Liz Donahue with us online? No. Neil O'Brien.
Yes.
Go ahead, sir.
My name is Neil O'Brien. I'm a resident of Norwich Taffville. I was attacked in 2020 by a violent offender with 6 prior convictions of assault. He got a plea deal of 1 year, which I had no say in. I am still suffering from a second brain injury because of him. And I just got a notification last Monday. He's applying for early release. This can't happen because my nightmares have started again of him attacking me for being a former first responder and just going to help his father who's having a possible heart attack. This can't happen. Violent offenders cannot be released. Thank you for your time.
Thank you, sir. Questions or comments from the committee? If not, we appreciate being with us. Kelly Memphis. Kelly Memphis. Allegra Weir.
Hi there.
Go
I
ahead.
want to, oh, I am here. I want to thank the chairs and the other members of the committee for their service and the opportunity to speak here today. My name is Allegra Serb Weir, and I'm here to share with you my personal story in regards to the Board of Pardons, specifically with these involved in the commutations. People go through life thinking truly bad and heinous things only happen to other people, and I'm here to speak for those victims who cannot speak for themselves, like my beautiful mother, Susanna. She, at 48 years old, was murdered when I was a 17-year-old senior in high school. She was stolen from me only 9 weeks after my father passed away from Lou Gehrig's disease. Her murderer left me and my 4 brothers orphaned. Back in 1995, her murderer went to pretrial, where it was explained to him that the state had enough evidence to convict him of my mother's murder. He accepted a plea bargain, the Alford Doctrine, to agree to a 45-year sentence without the possibility of parole, where he has never had to admit that he killed her or why. I believe the reappointment of this board, specifically those involved in the commutations, should be halted until there are some procedural changes. To learn earlier when Senator Kissel was asked and received the information that it is just a panel of 3 who oversee and listen to the application for commutation makes me lose a little respect for the process as it was explained. How can only 3 people, who are the same 3 people, be at both tiers of commutation, both the initial hearing and then again at the full hearing? The committee members need to take a hard look at their position on who they are releasing back into society, and they need to hear from the actual victims and the victims' families. During the last 2 years since this policy or process that allows convicted criminals of all levels to apply for commutation, I personally have received 2 letters stating that my mother's murderer has requested to have his sentence reduced. This is very disturbing to me and my brothers. I actually had to reach out to the state of Connecticut, which is hard to get a hold of somebody sometimes at the victim services, to question the letters that I received. I was told that he was not eligible, but why I had to receive a letter, 2 letters, was very upsetting. So why should a man who killed a mother of 5 in cold blood who did not know her even, he did not know my mom, be allowed to even request commutation? Do you realize that this paper notification alone rips open a wound that the victims of these criminals' crimes of murder, rape, assault, they have to revisit that life-altering, painful time like it was yesterday, which in turn re-victimizes the victims all over again. Your policy of who can apply needs to be much stricter so that people like me do not have to receive a letter or multiple letters in the mail. Oh, sorry.
Thank you, ma'am.
I have a few more, sorry.
Ma'am, I just,
So my mother's murderer actually signed a deal, which somebody had mentioned was a contract for 45 years without the possibility of parole. So we were under the impression that that's what that meant. He shouldn't even have been allowed to apply to force us to relive that most painful, difficult day of our lives. So I want you guys to take that into consideration.
we appreciate your testimony. Thank you for sticking with us. Thank you for your advocacy. Question from Senator Kissel.
I just want to thank you for being patient and waiting to testify, and I very much, very sympathetic to your situation. We are grappling with this, but we hear you as well. And you made it, I was going to ask you about the response you had to the letter, but you wrapped up with that sentiment, so I appreciate that. Thank you, Mr. Chair.
Thank you, Senator.
Thank you, Senator.
Next up will be Michael Leibowitz.
Good afternoon. Thank you for allowing me to be here. My name is Michael Leibowitz. I spent 25 years in prison. I was released 4 months ago. I believe strongly in rehabilitation and think that inmates should be rewarded for doing so. However, there's two things about these commutations that greatly disturb me. One is they're completely arbitrary. Nobody in prison has any idea what the criteria are to get one. Secondly, I heard Mr. Pohl talk about all the rehabilitative opportunities in prison, from the vet dog program, hospice, and programming. These are nonsense. None of these programs have any evidence to show that they work. There's simply no way for the commutation board to know whether somebody is rehabilitated or not. The rules in prison are not enforced by the guard, so going 10, 15, 20 years without a DR says nothing about the person. Until you can fix the correctional system, I think the commutations should be put on hold.
Senator Kissel.
All right, so you're an example of something that's counterintuitive. As someone who has been incarcerated for a long period of time, I thought you'd come up here and testify in favor, but you say put it on hold, which I think putting it on hold for a little bit of time would be a healthy thing too. You say that there's really, like, they based a lot of their decision on expanding the record from the pre-screening to the hearing. And you're saying that that record really is not that reflective of an individual's rehabilitation?
It reflects nothing. And the problem is, I think that inmates who have actually reformed themselves should be given relief. But what ends up happening, because there's no way to assess who's been rehabilitated or not, the people that actually are rehabilitated don't get relief, whereas some, and I'm not saying by any means all, but some who are not do get relief. They simply don't know in corrections. I'll just give you an example. There was a survey done of 170 correctional practitioners. The fundamental concept in correctional rehabilitation is criminogenic needs. Not one in 170 correctional practitioners can identify 3 criminogenic needs. I've tried that myself and asked people that worked in the DOC when I was in there if they could name 3 criminogenic needs. They could not. And if I were a wagering man, I would bet that not one of the board members sitting behind me could do so either.
Like, did you just read this stuff while you were in prison, or how'd you become so aware of criminogenic needs? I've been on here, this committee, for a lot of times, and I can't rattle off.
My 25 years in prison was not put to waste. I co-authored a book called Down the Rabbit Hole: How the Culture of Corrections Encourages Crime, where we documented many of the problems within the correctional system. I've been a regular guest on a local talk show here, the Todd Feinberg Show, discussing these issues for years. I've offered to debate anybody within the correctional system, whether they be correctional officers, lieutenants, all the way up to the commissioner. I've told them, if you think I'm lying, check the tape, because of most of what we said is on video. They don't do it. The correctional system is an absolute disaster. And there's simply no way that an unelected board of pardons and parole can possibly know who's rehabilitated and who isn't.
Thank you for your testimony. Thank you, Mr. Chair.
Thank you.
Senator Kissel. I mean, sorry, Senator Kissel, thank you. Senator Winfield.
It's cool. Just a question. Did you send that book out to at some point?
I've sent that book out to every major media outlet in the state, to all the major newspapers, and to many, many people that are a part of the General Assembly.
Okay. Yeah. Okay. Thank you. I know it has nothing to do with this, but the name of the book was familiar, and I think I've read
I'm
it.
pretty sure the book was delivered to you, sir.
And I got it. Thank you.
All right, thank you, sir. Thanks, Representative Porter.
Thank you, Mr. Chair, and thank you for your testimony. You had me at attention. My question to you is, you're saying that there's no way to gauge rehabilitation and what they do in commuting sentences, but you sit here as someone who has benefited from commutation.
No, I did not. That's false. I did not
Okay.
benefit from a commutation. I didn't say that, so I don't know why that would be assumed. I did not
Well,
benefit from
I'm
commutation.
making the assumption because you are released, correct?
Yeah, I
After
served
25 years of
Yes.
serving a sentence.
Yes, but a commutation had nothing to do with me getting out of prison.
Okay, I thought you said that you had received a commutation.
No, I did not say that.
You did not.
No.
Okay, then that ends my questioning for you. That was my
Uh-huh.
miscommunication on my
Okay.
part. I thought you had received commutation.
No, I did not.
You have not.
No.
Thank you for that.
Thank you.
Thank you, Mr. Chair.
Thank you. Jan and Harold Kritzman.
You're just going to get Jan Kritzman today. Good day, Chairman and members of the Judiciary Committee. I am Jan Kritzman, Newington resident for 45 years. On May 22nd, 2002, which was the worst day of my life, Elizabeth Ann Carlson was brutally murdered in cold blood by her stalking ex-boyfriend. It was a premeditated ambush in her parents' home in Newington. Elizabeth's parents, Audrey and Bruce Carlson, and her sister Leslie have been left to grieve her senseless death for the past 21 years. Connecticut prisoner 300990, I can't say his name, was given a sentence of 42 years with no parole, but the Carlsons live a sentence of a lifetime without their daughter, Elizabeth. Things like this happen to somebody else. No, the Carlsons are the somebody else. The Carlsons are our closest family friends, mi casa su casa. Unfortunately, they're unable to attend in person today's nomination hearing. Elizabeth's murderer, Connecticut prisoner, you know the number, who has never shown remorse, was given a plea deal at the time of 42 years, no parole. After much negotiation with the prosecutor, lawyers, and the judge, the Carlsons were assured that the murderer would serve the entire sentence, not a day less and not a day more. An ironclad contract. A deal is a deal. Until they were shockingly notified of Board of Parole and Pardons Policy 11102, which is not a state of Connecticut law voted on by the legislature and not subject to legislative oversight, I guess until today. It is no surprise the Connecticut prisoner, you know the number, took advantage of the opportunity to apply for sentencing commutation. The Carlsons and their family and friends went into a tailspin of anxiety, awaiting this pre-trial hearing. Friends and family sent more than 1,000 emails to the board pleading that Connecticut prisoner, you know the number, be denied sentencing commutation. Thanks be to God, at the pre-trial hearing in late January this year, his request was denied. 3 very astute parole board members who denied him are here today, and I thank them. They know who they are. But according to the policy 111.02, he can request another hearing again in 5 years if he can. I will use the word fabricate because this is what he would do, fabricate. Quote, new compelling information not included and considered by the board with this application. Today, we're respectfully requesting as follows. No reappointments to the board be made until policy 11.02 is thoroughly reviewed and voted on by the Judiciary Committee. 2, Murderers with plea agreements, ironclad plea agreements cannot apply, especially those who, like this prisoner, you know the number, were educated adults. He was a graduate of Trinity College and a veterinarian, a graduate of Kansas State University Veterinary School. He was 30 years old at the time. I'm almost done. When they committed premeditated murder, all sentencing commutations must be signed by the governor. Thank you for your attention to this critical matter. I'm Jan Kritzman from Newington.
Thank you. Ms. Kritzman, just a brief question for you, because I have been giving some latitude to folks, but we're not here on a review of a commutation policy. That's not the matter before us. And frankly, it wouldn't be appropriate for the legislature to sort of vote on that today. What we're voting on is the nominees before us. And I heard you give thanks to 3 nominees who are before us today for denying this application that was submitted. So are you asking us to vote in favor of their nominations today?
I will say that those 3 denied his application for a sentencing commutation, and I thank them very, very much for being astute in doing that. They probably saw through his and denied his sentencing commutation. I do not know any of the other board members. I don't know them.
Understood.
But-
But on the 3,
but-
are you asking us to vote in favor of those 3? Because we're scheduled to vote on that today. And per our rules, we have to vote on that within the next.
I don't feel that I can tell you, the Judiciary Committee members, what to do. It is not my position to vote. You have a position to vote. And I think you've heard all of them speak and address you, saying what they say about themselves and their resumes and so forth, which is very important for you to make your decision. My objection to the reason I'm being here today really is my objection to policy 111.02, which has to be revised, and I believe it should be revised before they are reappointed.
I hear you on that, but like I said, on our agenda today, it's a yes or no on whether these folks should be renominated.
Well, you're going to do yes or no, aren't you?
Okay. All right. Thank
And
you.
I'm
ma'am.
not, you are.
Appreciate it. Senator Kissel. Ma'am, Senator Kissel has a question.
Yeah,
Oh,
I just
I'm
want to
sorry,
thank
I
you
thought-
for taking the time and testifying. I know the Carlsons couldn't be here, but I know their hearts are broken over this. And for what it's worth, the 3 people that denied his application are the only 3 people to vote on commutations. And our chairman is correct. We just have a green or a red or a yes or a no on whether to reappoint them, and for the 2 new appointees, whether to appoint them. But I understand the concern with the policy, and I've attempted to express my concerns regarding that as well. So we're hearing you loud and clear. So thank you. Thank you, Mr. Chairman.
Thank you for hearing me loud and clear.
Thank you, ma'am. James Cantu. James Cantu. All right. Mr. Cantu, James Cantu. All right, one more time, James Cantu. If not, that's the end of our list. Although I believe Heather Summers is now with us, even though she missed her call, so we'll let her testify.
Good afternoon to the chairs and ranking and distinguished members of the Judiciary Committee. My name is Senator Summers, and I am here to make a statement. First of all, I can't express to you,
Our senator, as a member of the legislature, it's for or against nominees, and it's on the nominees today. So
Yes.
are you testifying?
yes, I'm testifying against the nominees.
Against
today.
against
Yes,
which nominees?
every single one of them.
Okay, the
Okay.
entire board of pardons and paroles, including the new
Yes.
nominees. All right, go ahead.
Okay, so I cannot express to you any more clearly of how horrified I am of what's happening in the state of Connecticut concerning the Board of Pardon and Paroles and the policy that was crafted in the dark of COVID. I'm haunted by this and can't sleep after talking to the families. We are commuting sentences of seriously dangerous criminals that have taken the lives of others, murderers, rapists, and murderers. Many of those who are receiving commutations were sent to prison on plea deals, meaning they pled to a lesser charge than what they actually committed. This was an ironclad agreement, a contract, one that takes months and many people, even years, with countless hours of judges, prosecutors, and defense attorneys and families, as well as the accused, to agree on. The defendant gets lesser time served, and the family knows an immutable sentence was imposed, or at least so they thought. Now these same individuals are eligible for commutation, going against everything that families were led to believe. And to add injury to insult, sometimes these families are given 5 days for notification of a pre-screening hearing concerning commutation. I want you all to close your eyes and imagine having a grandson brutally raped and beaten to death. Having that person plead down to a lesser charge, so the rape and the molestation is dropped. And having that person be able to sign up for a pre-screening for commutation. And that grandson was 3 years old and his name was Andy. Can you imagine having to unpack that, your child's life, the murder of your grandson, in 5 days to be able to get your thoughts together to come and testify or submit written testimony in front of the Board of Pardon and Paroles? It's unfathomable. It's unconscionable. And now inmates can come back every 3 years. So your family has to undergo this trauma every 3 years if they decide to sign up. Every 3 years, the victims are re-victimized again and again. And that's in our statute, right? Because our statute allows the Board of Pardon and Paroles, a group of lay people that are well paid, to override sentencing judges and rulings and plea deals. It's outrageous that this board has the power to take this upon themselves without any notification to this committee, to the governor's office, or anyone to change the trajectory of our judicial system. It's inexcusable to victims, to their families, to allow this to continue, invoking complex PTSD, hopelessness, and actually horror. I'm asking this committee to please do not reappoint anyone to the Board of Pardon and Paroles until there is a meeting with the governor and your committee, which he has agreed to have. Let the committee and stakeholders weigh in on what the policy should be before you reappoint anyone again. Doing this is anything less than this really is a miscarriage of the judicial system.
Questions from the committee.
Thank you for your time.
Representative Howard.
Thank you, Mr. Chairman. Thank you, Senator, for being with us. We've heard today that that those who had their sentences commuted have not reoffended. I've been following the work that you're doing. Do you find that statement to be accurate or inaccurate?
I would find that statement to be false, and I will give you an example. Michael Cox, he was sentenced to 75 years in prison for murder, felony murder, manslaughter, second-degree assault with a firearm. His sentence was commuted by 30 years in November of 2021. He then was eligible for compassionate parole in December of 21. The people who were arguing his case said that there was no way that he could be a risk to society because of his medical conditions. In July of 2022, he was charged with strangulation, suffocation in the second degree, and disorderly contact. So that is a false statement.
Thank you. Do you happen to know where that subsequent charge was?
I have the information. I can send it to you.
Okay, yep, just so I can look that up. Thank you.
Further questions or comments, Senator Kissel?
Thank you, Senator Summers, for coming here. I know you were downstairs in public health. Have you had folks reach out to you upon learning of this policy, constituents?
Well, I first learned of this policy when I was contacted by the Carlsons that I know that you heard a lot about today. And I'm glad that everyone feels comfortable in the fact that the perpetrator in that case was not released. But the fact is the Carlsons, Mr. Carlson can't even say the person's name. He says it by his inmate number, and they are traumatized. Elizabeth's sister
had to see her dead sister's body in the house. And they had to go in 5 days and go in front of this committee and relive that again. I hope you have a chance to read the testimony from the woman who's treating them, Dr. Weiss. She has a lot to say about the trauma that these families have to endure. And again, it seems to be that the Board of Pardon and Paroles wants to get everyone to 30 years. I think what we're not recognizing is that when you lose a loved one or when you lose a child or a grandson, you have a lifetime sentence as a victim. And yes, I have been contacted by so many either victims. I've been contacted by people that have gotten commutations and said what's happening now is outrageous. They have submitted testimony that hopefully you will be able to read today. I can't tell you how many people that have reached out. Our own representative, Steve Weir, I didn't know that his wife's mother had been murdered and that she actually had to go through this process also herself. Especially when it's a plea deal. I'm sorry, like
Well,
that is a contract. And now we are violating that.
Well, that was going to be my question.
Sorry.
My last question, Mr. Chair, was we have two scenarios. One is a trial and a sentencing after a trial where the accused is adjudged guilty of a particular crime. But most, I'd say over 95% of our criminal matters are plea agreements. And is it your belief, and have you spoken to constituents to support that belief, that victims or family members of victims believe that there's a contractual nature when dealing with a plea agreement, especially in light of what transpires in a courtroom, having done special public defender work and other criminal defense work over the years? It certainly sounds like that's the written in stone determination when a sentence is meted out through a plea agreement.
100%. People believe that's an ironclad agreement, not a day more, not a day less. I can tell you, I personally sat through a horrific murder trial in my district last year, the Lindquist trial. Eric Lindquist, the only surviving family member, works for OPM here in the state of Connecticut. What happened to his family is unfathomable. And one of the girls who was involved had a plea agreement so she could testify against the other perpetrator and was guaranteed 40 years in prison under a plea deal, under a contract, not a day more, not a day less. She is eligible for a commutation in 10 years. Someone who killed 3 people and set their house on fire under extreme circumstances.
Thank you, Senator Summers. Thank you, Mr. Chair.
Further questions or comments from the committee? Further questions or comments? If not, thanks for being here.
Thank you.
James Kutu. James Kutu. If not, Steve Weir.
Thank you, Senator Winfield, Representative Staffstrom, ranking members and members of this committee. Steve Weir, State Representative here in the building. You heard earlier from my wife, Allegra, and I would say that our journey on this began as we were teenagers when her mother was murdered. We certainly weren't given the opportunity to ease into this, into adulthood. We were kind of thrust into it. As you probably heard her say that she had lost her father recently before that. And I'll talk about, the murderer. This man took a plea. He made an agreement with the state back then. And it was our expectation that both sides would honor that agreement, including the Board of Pardons. And we're aware that, at some point, everybody's due their opportunity to be heard and to be rehabilitated, perhaps. So I'm grateful for her grit. This is my wife, her perseverance. At no point will I acknowledge us as being victims. I'll say that over the course of the years, we persevered and worked together through it. But I understand that not everybody sees themselves that way. Some people are thrown into adversity. Or worse, they're scarred or harmed for life. I don't consider us to be in those circumstances, but in the current process, the way it works, it seems like some of these people are victimized over and over again. Last fall, being newly elected, I read an article in the Hartford Courant by Kevin Rennie talking about how this process works and that is not an example of transparency in quote, sparse minutes of meetings and operating with little transparency. So I guess I'll describe this panel as having worked in the dark as far as I'm concerned. And I think that the dark really means a lack of transparency and accountability.
Representative, and just because I've admonished others on this, which nominee are you testifying on? Are you testifying?
I'm just making a general statement.
Yeah, unfortunately, we don't allow that in this committee. Particularly under our FOIA rules and the like, you have to support or oppose a nominee before. So we're not talking about the process, John.
I'll conclude my testimony. I thank you for
Appreciate you
allowing
being
me
with
that.
us. Thank you. Thank you for being here. All right, that concludes our public hearing today. I will call the public hearing closed. I will convene our committee meeting for March 20th. The members will break for what I hope is a brief caucus. The Republicans will meet in room 2600 and the Democrats will be in 2B. Members who may be joining us remotely, please look for a login from your respective caucus. We stand in recess, subject to being recalled. All right, I'd like to reconvene the Judiciary Committee meeting, please. If the committee could come back to order, please. All right. Any remarks from my co-chair?
Oh, let's go.
All right, nominations for review to be Claims Commissioner. I will entertain a motion to JF the governor's nomination of Robert F. Shea Jr. of West Hartford to be the Claims Commissioner. I have a motion from Senator Winfield and a second from Senator Kissel. Is there discussion on this nominee? Is there discussion? Senator Kissel.
Mr. Chair, I propose that we establish a consent calendar and that this be the first item thereon.
Is there objection to placing this item on consent? Is there objection? Seeing none, this item will be placed on a consent calendar. Next, we'll move to the governor's nomination of Carlton C. Giles of Milford to be a member of the Board of Pardons and Paroles. I have a motion from Senator Winfield, a second from Representative Doucette. Is there discussion on this nomination? Representative, I was looking at Senator Kissel. Let's go Representative Howard first and then Senator Kissel. Yeah, let's go with Senator Kissel first, please.
Thank you. Got to watch those house guys all the time. I'm going to be voting no on Chairman Giles. I've known him for pretty much at least the whole 10 years that he served on the Board of Pardons and Paroles. I have the utmost respect for him as an individual. And I know that we're voting on individuals and not the policy, but I think this policy on commutations is such a huge, as I indicated in my questioning, sea change, and affects the whole criminal justice program and policy in the state of Connecticut, that it's very disconcerting to me that he almost unilaterally came up with this policy and implemented it without reaching out to, from what I could tell, the executive branch or higher up in the executive branch, or certainly not to the legislative branch, or at least certainly not to me. And all roads don't have to go through me, but it would be very important to get input, and would be very important for us to be and to get the information out to our constituents as well. And I think that has the potential to undermine confidence in our entire judicial system as it pertains to criminal justice. And we are a state and a nation that depends on the full faith and confidence of our constituents. If they don't believe in the institutions that undergird this republic that we are all so blessed to live in, then so many other things become immediately at risk. And so I'm looking forward. I believe the co-chairs will acknowledge we had outreach from the governor's office. They want to bring all the stakeholders around a table to further discuss the commutation policy. I look forward to that, but at this time, I'm going to have to vote no on Chairman Giles. If for no other reason to flag this issue, in all other respects, I highly respect what he's done with the Board of Pardons and Paroles, but this one's too big to let go without acknowledging that we have a problem. And for that, Mr. Chair, that's why I'll be voting no. Thank you.
Representative Howard.
Thank you, Mr. Chairman. First, if I may, I just want to clarify what was seemingly conflicted testimony that we heard today. I took the opportunity after the senator testified to speak with a good chair and clarified some things relevant to the testimony that she gave. In fact, the case that she spoke about was the individual who was commuted and then subsequently released under compassionate release. And that was before the current round of commutations that became the subject of much discussion today. So when the chairman was asked about that, that led to the confusion. But I just wanted to clear the record so that we all understand that nobody was being dishonest today and that a lot of testimony came. So that's because I do think, as the good Senate chair references all the time, that it is important that when we have these discussions that we have facts on the record. Secondly, I'd like to align myself with the good Senate ranking member. We have heard from constituents excessively. In fact, I had a constituent outreach event and an individual drove across the state to speak with me on this issue. And it's not about the three individuals that sit on that commutation board so much as the policy itself. I do believe in good faith that the chairman's representation and the governor's representation, that there will be an ongoing discussion to address the concerns of the people of the state of Connecticut is ongoing. But like the senator said, for today, I think it's important that there's at least a few no votes on today's vote so that we can make sure that we send the message appropriately, that those conversations are continuing for those victims' families, and that we can continue on with the great work that the Board of Pardons and Paroles was doing, and well-received work, as I should say, prior to this policy. So I hope that that clarifies my no vote. Thank you, Mr. Chairman.
Further questions or comments? Further questions or comments? I'll just say briefly, sort of to recap what was said during the public hearing and just to put it on the record after my colleague spoke. I will be supporting this nominee, and I hope my colleagues do as well. I will state that I have not always agreed with this nominee and some of the positions he has taken as chair, and there have been times where I wish the Board of Pardons and Paroles had gone further than they had, particularly with medical and compassionate release during the pandemic. And I think the chairman has done his right best to strike the balance, to act within the board's statutory authority. I think folks could rightly quibble about whether the compassionate release policy is entirely 100% the correct one or not, but I don't think folks can quibble that that is within the board's purview, that the statute allowed them to adopt that policy. The statute gives the board the ability to commute sentences, and the statute gives the chair the ability to set policies, which he testified today is exactly what he did within his power. So I think the chairman acted within his power. I think he has led the board with distinction over these last 9 years and is deserving of our support today. And for us to cast no votes based on a policy as opposed to the nominee before us, I think sets a bad precedent for this legislature. I think our vote on nominations that come from the governor is advice and consent on that nomination. The governor has seen fit to renominate these individuals before us, and I think we need to look at them as individuals as opposed to particular policies. With respect to the commutation policy, I think we did learn some stuff today. I think there is at least one change I would like to see of that policy, and that is that what we heard today is a number of the applications that come in are sort of summarily denied or rejected before they even get to a hearing. So it would make sense to me that notice go out to the victim only after a hearing date has been set. And that if what we're talking about is sort of not re-traumatizing a victim by an application being submitted over and over and over again, the solution is not to stop the application from coming in. It's to make sure there's that initial case assessment before the notice is sent out. That to me seems like a very easy fix, and I think would alleviate at least a number of the concerns we heard today. So I look forward to meeting with the chairman. I look forward to meeting with the governor's office and continue to work through this, but I don't think we need wholesale change to the policy. I think it's a couple of reasonable tweaks here and there. Madam Administrator, please call the roll.
Roll call vote on Carlton J. Giles of Milford to be a member of the Board of Pardons and Paroles. Winfield. Staffstrom.
Yes.
Flexer. Quinn.
Yes.
Kissel. Fishbein. Blumenthal. Callahan.
Callahan votes no.
Conley.
Conley votes yes.
Curry. Delaney.
Delaney votes yes.
Dillon. Doucette.
Yes.
Dubitsky.
Bitzky votes no.
Elliott. Gaston.
Gaston vote yes.
Gilchrist.
Gilchrist votes yes.
Godfrey.
Yes.
Hall.
No.
Harding.
No.
Hayes. Howard.
No.
Johnson.
Johnson votes yes.
Khan. Labriola.
No.
Lesser.
Lesser votes yes.
Marr.
Marr votes yes.
Miller. O'Day. Osborne.
Osborne votes yes.
Pavlock D'Amato.
Pavlock D'Amato votes no.
Porter. Sampson. Sims.
Sims votes yes.
Veach. Veach votes no. Walker. Wilson.
Wilson votes yes.
Madam Administrator, we're gonna hold the votes open until 6 o'clock. Next, we'll entertain the governor's nomination of Joy Chance of Bloomfield to be a member of the Superior Court. It's a motion for JF. Motion from Senator Winfield, second from Senator Kissel. Discussion, Senator Kissel.
Mr. Chair, I'd like to move this to the consent calendar.
Is there objection? Seeing no objection, this item will be placed on the consent calendar. Next, we will. Okay, let me, I guess maybe I've gotten too used to these and if I did, let me rephrase that. So let's go back. The previous motion was to approve Joy Chance of Bloomfield to be a member of the Board of Pardons and Paroles. So we will correct that, and I think and there's
And I'll second again.
Okay, there was a motion from Senator Winfield, there was a second from Senator Kissel,
Sorry.
and that nomination for the Board of Pardons and Paroles was then moved to the consent calendar by Senator Kissel. There was no objection, so the nomination of Joy Chance to be a member of the Board of Pardons and Paroles will go on the consent calendar. All right, let me see if I can get this next one right.
She was judge for a minute.
Yeah, and we certainly don't want to appoint this next one to the bench. So I will entertain a motion to JF and approve the governor's nomination of Stephen D. Dargan of West Haven to be a member of the Board of Pardons and Paroles.
So move. Second.
I have a motion from Senator Winfield, a second from Representative Godfrey. Is there discussion on this nomination? Senator Kissel?
Mr. Chair, I'd like to move this matter to the consent calendar.
Is there objection to placing this item on consent? Is there objection? Seeing none, so ordered. Next, I will entertain a motion to JF and approve the governor's nomination of Rufaro B. Page of Naugatuck to be a member of the Board of Pardons and Paroles.
Second.
I have a motion from Senator Winfield, a second from Senator Kissel. Is there discussion on this nomination? Senator Kissel?
Mr. Chair, I'd like to move this nominee to the consent calendar.
Is there objection? Seeing none, so ordered. Next, I will entertain a motion to favorably report on the governor's nomination of Michael E. Pohl of Manchester to be a member of the Board of Pardons and Paroles. I have a motion from I have a motion from Representative Doucette and a second from Senator Kissel. I'm sorry, it's from Senator Winfield. I apologize. Yeah, you know, I was trying to sneak one by other senator. Is there discussion on this nomination? Is there discussion on this nomination? If not, Madam Administrator, please hold the roll. Oh, well, there is discussion. Hold on.
No, I just, I made this single comment earlier for the three individuals. I hope everybody understands that was, what the no votes are for. Thank you, Mr. Chairman.
Thank you, Representative Howard. Further discussion on this nomination? If not, Madam Administrator, please call the roll.
Roll call vote on Michael E. Pohl of Manchester to be a member of the Board of Pardons and Paroles. Winfield.
Winfield, yes.
Staffstrom.
Yes.
Flexer. Quinn.
Yes.
Kissel.
Yes.
Fishbein. Blumenthal. Callahan.
Callahan, yes.
Conley.
Conley, yes.
Curry. Delaney.
Delaney, yes.
Dillon.
Dylan, yes.
Doucette.
Yes.
Dubitsky.
Trubisky's yes.
Elliott. Gaston.
Gaston, yes.
Crest.
Gilchrist, yes.
Godfrey.
Yes.
Paul.
Paul, no.
Harding.
No.
Hayes. Howard.
No.
Johnson.
Johnson votes yes.
Khan. Labriola.
No.
Lesser.
Lesser, yes.
R.
Mar votes yes.
Miller. O'Day. Osborne.
Osborne, yes.
Pavlock D'Amato.
Pavlock D'Amato votes yes.
Porter. Sampson. Sims.
Representative Sims votes yes.
Veach. Rep Veach votes no. Walker. Wilson.
Wilson votes yes.
Thank you. Next, I will entertain a motion to favorably report on the governor's nomination of Deborah Smith Palmieri of Guilford to be a member of the Board of Pardons and Paroles. I have a motion from Senator Winfield and a second from Vice Chairman Quinn. Is there discussion on this nomination? Is there discussion? Seeing none, Madam Administrator, please call the roll.
Roll call vote on Deborah Smith Palmieri of Guilford to be a member of the Board of Pardons and Paroles. Winfield.
Winfield, yes.
Staffstrom.
Yes.
Flexer. Quinn.
Yes.
Kissel. Fishbein. Blumenthal. Callahan.
Callahan, yes.
Conley.
Conley, yes.
Curry. Delaney.
Delaney, yes.
Dillon.
Dylan, yes.
Doucette.
Yes.
Dubitsky.
Bitzky's yes.
Elliott. Gaston.
Gaston, yes.
Gilchrist.
Gilchrist, yes.
Godfrey.
Yes.
Hall.
No.
Harding.
No.
Hayes. Howard.
No.
Johnson.
Johnson votes yes.
Khan. Labriola.
No.
Lesser.
Lesser, yes.
Marr.
Mars, yes.
Miller. O'Day.
I'm sorry, which vote is this for?
On Deborah Smith Palmieri to be a member of the Board of Pardons.
O'Day, yes.
nominate.
Osborne.
I should be opposed to.
Osborne.
Osborne, yes.
Pavlock D'Amato.
Pavlik Tomato votes no.
Porter. Sampson. Sims.
Sims votes yes.
Veach. Veach votes no. Walker. Wilson.
Wilson votes yes.
Thank you. Next, we'll entertain a motion to favorably report on the governor's nomination of Nancy A. Turner of Groton to be a member of the Board of Pardons and Paroles. Motion from Senator Winfield, second from Senator Kissel. Discussion on this, Senator Kissel?
Mr. Chairman, I'd like to move this nominee to the consent calendar.
Seeing no objection, so ordered. Next, we'll entertain a motion to favorably report on the governor's nomination of Jennifer M. Zaganini of Oakville to be a member of the Board of Pardons and Paroles.
Second.
Motion from Senator Winfield, second from Senator Kissel. Senator Kissel,
Mr. Chair, I'd like to move this nomination to the consent calendar.
is there objection? Seeing none, so ordered. Next, we will entertain the governor's nomination of Neville A. Brooks of East Hartford to be a member of the Board of Pardons and Paroles.
Second.
Motion from Senator Winfield, second from Senator Kissel. Senator Kissel,
I'd like to move this nominee to the consent calendar.
is there objection? Seeing none, so ordered. Next, we'll entertain a motion to favor report on the governor's nomination of Sergio Rodriguez of
So moved.
to be a member of the Board of Pardons and Paroles. I have a motion from Representative Dillon and a second from Representative Porter.
New Haven pylon.
New Haven is in the house. Senator Kissel,
I move this matter to the consent calendar.
is there objection? Seeing none. Wait, Senator Winfield, did you have a? Oh, no, okay. Seeing no objection, so ordered. All right, with that, Madam Administrator, if you could read back the consent calendar and call it, please.
The consent calendar consisting of the nominations of Robert F. Shea Jr. of West Hartford, Joy Chance of Bloomfield, I should say Robert F. Shea Jr. of West Hartford to be Claims Commissioner, Joy Chance of Bloomfield to be a member of the Board of Pardons and Paroles, Stephen D. Dargan of West Haven to be a member of the Board of Pardons and Paroles, Rufaro B. Page of Naugatuck to be a member of the Board of Pardons and Paroles, Nancy A. Turner of Groton to be a member of the Board of Pardons and Paroles, Jennifer M. Zaccanini of Oakville to be a member of the Board of Pardons and Paroles, Neville A. Brooks of East Hartford to be a member of the Board of Pardons and Paroles, and Sergio Rodriguez of New Haven to be a member of the Board of Pardons and Paroles. Winfield.
Winfield, yes.
Staffstrom.
Yes.
Flexer. Quinn.
Yes.
Kissel. Fishbein. Blumenthal. Callahan.
Callahan, yes.
Conley.
Conley, yes.
Curry, Delaney,
Delaney, yes.
Dillon,
Yes.
Doucette,
Yes.
Dubitsky,
Yes.
Elliott, Gaston,
Gaston, yes.
Gilchrist,
Gilchrist, yes.
Godfrey.
Yes.
Paul,
Yes.
Harding,
Yes.
Hayes, Howard,
Yes.
Johnson,
Yes. Johnson, yes.
Labriola, Lesser,
Lester, yes.
Mar, Miller,
Oh, I'm sorry, that was Mar, yes, I had my mute on.
thank you, Senator. O'Day, Osborne,
O'Day, yes, sorry.
Osborne,
Osborne, yes.
Travalock, D'Amato,
Carlock D'Amato votes yes.
Porter, Sampson, Sims,
Sims votes in the affirmative.
Beach,
Beach votes yes.
Walker, Wilson.
Wilson votes yes.
Thank you, everybody. That concludes our votes for today. As a reminder, votes will be open until 6 o'clock for members. We have a public hearing on Wednesday, which I believe is our last substantive public hearing on bills on Wednesday, which I know makes our LCO attorneys pleased. We will ask members also to hold every day next week. That will be our JF week, and so we would remind members to block off their calendar for basically until 5 p.m. on Friday. And with that, we stand in recess until 6 o'clock.
Madam Clerk, can I vote?
Yes, Representative.
Thank you. I think I just missed two. Board member Giles and Cole.
For Giles.
Giles, Representative O'Day votes no.
And for Paul.
Representative O'Day votes yes.
All right, you're all set. Thank you.
Hello, Madam Clerk. Just wanted to see if I missed a vote, if I can vote.
Yes. All right, let's see. 4. Oh, you're all set.
All set?
Thank
Thank
Senator.
you.
Hi, Senator.
I'm here. I'm trying to get rid of this music. Can you hear it?
I can, but it's okay.
Okay.
So, for Carlton Giles of Milford, to be a member of the Board of Pardons and Paroles, how do you vote?
Yes.
Okay. For Michael E. Pohl of Manchester to be a member of the Board of Pardons and Paroles.
Yes.
For Deborah Smith Palmieri of Guilford to be a member of the Board of Pardons and Paroles. How do you vote?
Yes.
Okay, and then we did a consent calendar for the rest of the agenda items. Did you want me to read the names or no?
No, I have them all. I'm looking at them.
All right, how would you like to vote?
Yes.
All right, you're all set. We have a hearing on Wednesday.
All right. Thank you.
Take care.
Hi, Kirsten.
Hi, how are you? So I just needed to get you for Giles.
Okay, thanks. Yes,
All right, you're all set. Thank you so much.
yeah, sorry, I got kicked off. I don't know what happened.
No, no worries at all.
Appreciate it.
You're good. Thank you so much. Hello. Hang on, you're muted. There you go. Okay, so really quickly, for Giles to be a member of Board of Pardons and Paroles,
No.
for Michael Pohl of Manchester to be a member of the Board of Pardons and Parole,
Yes.
for Deborah Smith Palmieri of Guilford to be a member of the Board of Pardons and Parole,
Yes.
and for the consent calendar.
Excuse me?
For the consent calendar?
Yeah. Okay. So everybody else is on consent?
That's correct. Yep.
Yeah. Then yes.
Okay, you're all set.
Thank you very much. Have a good night.
Thank you, you too.
Bye-bye.
Hello. Ready to vote.
Hello, how are you?
I'm good.
Okay, so we did a consent calendar, but we had 3 that did not go on there. So for Carlton Giles of Milford to be a member of Board of Pardons and Paroles, how do you vote?
Are those individual votes?
Yes, these are the individual ones that are not on consent.
Okay, I vote yes.
We've got Michael Pohl of Manchester to be a member. How do you vote?
Yes.
And then Deborah Smith Palmieri of Guilford to be a member.
Yes.
And then the remaining items were on consent.
Okay. So I
How do you
vote on the consent calendar.
Okay. Awesome. That's it. Thank you so much.
Thank you.
Take care.